Yes.
My lord, one submission.
Kodi.
Kindly. My lord, may I submit, my lord?
Yesterday, this is 2018 final hearing matter was listed,
Ah.
but it was not reached
My
to
lord,
your lordship.
yesterday-
Serial number was there. Without date, it has been adjourned.
Kodi.
My lord,
Tomorrow it may post it.
Not
Senior citizen is there.
Kodi.
mine is a little different.
Huh?
Mine is little different. I pray for posting the matter today at the end of the list.
What is that?
Transfer. I'll be relieved, if my lords. That is my request. I suffered the order before KT, and I had a stay throughout. I have filed, and my matter number also have. Kindly.
Government munche kodi.
Kottidini. Copy kottidini.
230.
Yes, ma'am. Copy kottidini. End of the list
We
today.
don't know if we'll give interim order, but we'll give it at 230.
Great.
Government, just check. Telephonic.
my lord, may I,
Yes.
my lord, one submission, my lord,
Yes.
kindly. My lord, yesterday, my lord, lordships, my lord, were, my lord, had, my lord, disposed of one departmental inquiry matter, my lord, 20166 of 21. My lord, I request, let there be time for complex of the, my lord, order. The time frame was not.
You're not audible. Please make your submission clear. Your request is?
Yes. My lord, yesterday, my lord, when the departmental inquiry order, my lord, one matter was posed, my lord, lordship.
Yes.
I'm audible, my lord? Kindly.
Yes.
My lord, I request, my lord, that some time frame may be, my lord, fixed, my lord, for compliance of the, my lord, order. So, some time frame, my lord. Time frame was not fixed.
Yes.
Grateful.
We'll make a note of it.
Please, I'm grateful.
Lots of permission, Malad. The serial number 34, Malad.
Just one. Page wise.
Adjournment. Page number 40, number 37 to 41, 50, 42 to 44, 45 to 51, 70, 52 to 56, 80, 57 to 61, 90, 20, 66 to 68.
Yes.
Sir.
Yes.
WP 201680, Malad. Serial number 6.
Huh?
Serial number
Number
38.
38, Malad.
38.
Sorry. 10 days.
Well, 10 days is accommodation set required.
Inform the other side. Inform the other side.
Please, Malad.
Relist the matter on date 7th of February.
Much obliged.
1-3. Inform the other side. There is no stay, no? Week after next.
Problem is, my lord, every time they give representation, the bank rejected. The queue is over, you see, increasing like anything. But they want to sit up on the one-time settlement and they are taking the matter like last time. Last bench also has said. Lordship is also passing same order in earlier.
Anyhow, there's no stay.
No.
What are-
Serial number 44, Malad. Loan fund is appearing, Malad. This 44, 44, Malad. In this matter, Malad, Lordship is directed us to get the survey, Malad, whether the land is, Malad, acquired or not. Here, my lord, this land
see.
was, my lord,
When it reaches with.
that's why your lordship directed us to get the survey, my lord. We requested the ADLR to make the survey. That report is not yet come. So that is the, my lordship, I have next week, my lord, on 30th, my lord, by that time we will get the,
Let us see, finally.
that's why both of us only may requested,
Relist the matter finally on 30th.
please.
Non-compliance of the subject is serial number 1. Ika Anandra Sajjana Shetty.
Weeks time granted for necessary compliance. Next.
Serial number 2. Manjunath Malaya Shetty.
Which matter? No, correct. Sixth time, how we can give time? Relist finally on 10 days आदमी को. It's made clear that office objections are required to be cleared by the next date. Yes.
Orders matter serial number 3. Shivakumar R. Tengli.
Learned counsel for the applicant submits in 3.1. Counsel appearing in MFA CROB 20074 of 2016 submits that amended cost title is filed. What about in 3? Appellant in serial number 3 to carry out amendment forthwith. Relist the matter week after next. Could it? Date could. Covered.
Serial number 4. Sharana Basappa K. Babashetty.
Yes. Yes. Appellant is the respondent is the father. Correct. Huh? Correct. How you can have a better right than the parent? No. No, that's a different matter. See, the issue, I mean, we don't know the facts, but what we are saying, the issue between the husband and wife may be most acrimonious, but the relationship between the child and the father is something different. Correct. Now the question of guardianship is only the third now. Father must have the overriding right, natural course of events. On what ground you want to disentitle the father? That is of no relevance. The wish of the child requires both father and mother. Whatever reason, mother is no more. Father has the first right, naturally, unless you show he is disqualified. Maybe, finally, if they are there together only you can express. If you're not there together, how you can express any love and affection? You just think about it.
No, ma'am. No. No, ma'am. No marriage. It is no.
Why will he fight for the guardianship of a child if he is not interested? Suppose he would be most happy in case he's married somebody, I don't want the child. Okay, on merits, will you get ready? That's all we'll hear. You get ready on merits,
Please, ma'am.
place your authorities,
Please,
support of your case.
please.
Under what circumstances the father can be disentitled for custody of the child. You must, both of you, examine it, come back, we'll fix it. Relist, file your synopsis.
Please, ma'am.
Synopsis to be filed by the next date. Relist the matter on. What is the age of the child?
SLC, ma'am. He- Last child.
Hmm.
15.
Noted. Week after next date could. Yes, next.
Number 5, Ajay Kumar, Ashok Kumar.
So who appears now? Yes. You appear, is it? For the appellants. The memo of retirement filed by counsel for R1 is accepted. As it is noticed, another counsel has put in appearance. Office to make the correct description of name of counsel for the respondent. That's a real one. Huh? Correct. There is no space. Then, yeah, relist the matter. Now it is to be come in final hearing. It's admitted. List in final hearing. Yes, next.
Till number 6, Ganesh Subhash Chandra Kalaburagi.
Second set must be filed in the first matter.
Yes, earlier it is in the first matter,
Ah.
I have filed it as a defendant number 3 is appeal, your worship. So it was
No.
earlier, it was filed before the honorable single judge.
Correct.
It has
now-
been transferred now, and I will,
Correct.
during the course of the day, I will comply that operations. One aspect yours, and better affidavit also filed in support of my delay condonation. That as I already have filed. The delay is there, that is required to be condoned.
Let us see, you file your second set.
I will see. One,
So that right devolves on both the appellant and respondent. Right?
because there is a will also in favor of my.
No, then you take your stand to the affidavit. Where the right devolves on both,
Yes,
then there is an issue.
yes.
Both of them, there will be
We
some
treat it as
conflict
the
of
part.
interest. So you take your stand in writing regarding that. Necessary stand to be taken insofar as the affidavit filed to treat appellant 1 to 3 as 1 to 3 and respondent 2, 4 and 5 as LRs of R1. You take your stand in writing.
Much.
If there are conflict of interest, no, whatever, we'll see.
And more so, your worship, the FDP proceeding is filed, these appellants, that is going on, your worship. That has to be stayed, your worship. They
Drawing
have
up
filed
of-
FDP even and they also
drawing
filed
up
appeal
of
before
final
this.
decree is stayed pending further consideration of the present appeal.
Much,
Yes,
much.
first let second set be filed, then we'll correct all are clubbed, isn't it? Relist the
see.
matter on date code. And we have to decide on the
Much.
LR also.
I will.
Yes, next
Copy.
BK Hireman.
week's time granted to take necessary steps insofar as deceased R1 is concerned. Next. Correct, 1,398 days delay has to be condoned. Who appears for the respondents? Notice is still to go or ever? That's servagide. Huh? Issue notice on IAS as well as main. TCR to be summoned forthwith. Next. No, not 1,398 days. Only after they come, we'll see. Yes.
But it,
Counsel for the appellant files a memo and submits that enclosing the receipt for having paid cost. Same is taken on record.
My lordship, I am for crop objector. ma'am.
The memo akile kottbidi.
I filed an IA for withdrawal of amount. They have challenged negligence.
Hmm.
It's a case of death, my lordship. 50% amount deposited before this court have maybe released, my lordship. IA is pending.
The correct apportionment of liability only. So he's asking 50% of that which is deposited.
Yes. MFA probable 200,019. This IA order on IA number 2 of 2023-22 for the reason accompanied to the application for the reason assigned in the memorandum of facts accompanied to the application, the IA 2 of 2022 is allowed and the respondent is permitted to withdraw the amount deposited by before the tribunal, before this court,
Before this court,
by the
ಮಾಡಿದ್ದಾರೆ.
interim order dated so and so by this court.
ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ರೆ ಅಲ್ಲೇ ತಗೋತಾರೆ ನಮ್ಗೆ ಅಮೌಂಟ್ ಇಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಅಲ್ಲಿ ಮಾಡ್ರೆ ಅಲ್ಲೇ ತಗೋಬರ್ತದೆ ನಮ್ಗೆ
Amount ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು.
ಅಲ್ಲಿ ಹೋದ್ರೆ ಅಲ್ಲೇ ತಗೊಂಡ್ರೆ ಮತ್ತೆ ಇಲ್ಲಿ ತಗೋಬೇಕಂತ ಅಷ್ಟೇ ಇಲ್ಲೇ ತಗೋದಿ ಬಿಡಿ
ಇಲ್ಲೇ ತಗೊಳ್ಳಿ. 8.1 ನಲ್ಲಿ ಶ್ರೀಮತಿ ಪ್ರೀತಿ ಮೇಲ್ಕೊಂಡಿ as notice to R2 issue notice to respond number 1. But then records ಬೇಕಾ? Yes, which is directed to secure the TCR.
number 9. AG,
Here for the petitioner, my lord. In this matter, my lord, this is my appeal, my lord. I don't know, my lord. Suddenly they start, my lord. That is, I don't know, my lord, why, what is the urgency? What is the thing is, the kindly see the, my lord, this order, my lord. But yesterday, my lord, I received the information, my lord. Regarding these respondents, my lord, appointed, subject to the outcome of the result of the writ petition. Now, my lord,
No, what we had indicated last time, that in this is the same matter, isn't it? The
same,
3 years,
3.5 years, my lord. Same, my lord.
So when you look at Hulappa, that case
Yes.
comes. No, just one. Now, what we had indicated last time, that the interim direction that was passed, directing you to remove those who are ineligible, we would observe
Yes.
that those people were not parties. So we will leave it at that, reserving liberty for you to take action in accordance with law, insofar as those people,
Please.
and modify the order of the KAT, which made the interim order absolute. And insofar as these people are concerned, since admittedly they have done, they are qualified, we would affirm the order of the tribunal, taking note of the earlier order, and leave it at that. Insofar as those people direction to take action, will discharge that order.
Yes. There now, my lord, what happened? There is a 44 posts still vacant, my lord. Yesterday I got the instruction, my lord. But if these persons come up above there, my lord, so we are already selected, my lord. who has completed 3 years course, my lord, automatically they have to come up, those person. For that is the reason, my lord, we are making the list, my lord. But even, my lord, if it is confirmed the appointment, my lord, he will be my last candidate. For that is a reason, my lord, we are preparing the list, placing the correct place. For that is the reason we requested the authorities to prepare the list and where he will
Correct.
place.
Now that order regarding seniority or where they must
Yes,
be
ma'am.
placed is a different cause of action. Now we are only on the, you have challenged that order.
No, not
Now,
different.
now
Please.
their appointment would be affirmed. Where you are going to place them is your headache.
That's why, my lord, in the final list, my lord, in the
Huh?
final list, my lord,
Hmm.
their name is not included.
Correct.
But then, my lord, what happened, my lord? They challenged that, my lord, they completed 3.5 years course. Who has completed 3 years course, my lord, they are selected. So for that is the reason they challenged it before the KT. But KT, my lord, there is a direction to us, include their name also. Then we filed the, my lord, writ petition before lordship, my lord. That's why, my lord, I requested them to make the list and all, give the instruction to me. Then I can make the submission before lordship, my lord. Lordship have done 30th, my lord, finally, but I will not take much
No
time.
further
on that.
adjournment. Otherwise, we're going to pass an order on.
Definitely, on 30th, my lord, that's why I'm not.
Relist the matter in the same stage on
Yes,
30th.
same.
Now, the-
Finally, last
Before
chance,
this
everything
roster-
has to be mentioned.
Before this roster completes, we will complete.
Huh?
We'll have it on, huh?
ಇಲ್ಲ 31st ಬೇಡ ನಾನಿರಂಗಿಲ್ಲ 29 ಬೇಡ ಅದ್ರ ಬೇಗ then you also pay it 10th ಮಾಡು you also pay it on ಮಲಡ್ 10th ಮಲಡ್ February
Monday, we'll have it on that Monday. We'll have it on that Monday.
ಅಲ್ಲ 31st ಬೇಡ
ಅಲ್ಲ,
sir, ನಾನು
Friday ಬೇಡ, half day ಇರುತ್ತೆ. We split for bench. Friday ಬೇಡ. We'll have it on that Monday. Immediately after that. Third.
first week ಬೇಡ
Third.
first week ಬೇಡ lots of that's why I'm requesting on 10th ಮಲಡ್
31st madam. 31st.
ಅಲ್ಲ 31st ನಾನು ಇರಲ್ಲ I will be not there 30th ಇದ್ರೆ ಪರವಾಗಿಲ್ಲ ಇಲ್ಲಾಂದ್ರೆ ಮಲಡ್ lots of pay it on 10th ಮಲಡ್ ಸರ್ ನಾನು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ದೀನಿ ಅವ್ರಿಗೆ ಲಿಸ್ಟ್ ಬರ್ಬೇಕು 10th ಮಲಡ್ nothing will be happen to him also let him ಮಲಡ್
10th finally.
Please.
No further adjournment.
No,
will be
yes, madam.
granted for
Right.
the respondent state.
Please.
10th of
Mhm.
Number 10, Hanuman M. HR Darigood.
About the complainant.
Yes.
This matter, my lord, not received any instruction from the my lord, department, my lord. May I request you also pay out on 30th, my lord. in this.
Deal is the matter on 30th
Please.
finally. Yes.
But make one submission. Along with other two matters, Maladi, similar matter.
Huh?
Other two matters, Maladi.
30th.
30th.
Other two matters, post along with other two matters, Maladi,
List
10013.
list along with give the numbers.
100,132.
Birth code nim colleague ಹೇಳಿ. Give the
Please.
numbers.
Please.
Number 11, Ramachandra K.
Concerned about the respondent in this case, Malad. The acquisition of the land is 1 acre 30 guntas is a particular survey number while taking the position of the property. So under the section 61A, 61, it's a paid amount also, nothing remains in this case. Now, first originally notification issued for the acquisition of land for 2 acres 30 guntas. Subsequently, we have been dropped 1 acres and 1 acre 30 guntas. In 6-1, we have acquisitions is over and paid the amount.
1 acre 30.
Yes, and they are not disputing also, I hope that. So it's nothing survival of the
What was the direction?
directions for the representation has to be considered by the deputy commissioner and issue endorsement on that, man.
Correct. Now they claim that they have left out 1 acre and confirmed 6-1 for 130. So there ends the matter that they've considered. 1 acre they left out. Yes. Yes. The present petition has been filed. Yes. Present petition has been filed. Seeking initiation of contempt of court proceedings for disobedience of the order passed by the learned single judge in WP so and so, directing the respondents to consider representation of the petitioner with an outer limit of 3 months. Affidavit of the concerned, affidavit or memo?
That is memo.
Memo, my lord.
Memo along with documents are filed by the respondents. It is submitted that consideration of the representation is complete in terms of annexure, in terms of
The directions.
16724.
Please, ma'am.
Huh?
My lord, page number 18, sir,
Affidavit, my
clarity
lord.
is there.
Affidavit of
Page
the-
number 8 of the memo, and apart from that, affidavit also, sir.
Hello, stop. Is filed. Affidavit of the assistant commissioner is also filed. Annexure R,
My lord, kindly see the page number 8 of the memo, my lord, so that is getting clarity. Memo, page number 8, my lord. Yes. My lord, the serial
is,
number 1 is there, survey number.
it is filed. It
second.
is submitted that out of the total extent of land of 2 acre 30 guntas belonging to the petitioner, the acquisition proceedings are finalized only insofar as 1 acre 30 guntas.
Paid.
And compensation has also been paid.
Paid.
Full stop. It's further submitted that 1 acre is, the remaining 1 acre belonging to the petitioner has been left out of the acquisition proceedings. Please stop. Taking note of such time, proceedings are dropped. Needless to state, if the complainant is aggrieved by any portion of the consideration by the respondent state, contentions are reserved to be raised in appropriate proceedings.
My lord, the concerned about this 2 survey number, 1 survey number, 2 acres, 1 acre 30 guntas is paid and acquired. And second, subsequently 4 guntas is there that acquired and are paid also. There is a 2 survey number. Page number 8 of the memo, my lord. Page number 8. Of the memo, my lord. Second para, the serial number 1, 41 Prakara, survey number.
As regards survey number 51/1, 51/1/1 and 51/2. ಆಮೇಲೆ one sentence ಇನ್ನೊಂದು. Insofar as 52/1, an extent of 10 guntas
Out of 10 guntas, we have
Five.
acquired 4.
under 4/1 notification, out of which an extent of 4 guntas has been acquired and compensation paid.
Paid, please.
First ಮೂರ್ ಸರ್ವೆ ನಂಬರ್ ಇದೆಯಲ್ಲ 51/1 ಮಾತ್ರ ಇರ್ಲಿ, ಬೇರೆ ಎರಡು ಇದೆಯಲ್ಲ 51/1/1, 51/2
Number 12, Basavaraj Armad.
Cross objector, since trial court records are received.
Paper book is dispensed with noticing that TCR is received. List for final hearing. Admit ಆಗಿದೆಯಾ?
How the admit agreement, if some date could be fixed, my lord, if some date could be fixed. I mean, the wife, my lord, staying away from the husband since past 6 years.
Any settlement you see?
My lord, we tried to, my lord, settle.
Yes, madam. There is some he has been granted by the. I have challenged the matter to the only some evidence that is relating.
Beautiful salary, handsome. Beautiful and better. Gender approach. The best way is to pay money by
That
by
was
post.
what proposed by the petitioner, for which the respondent is willing to join. Only differences is between the members of the family, the mother-in-law. What we have made a suggestion, if he is ready to provide separate residence, I am always ready to join her. He may our interested this is not a institution where they can straight away throw away the wife. There should be some reason. The trial court has given reasoning of two cases. Let there be a matter consideration on merits.
Let us list the matter in final hearing, first week admin date. Yes. Yes, next.
13,
4th.
14.
We put it on Valentine's Day. Yes, next. Yes.
Hope may not.
Manjunath Mallaya Shetty.
Week's time granted to do the needful. Respondent number R7. Learned Counsel Sanjay M. Joshi is directed to accept notice for R7. Connected in 13.1. Learned Counsel Shri Sanjay M. Joshi is directed to accept notice for R5. 13.2. Yaro, our respondent number R5. Sanjay M. Joshi for R5. And list along with so and so.
For claimant in this case, my lord.
All the case of death.
My lords.
What is the ground of appeal?
My lord, sir.
These are not covered, is it? Not covered.
My lords, the insurance policy issued by the insurer is the, my lords, package policy.
Okay.
And he was received, my lords, extra premium of ₹300 for 5 persons. This is a package policy. Yaudunu restrict madak baradilla package policy. 1 lakh kortini, 50,000 kortini. If my lords
List along with
my lords, my submission is that, my lords, I'm filed, my lords, memo for withdrawal of amount. In connected matter, my lords, 50% withdrawal permit ಮಾಡಿದ್ದಾರೆ ತಾವೇ. Kindly, my lord. ಇದರಲ್ಲಿ 25% ತುಂಬಿದ್ದಾರೆ. In connected matter ಅಲ್ಲಿ 50% ತುಂಬಿಟ್ಟು ಅದನ್ನು withdrawal permit ಮಾಡಿದ್ದಾರೆ.
We'll dispose it.
ಅಲ್ಲಲ್ಲ.
We'll dispose it. We'll fix a date. If it is
ಅಂದ್ರೆ ಏನಾಗಿದೆ?
one ನಿಮಿಷ. Now, if you are contention that extra premium is paid, etc., we'll dispose it. What is there in it? Avatagdidre you press for it.
Kindly one date next week.
Relist next week date. Yeah. R6. Who's the unserved respondent? Huh? So list on next week along with MFA number so and so.
One date ಕೊಡ್ರಿ please. 31st.
Let us.
Number 40, DP Ambedkar.
Here for the respondent, he comply the direction of the learned single judge. Kindly see the direction of the learned single judge.
Complied, huh?
Yes, my lord. We issued the endorsement, my lord. Kindly see the, my lord, order of the learned single judge, my lord, para number 4, my lord.
Wait, just wait.
Para number 4, my lord.
Ah.
Having taken note of the grievance urged by the petitioners herein, respondent 1 to 7 are directed to consider the representations produced at Annexure D, so and so, within 8 weeks from the date of receipt of the copy. Now kindly see the endorsement, my lord, which we issued, my lord. That is along with memo I produced it on 20th 1, 2025.
Now you have considered the.
Yes, my lord. This endorsement is issued last, my lord, para, ma, or that is, my lord, para number 3, my lord, ಮುಂದುವರೆದು, may read, my lord, that. ಅದರಂತೆ ಪರಿಶೀಲಿಸಲಾಗಿ ಈ ಕಚೇರಿಯಿಂದ ಜಮೀನುಗಳಿಗೆ ತಾಂತ್ರಿಕ ಅನುಮೋದನೆ ಮಾತ್ರ ನೀಡಲಾಗುತ್ತದೆ ಹಾಗೂ ಈ ಕಚೇರಿ ವಿನ್ಯಾಸದ ಮಾಲೀಕರೊಡನೆ ಸೇರಿಕೊಂಡು ಕಲ್ಲು ನೆಟ್ಟಿರುವುದಿಲ್ಲ ಹಾಗೂ ಕಲ್ಲು ನೆಡಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಮುಂದುವರೆದು ವಿನ್ಯಾಸ ಅನುಮೋದನೆ ಸಮಯದಲ್ಲಿ ಸದರಿ ಜಮೀನು ಗ್ರಾಮ ಪಂಚಾಯತಿ ಹುಣಸಿಗೆ ವ್ಯಾಪ್ತಿಯಲ್ಲಿದ್ದು ಸದರಿ ಗ್ರಾಮ ಪಂಚಾಯತಿಯು ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ರಾಜಪತ್ರ ಅಧಿಸೂಚನೆ ಸಂಬಂಧಿಸೋ ಹುಣಸಿಗೆ ಪಟ್ಟಣ ಪಂಚಾಯತಿ ಎಂದು ಪದನಾಮಕರಿಸಿ ಉದ್ಘೋಷಿಸಲಾಗಿದೆ. ಹಾಗೂ ಅನುಮೋದನೆ ಸಮಯದಲ್ಲಿ ಸದರಿ ರಸ್ತೆಯು ಜಿಲ್ಲಾ ಮುಖ್ಯ ರಸ್ತೆಯಾಗಿದ್ದು ಸ್ವತಃ ಅರ್ಜಿದಾರರು ಲಗತ್ತಿಸಿರುವ ಸುತ್ತೋಲೆಯಲ್ಲಿ ರಸ್ತೆಯ ಮಧ್ಯಭಾಗದಿಂದ ಎಷ್ಟು ಅಂತರದಲ್ಲಿ ಪರಿಗಣಿಸಿ ರಸ್ತೆ ಗಡಿ ರೇಖೆ ಮತ್ತು ಕಟ್ಟಡ ರೇಖೆ ಅಳವಡಿಸಬೇಕೆಂದು ಇರುತ್ತದೆಯೋ.
Just 1 minute.
Sir, sir.
Now, the order of the single judge only says consider.
Yes, we consider.
I know, they are in accordance with approved level.
You should have, correct, but you should have insisted before the single judge that certain observations be made in terms of which consideration may be made. Nothing, what is there in the direction? Nothing is there. What is there in, I'll correct, so what we are saying, that if at all there has to be contempt against an order in Mandamus, if some observation is made and then a direction is issued, in light of such observations, you must consider, then they're bound to consider, otherwise it keeps it open.
I followed my. But what learned single after passing of direction, there are some.
No, correct. We can't enter into that here. That has to be done separately, simply because the single judge's order is very crisp. It only says consider, no observation how it must be considered. The single judge. Yes, that will see. The learned single judge in WP number so and so had disposed of the petition filed seeking issuance of writ of Mandamus by directing the respondents to consider the representations at annexure D, D1, E, E1, E2, F, F1, G, G1, H and H1 within 8 weeks. Third, government advocate has filed a memo dated 21/1/2025 and enclosed an endorsement dated 13/1/2025. The counsel for the complaint submits that the endorsement issued is contrary to records of the respondent themselves. However, taking note of the limited scope of the present proceedings are draft. The complaint is reserved his liberty if aggrieved by the endorsement dated 13/1/2025 to take appropriate action in accordance with law. All contentions are kept open. Next time Mandamus issue ಮಾಡುವಾಗ ನೀವು ಸ್ವಲ್ಪ insist ಮಾಡಬೇಕು so that there will be meaningful consideration. That is what's the whole purpose of the exercise. Yes. Yes.
50, Channabasappa.
In this matter, my lord, appear for the respondents, my lord. Kindly see the, my lord, direction of the learned single judge, my lord, para number 3, page number 9, my lord. Para 3, my lord. It is a grievance of the petitioner that the land belongs to the petitioners has been utilized by the respondent authorities for construction of the bridge cum barrage without initiating acquisition proceedings. In this regard, petitioner are permitted to make representation to the competent authority seeking redress of their grievance, and if such representation is made within 2 weeks from the date of the receipt of the copy of the order, then respondent is
So what have you
yes,
considered?
now, my lord, we accepted that one, my lord, we utilized that one, my lord. Now issued the notification.
Issued.
Yes, madam.
Kodi.
11/1, my lord, notification is issued, my lord, on 1/1/2000. Sorry, my lord, this is issued on 6/1/2025. Notifying the land of the, my lord, complainant.
This is the preliminary
Yes, ma'am. This is 11/1 notification.
under the new act.
Yes, ma'am. Under the new act, ma'am.
So this is a preliminary notice.
Yes, yes. We'll proceed with the, my lord, in accordance with law, my lord.
Serial number,
Pardon, my lord.
which all the
This is,
annexure to that order
yes, my lord.
Relates to
That is
all
only
of
one.
the three petitions.
Yes, including others land also, my lord, we included.
Yes. Yes.
Amount has to be deposited. It has not put the deposit of the part amount.
No, correct. Now we'll take note of it for the present.
Please.
But you must file an affidavit. What is the procedure? What are the steps for completion of this? And roughly how much time will be taken?
Please.
Let us, the AGA submits that the direction of the single judge has been considered and notification under section 11(1) of the so-and-so act has been issued dated 6/1/2025. Copy of the said notification is produced along with the memo. Full stop. However, it would be appropriate that the accused file an affidavit detailing the procedure now to be followed for completion of the acquisition process and the time that would be taken for completion, approximate time that would be taken for completion. For filing of necessary affidavit, list the matter on
30th.
30th.
Date padega.
Yes.
Please.
Yes. Yes. Which paragraph?
Page 14.
Correct. So that is para 1. Which paragraph of the order you want to refer? Yes. 233. You're reading in which petition? Only one
Lord,
petition.
he is referring to, Lord, contempt proceedings 200234. Contempt petition, I'm sorry. Petition.
Yes. Yes. So what, correct. Now what is your submission? What about the writ appeal? That the principal bench is hearing. It appears checked. The principal bench is seized of some matter in which it is hearing on this very aspect. The Harvard bench also apparently has is awaiting orders from the principal bench to avoid conflicting orders. I'll have it on 30th. And on that day, we'll see what is to be done. Find out what is the stage, whether any matter is pending in the other benches also.
Obliged. And Lord, in between. Honorable Supreme Court, please.
Has been passed by what I see by this honorable court has been confirmed by the bench of bench. The humble submission is this honorable court was pleased to pass the order holding that by following full bench judgment that has been upheld. The court, whether it is principal bench or upper bench or bench, can go contrary to that bench. And this honorable court has already taken this view. This Supreme Court has
Thirtieth, let us
Please.
That other batch we are putting on 30th, on the same point. We'll consolidate all matters relating to that issue and we'll hear. We'll have it on 30th.
Ablash.
30th, no, they are going.
And my lord, moreover, just I draw my lordship attention that whatever the my lord, the operative portion, my lord, read out by other side, that matter itself is being, my lord, stayed in the, my lord, SLP, lord, 200147. Last occasion, I drawn my lordship attention to, lord, this matter.
Stayed.
Yes, my lord, contempt. 200147, my lord. That is a SLP. And my lord, coming to my lord, last, that is second page, last line, my lord, last sentence. In the meanwhile, High Court shall not proceed with the contempt petition in so and so matters. So it's, these are all, 1 second, these are all interconnected, my lord. And regarding, my lord, regularization only. And other side is also basing on, my lord, that is a, my lord, writ appeal, 200147. That's why my lord, humble submission and my lord, with due respect, maybe my lord. And inter-appeal also I have, my lord, 2-3 judgments, my lord. Whenever matter comes up.
It's correct, it's against the
Like,
common
these
order.
are all interconnected.
It's against the common order.
Common, my lord, please. And even other side also, my lord, depending on.
No, correct. Stay. Correct, but that's a common order.
Common order.
It's a common order which has been correct. But that order in the writ appeal is a common order.
Common order.
Though we are with you on the point that in only 2 matters, there is a specific order for restraining progress of contempt proceedings. We are with you on that. But that order itself is a common order.
Please.
So we will wait a little. This no, now this till the SLP is decided, we may have to wait.
Please.
List on 30th. 30th.
Ablash, no issue. Ablash, much.
Yes.
Much of.
Here for the respondent, we complied the order, my lord. We paid that amount, my lord, to the order. His request is, my lord, for payment of the, my lord, 2 months' salary.
Government in that batch of matters of intra-court appeal, state may also have to take its stand because you also will be an employer in some of the matters in the labor code, government companies.
In which?
Where against appeals against in labor matters.
Yes.
You also are an employer in some of the ID disputes.
Please, yes.
So you must ask your AG to look into it. When it comes for hearing, we want you also to voice because it's not a simple matter of just 2 litigants, isn't it? You just keep that in mind.
I'll do it.
Yes.
But in this matter, my lord, page number 20, my lord, of the content petitions, my lord, kindly. He is requesting, my lord, payment of the 2 months salary, my lord. That is, madam.
Put it.
Page number 20, my lord.
Page number
20, my lord. His representation, my lord, this is. ನನಗೆ ಕೇವಲ 2024 ಜನವರಿ 20 ಮಾಹಿಯೇ ಹೊರವರೆಗೆ ಗೌರವಧನ ಪಾವತಿಸಿದ್ದು ಉಳಿದ 2 ತಿಂಗಳ ಅಂದರೆ ಫೆಬ್ರವರಿ ಮಾರ್ಚ್ ತಿಂಗಳ ವೇತನವನ್ನು ಹಲವು ಬಾರಿ ವಿನಂತಿಸಿರೋದು
ಹ್ಮ್.
ಕೊಡಿ. Then we paid that amount, my lord. That is kindly similar in the memo I filed along with the receipts, my lord. That is. That will be take in course, my lord, because this is the amount, my lord, we have to send the first treasury, my lord. Treasury in turn to the, my lord, after verification, it will be put to
Correct. So we'll have it after a
Yes,
week.
my lord. After 2 weeks, my lord, you'll also pay out on 11th, my lord.
Till for the government advocate submits, order is complied, amount is cleared for remittance to the complainant. Full stop. For the list, relist on
10th.
10th.
Right.
Yes.
Number 80. Ratna and Shivyogimma.
Yes. Notice is, service of notice is still not complete. Two zero zero. Huh? Which matter? You're appearing in which matter? But all these three are connected matters.
The same order is the subject matter of all the three appeals. For whom?
The first of them is taken over the additional floor.
ನೀವು builders ಇದೆ, ಅಲ್ಲ? ಬರೀ purchase. You have built it. You have to demolish the building which you have constructed.
You appear for whom, madam?
My lord, on behalf of DP Ambekar, the Commissioner Mahanagar Palika Kalaburagi, my lord.
What is your stand?
Senior is held up in court all 4, my lord, kindly pass over.
Pass over.
Yes, ma'am.
Any of this requires hearing. We'll stay the order, we'll see later.
There is already order not to precipitate the matter, my lord. There is a direction by this on the court, my lord, on 28 one last occasion.
ನಮ್ಮ appeal number. ಏನಮ್ಮ?
There is no order.
Two 49.
2000250 for it. 2000250.
250.
Interim order is only. We'll extend the interim order, let the service be complete.
All right.
There is already an interim order directing the Commissioner Kalaburagi Mahanagara Palike not to precipitate the matter. We'll extend that, let the service be complete. Earlier, the interim order passed in WP 2000250 of 2024. Extended in other writ appeals as well. In order dated 28/10/2024 is extended till the next date. Service of notice in all the matters to be completed by the appellants.
Right.
Yes. List week after next.
Number 90.
Simple. Thank you.
Justice Aspal.
Yes.
My lord, my learned friend has filed an application for release of the 50% of the award amount. Here in this case, my lord, only 2 points are involved. One, quantum. I have clearly mentioned at para 2 of my grounds, my lord. Just if it is perused once. Para 2 of my grounds, my lord. Just I have written in detail. There is a reduction to the extent of 5,64,840, my lord. Just I have mentioned clearly. As per salary slip, my lord, he is drawing salary of rupees 33,573, my lord.
Yes, yes, what is?
My lords,
Gross salary through is sir. As per their salary set.
in ground
The,
number.
the awarded by the tribunal is correct, my lords, because the gross salary has been taken and 50% has been added because he is a government employee. And deduction of 50% is also deducted. And other heads also, my lords, awarded as per Pranay Shetty. And one other is that, my lords, 10% escalation is not awarded. That is also, my lords.
For
No, let the amount be, let him take the money.
50% has been
Deposit.
future prospectus has been granted, my lord. So only one point is
Escalation is not provided.
my lord, escalation.
Escalation.
Yes, yes, I concede, my lord.
That is not time challenged.
Escalation is not provided.
Yes,
We can square it off is what he's saying.
my lord.
Even if you take your deductions,
Yes.
if you take escalation, it squares off there and there.
Escalation bhal agala. Escalation
10%.
10% ಆದ್ರೂ ಕೂಡ
ನಾವು
yes, yes, ma'am. As per
ಅಲ್ಲಿಗೆ ಸರಿ ಹೋಗುತ್ತೆ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
ಅದೇನು deduction ಮಾಡಕ್ಕೆ ಬರೋದಿಲ್ಲ.
Apart from that,
what is the deducted by the tribunal is correct, my lords.
Apart from that, my lord. Apart from that.
No, now let him withdraw the amount, the rest we'll see. We'll see. Let him withdraw the.
LCR maybe.
ಅಲ್ಲ LCR ಕಾಲ್ ಮಾಡಿದ್ರೆ ನಂಗೆ withdraw ಮಾಡ್ಕೊಳಕ್ಕಾಗಲ್ಲ.
We'll let him withdraw the amount. We'll send to for local.
Local agala, sir. They will not agree.
Accepting the reason assigned in the memo filed by the land council for the respondent, the respondent is permitted.
Respondents, two respondents.
Permitted to withdraw the amount deposited
Before the tribunal.
before this court by the.
Before the tribunal.
By the appellant, my lord, insurance company.
Before this court.
Tribunal.
Tribunal by virtue of the interim order passed by this court dated so and so and so.
Records may be called for.
Records ಮಾಡಬೇಡಿ ಸರ್. ಯಾಕಂದ್ರೆ after the.
Because after release of the amount, records may be sent. Otherwise, it will go further.
What to do? Records
records because he may insist in future, my lord.
ಇದರಲ್ಲಿ ಇಲ್ಲ ನಾನು future ಕೊಟ್ಟಿದ್ದಾರೆ.
After release of the amount, records may be sent.
Let him withdraw the amount first. Thereafter we'll see.
Yes, ma'am.
After release of that amount, records may be sent.
The registry is directed to secure the trial court records after withdrawal of the amount by the respondent.
Yes, ma'am.
Yes.
During the course of
Weeks time granted for taking of necessary steps. 20 and 20.1.
Lord, may direct AGA to take notice for all the respondents.
My lord, my instructions, officer, they are implementing, my lord. It takes, the orders passed by the High Court are to be implemented through Deputy Commissioner only. Therefore, it took some time, my lord. It will be posted on, my lord, Wednesday or Thursday next. By that time, I will produce the, my lord, ROR.
You are implementing it.
Yes, my lord. And along with the affidavit, I file on the Thursday, my lord.
29.
This is the matter. On 29th,
Please, my lord.
AGA submits that there would be compliance by the next date.
Please, my lord.
SS Mamadapur.
To appear for the petitioner.
In this matter, my lord, just now, instructions, my lord, I have received some papers. I will go through and submit, my lord.
2:30.
2:30 ಬೇಡ ಸ್ವಾಮಿ ಒಂದ್ 2 ದಿವಸ ಯಾಕೆ ಅಫಿಡೇವಿಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ PSI has to come. ಈಗ ಬೇರೆ ಒಬ್ರು ಆಫೀಸರ್ ಬಂದಾರೆ ಪ್ಲೀಸ್. It is with regard to the, my lord,
Detention under the provisions of Gunda Act.
Gunda Act
The
detention.
detaining authority.
At liberty if a person is involved in this case, how you can take very casually your police officers? Who is that police officer? In a matter of preventive detention.
Yes, ma'am. ಅದೇ ಬೆಳಿಗ್ಗೆ ಬಂದು ಮಾಡೋ ಪೇಪರ್ ನೋಡಕ್ ಆಗಿಲ್ಲ.
Yes, Saturday.
My lord,
Saturday.
25th.
25th.
please, my lord.
Please.
Irappa.
There are two office objections, my lord. One is with regard to translated copy of Kannada version, my lord. The same may be dispensed.
Section C number 52 regarding translated, furnishing of translated copy of documents is kept in abeyance for the present. Next.
Next, typed copy of Alexander F. It is a letter, my lord, one-page letter, and that is readable, my lord, given by the petitioner to the authorities.
The office objection is seal number 27 is kept in abeyance subject to the undertaking if at the time of hearing of the matter legible clearer copies are required. Counsel for the petitioner undertakes to furnish the same.
Yes.
What is the matter?
The matter is, my lord, the petitioner's daughter, my lord, who is about 16 years of age, studying in 10th standard, my lord, is in the custody of respondent number 7 since more than 3 months. They have kept her custody on the basis of some anonymous complaint stating that her there is some child marriage happened. So they keep the custody with them. Till today, neither they have registered any FIR. The parents are going to their office asking for her because they can keep the custody only if she is destitute or she is in care Lord, even the parents.
No, let them get a report.
Yes, ma'am. Even parents are ready to keep her present whenever they required, my lord. They unnecessarily keep in the custody, my lord, since more than 3 years because of her study is held up, my lord. She is studying in 10th
Since
standard.
when she is in the home? Since when she is in that home?
It is since 3 months, my lord.
3 months.
3 months.
We'll have it on Monday. Let them file the report.
Because her study is
Monday,
got
we'll have
held
it
up,
on
my lord.
Monday.
10th standard, that is.
Correct. We'll inquire into it forthwith.
If at all, my
LGA
lord, they say that there is some child marriage, they can file a register FIR. But what is the reason to keep her in the custody?
No,
That
we'll
is
find out.
unnecessary.
Yeah,
Is some
LGA
reasonable
accepts
reasons.
notice for response 1 to 7. Necessary report to be filed by the concerned by the next date. In the interregnum, taking note of the nature of matter, the Deputy Secretary, Juvenile Justice Committee, as an is directed in the capacity of an intervener to inquire into the matter and place report by the next date. Release the matter on 27.
Please.
Copy of the order to be communicated to the Deputy Secretary, Juvenile Justice Committee.
Please.
Here, the Juvenile Justice is not party, my lord.
Correct,
As an intervener, ಅವರಿಗೆ
Yes.
24. Prashankar Manu.
In this matter, my lord,
Yes.
in this matter, my lord, no conference meeting was, my lord, your lordship directed us to proceed with the no conference meeting on 18/1, my lord. We conducted the, my lord, and lordship is also directed to get the records.
Report.
Yes.
Report.
Report, my lord. That is, my lord, madam.
So now let him, you have a look at it.
Yes.
Have a look at the records. We'll have it on the next date. Let him inspect the
We
file.
also know that one, my lord. 2/3 members, my lord, he was the president.
ಅಲ್ರಿ ಸರ್ ಹೇಳ್ತಾ ಇದ್ದು ನಾನ್ ನೋಡ್ತೀನಿ.
Let him see. The-
And counsel for respondent number 7 not present me not today.
No, that's okay. Now, since you have to make out a case.
Yes.
You see whatever you want to. GA, you permit him to take a photo of whatever he wants to rely on. We'll take it up on someday.
Lordship direct, we
Yes, I'll
make
do.
a adjournment.
The government advocate has produced, placed before the court the records relating to the proceedings. Full stop. He's permitted to take back the record and share and permit the counsel for the appellant to inspect and take photos of relevant documents that the appellant feels would be of assistance to his case. Relist the matter on. We'll have it next week.
Date.
Third of April.
30th.
Third.
Third. First
20,
week.
when you want.
10th, lordship.
10th.
ಇಲ್ಲ. No further postings to be conducted in the.
No.
No, that
That
will
you
have
argue next week. Next week yavattu? 29th,
29th, you will also 30th.
29th, 30th.
Please.
Please, you will go through whatever you want and get ready.
My lord, in the meanwhile, my lord, they cannot proceed for election.
You have already said subject to the outcome. 29th, election madadu, it will take 10 days at least.
That one requested the deputy commissioner, my lord.
ಅಲ್ಲ ಏನಾಗುತ್ತೆ otherwise in stretches ಆಗ್ಬಿಡುತ್ತೆ.
No, then I will pass over, you get ready. Go
I am
to-
ready. 2:30 I am ready, my lord. Whatever
Pass
order.
over, have a look. Pass over. Yes.
25.
In this case, on last date of hearing, Lordship had directed the government to ascertain whether hostel warden post is there available. Government, but I also inquired, my lord, there is no any hostel warden post. She was working, though she was promoted as a hostel warden, she was working as a hostel superintendent itself. There is no post, my lord.
ಇನ್ನು ಇನ್ಫಾರ್ಮೇಶನ್ ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ.
Permission, my
You
lord.
complete your instruction.
Permission. Annexure A4.
Hmm.
In page 28. It was challenged before the honorable tribunal on two grounds. That insofar as disturbance of the petitioner is concerned, it is premature one and without posting. And the honorable tribunal only on the relying of the reply statement of the contesting respondent number 4.
Now, just one. As on date, now what has happened to the transfer order? Set aside or stayed?
Actually, it was stayed, but my application was disposed of with a direction to provide posting to the petitioner. That is applicant. As on today, by virtue of interim order of the honorable tribunal, I have continued. And after disposal of the case, the fourth respondent took assumed charge without, I have not handed over the charge as on today also. And it is admitted by the other side. She has taken the charge on the strength of the order passed by the tribunal.
Just one. Yes.
As per the transfer, my lord, the posts are not available as per instruction.
Now we'll dispose it off.
Please.
You complete your instruction. Have it tomorrow.
Tomorrow, instead of tomorrow, day after tomorrow at
Day
least.
after tomorrow. You
Please.
complete your instruction.
Please.
Transfer matter will dispose it.
Please,
Yeah.
madam, please.
GA to complete his instruction. Relist the matter on 25th.
25th, Saturday.
25th.
With permission.
Backward committee.
Number 26, Then go to Malipati.
This is yesterday's matter, my lord, regarding engineering student, my lord. I have secured the judgments and even the lordship had directed to produce the calculation memo and as well as judgments where whatever the compensation claim, more can be awarded. Sir. And even I have made I've made a calculation also, my lord.
My lord, what's, sir? My lord, I am submitting apex court citations, my lord. Division bench citation of Madras High Court. That is a recent apex court decision, my lord. I may permitted to convince on that point. As far as the apex court citation is concerned, similar facts of this case, my lord, which is disposed of in the year 18/11/2021, my lord. Wherein the Honorable Tribunal, he is an engineering student, Honorable Tribunal has considered 15,000 per month, my lord. The matter went up to Honorable Apex Court. In the pleadings and also evidence, it has been brought to the notice of the Honorable High Court that the deceased was also drawing, while studying, he was also drawing salary and also taking tuitions. So this aspect has been rejected by the Honorable Supreme Court after hearing both sides. So there is no evidence on record that he was an earning member, just he was a student. And considering the evidence on record and his occupation, he being a student of the BE third year, the Apex Court reduced the compensation. MACT has granted 15,000 per month. As far as future prospect is concerned, that has been considered. 50% was, he was a bachelor, 50% was 40% towards future prospectus, deducted 50% and granted the compensation. The present case on hand is aptly applicable to the facts of this case, my lord.
How much considered by the apex?
My lord.
How much considered by the apex court?
10,000 per month, my lord.
10,000.
Yes, my lord. Apex court, because tribunal has considered 15,000 per month, my lord. So that was not considered. That has been rejected by assigning the reasons, my lord. Even occupation is also not considered. He was a student. There is no material on record. And same on the same line, my lord, the division bench of the Madras High Court, division bench, my lord, wherein also the honorable division bench is pleased to consider the income of the deceased who was in engineering, 10,000 per month, my lord. But case on hand is very much clear that they themselves, even in this apex court decision, your honor, I will not come in the way that if they are entitled more, they are entitled, but
The thesis of engineering, which semester? Fourth semester.
Fourth semester, my lord. Based upon engineering, my lord, there is one more judgment. This is the. It has held, my lord, 20,000. What is taken by the tribunal is proper. My lord, para 4, my lord. Sorry, para 5. Lordship permits, having heard the learned counsel appearing for the respective sites and consider the fact that this is at time of death accident was aged 25 years of age and was a Bachelor of Engineering Computer Technology. We are of the opinion that the tribunal rightly considered the income of the deceased at the time of the death at least 20,000 per month. the same was not required to be interfered with by the High Court. The submission on behalf of the respondent insurance company that has no documentary evidence was produced or laid in support of the documentary evidence produced on record that deceased was earning 20,000 per month, and therefore the tribunal ought not to have assessed the income of the deceased at 20,000 per month is concerned, assuming that there was no supporting evidence laid. In that case, also considering the potentiality to earn, as the deceased was a Bachelor of Engineering in Computer Technology, his income can be safely be assessed at least rupees 20,000 per month. As such, we are in complete agreement with the view taken by the tribunal.
What is the year of accident in the apex court judgment?
My lord, it's 2000. Cholo, my lord.
ಅಲ್ಲ ನಿಮ್ದಲ್ಲ ಇವ್ರದ್ದು
13 ಇದೆ.
ಅಲ್ಲ ಇವ್ರದ್ರಲ್ಲಿ
It's not mentioned, my lord. It is only says appeal was of the year 2018, miscellaneous first appeal.
Accident
is not mentioned, my lord.
2013 ಇದೆ. Really, what my learned friend has relied ruling, probably that is in year of accident of 2018 year, sir.
Lord,
Recent judgment.
In the memo of
18 or
citation,
yes.
memo of citation which I have produced, my lord, in respect of judgment in Vasanti case, that is at page number 11, my lord. Here is also a case of engineering student. 30,000 has been awarded. Accident is of the year 2010, my lord. Here she was a second year MBA student, my lord. Para 11, Vasanti case, my lord, at page 11. In para 11, it says it could be seen that the deceased Satnarayan was 23 years of age at the time of the accident. He was a qualified engineering graduate and was pursuing MBA degree to further his professional career. In view of the specific comments made in the affidavit as to the employment prospectus of the classmates of the deceased, taking into consideration all this, 30,000 has been income has been taken for the accident occurred in the year 2010. Man.
Yes, sir. Yes, sir.
Lord, Lordship had even asked to provide the memo of calculation I have provided.
The pending case, my lord,
separate calculation for in both.
Yeah. Lord, I made calculation for
my
both
lord,
20,000 and 15,000 both.
Could
my lord, in the present case,
We will dictate your facts and your contentions.
my lord,
Will dictate your facts and contentions, yes.
yes, in the present case on hand, my lord, the year of accident, in the present case,
Both are calculated on 15 and as well as 20, my lord. This is
Injury case.
injury cases. Injury case 36,000 would be the enhancement. Even 20,000 calculation is also both, Lordship had said both 15 as well as 20, both we have calculated memo, my lord. But law is clear, 20,000 is the minimum amount being taken, my lord.
Told you to give this one.
Sorry, my lord.
You
Sorry.
want 5?
I'm sorry, my lord. By handing over, in injury case, it will be only 36,000, my lord.
What has expressed some opinion, that also you are.
My lord, while handing over, I.
Present case on hand, my lord, year of accident is 2013, my lord. 2013. What my learned friend has relied by the citations, it pertains to 2018, my lord. It's date of accident.
Yes, yes. I will consider, we'll consider. MFA number 201727 of 2015. And MFA number 20085 of 854 of 2015, arising out of filed against the judgment and award passed in MUC number 55 of 2014. 55 of 2014. Can be defect.
In case of death, my lord, it is MVC number 55 of 2014.
55 of 2014. By the dated 13/4/2015 by the MACT.
Yeah, to Yadgir. Number of MACT Yadgir.
Number of MACT 2 at
Yadgir.
Yadgir, wherein the learned tribunal allowed the claim petition
By awarding a compensation of
rupees
6,67,000.
440 with the interest at the rate of 6% per annum from the date of petition till realization of the amount against the respondent. It is ordered that the respondent number 1, 2, 3 are jointly and severally liable for payment of compensation. For sure. Against the said judgment, the claimants filed MFA number 201727 of 2015 for enhancement of the compensation.
Yeah.
However, the insurance company also filed the appeal in MFA 200854 of 2015 to set aside the award. So set aside the judgment and award. Full sure. The facts set aside for consideration which was borne out from the pleadings are that on 13/12/2013 at about 1:45 PM at Yadgir, Hyderabad Road near KSRTC Road, near KSRTC workshop, the one Priyanka, that is the daughter of claimants in MUC number 55 of 2014, 55 of 2014 was proceeding in Tavera Jeep bearing number AP09AZ2727 from the side of Mahibub Nagar to Wadi. Full shot. At that time, the driver of the Jeep drove the same with the high speed in a rash and negligent manner and dashed to the lorry truck bearing registration number KA281186 due to the impact, the said Priyanka sustained grievous injuries, and so she shifted to government hospital Rayachur and thereafter to Suraksha Hospital Rayachur, however, she succumbed to the injuries. Full shot.
Lorry also driven
Injuries. Yes, head burden, injuries, full shot. Injuries. Due to the due to the same injuries, full stop. As such, the jurisdictional police registered a crime registered a case against both the driver of the jeep, so also the driver of the truck. Driver of the truck in crime number 281 of 2013 in Yadagiri, rural police Yadagiri, Yadagiri, full stop. The as such, full stop. Since the death of the said Priyanka was in a road traffic accident, her parents filed the MUC number 55 of 2014 for compensation. Full stop. In the said accident, the very same accident, the claimant in MUC number
232 of 14.
232
of 2014.
232 of 2014 was also traveling in the same jeep, same jeep, and he also sustained injuries, injuries due to the accident. Injury to that. As such, he also filed a claim petition in MUC number 232 of 2014 before the tribunal, before the same tribunal, before the same tribunal, full stop. After full stop, to prove the full stop, as far as in MUC 55 of 2014, to prove the claim of the claimants, before the tribunal, the claimant number 2 as examined as PW1, so also got marked 21 documents as exhibit P1 to P21. However, the insurance company, that the officer of the insurance company also examined as RW1 and got marked one document, that is exhibit R1. Exhibit R1, full stop. After assessment of the oral and documentary evidence, the tribunal partly allowed the claim petition and granted the compensation of rupees 6,67,440 as stated supra. Full stop. As far as in full stop, as far as in MUC number 232 of 2014, to prove the claim petition, the claimant himself examined as PW1, examined as PW1, so also examined the doctor as PW2 and got marked 8 documents, that is exhibit P1 to P8, P8, full stop. However, the insurance company has not examined any witness nor got marked any documents. Accordingly, the tribunal granted the tribunal allowed the claim petition in part and granted a compensation of rupees 1,84,600 with interest at the rate of 6% per annum from the date of petition till realization of the amount against the respondent number 1 and 2. Full stop. These two judgment and awards challenged by the respective claimants, that is the claimants in MUC number 55 of 2014, 14 in MFA number 201727 and the said judgment was challenged by the insurance company in MFA number 200854 of 2015, whereas the judgment and award passed in MUC number 232 of 2014 challenged by the claimant in MFA number 20116 of 2016.
20126.
20126 of 2016 and the insurance company has challenged the same in MFA number 200870 na?
Yes, ma'am.
870 of
16.
2016, full stop. Since the cause of action arose to file these, though the judgment and award passed separately, by the tribunal, comma, since the cause of action the same cause of action arose, comma, the matter was clubbed together and taken up for final disposal. First, we have heard the learned counsel for the claimant, so also the insurance company. First, the learned counsel for the claimants in MFA number 201727 contents that the primary contention of the learned counsel in MFA number 201727 of 2015 that the tribunal has erred while granting the compensation on the compensation compensation the compensation for the following reasons. Number one, the tribunal has not considered the aspect that the deceased Priyanka was an engineering student, was studying fourth semester.
Final year, 8th semester, that is final year, 4th year of engineering.
Was studying 4th year of the engineering degree, was pursuing the 4th year engineering degree, and engineering degree, and she is a potential student, without taking into consider the said aspect, the tribunal granted it a compensation of tribunal as consider her income at rupees 10,000.
6,000.
6,000.
They have claimed 10,000. They have claimed 10,000 in the petition.
6,000 per month. 6,000 per month. 6,000 per month. Full shop. For the tribunal also erred by what is your next?
My lord, under the head of consortium and under the other heads.
The tribunal also erred while granting compensation under the other heads, full other heads. Whereas the said judgment is challenged by the insurance company on the ground that the accident was caused due to the head-on collision and with the driver of
the MACT has come to the conclusion that both drivers are negligent.
Yes, the accident was caused in the head-on collision, and both the vehicles involved in the accident was contributed the negligence, and the said aspect was admitted and relied by the tribunal. In spite of that, there is no apportionment.
Yes.
Apportionment
Yes.
of compensation, apportionment of the
Negligence.
negligence
Yes.
and liability. Negligence and liability. Further, according to the learned counsel, the claimants in the claim petition has clearly stated that
The income of the deceased at rupees 10,000 per month.
10,000 per month. In such circumstance, the tribunal justified.
Yes.
Justified
in considering
by considering her income at rupees
6,000 per month.
6,000.
Considering the year of accident 2013.
The year of the accident was 2013.
Yes.
13, full shot. Where another nimdu? Where any?
My lord, the charge sheet has been filed against the lorry driver, wherein the lorry driver does not have any DL.
Also contends that though the charge sheet was filed against the truck driver, he has no driving license at the time. He had not possessed the driving license at the time of accident.
And owner is also prosecuted.
Yes, and accordingly, the owner of the said truck was also prosecuted in
giving the lorry to a person who does not have any DL.
Yes. In such circumstance, what is your contention?
The entire liability should be passed on the.
In such circumstance, the tribunal ought to have fixed the entire liability against the owner of the
lorry.
Owner of the truck. Yes. With this submission, he prays to allow the appeal filed by the insurance company by dismissing the claim petition, by dismissing the appeal filed by the claimants.
Further, my lord, my contention. Since the claimant himself has claimed in his claim petition evidence and also in appeal memo filed before this honorable court the income is not more than 10,000. Under these circumstances, considering the citation of the Supreme Court, in appeal also, there is no this.
Burden.
Nothing-
10,000 anta it stated.
Yes.
They were to buttress his submission, he relied the judgment of the Honorable High Court of the Nagpur.
Supreme Court.
Supreme Court in a
My lord,
judgment
in
reported in Meena Pavinana.
yes, my lord.
Huh?
Meena Paiva and others.
Paiva and others.
Afsar
versus
Ali.
Ashraf Ali and
Yes.
others.
Which is
Reported in 2022 ACJ 528. So also they so in the judgment of IFCO Tokyo General Insurance Company versus Kalesh Silvi and others reported 2024 ACJ 1061.
Yes, madam. Yes, madam. Yes, madam. And I may not be wrong, my lord. I should not submit. If my lord is take to income more than what my learned, he has submitted two calculations, my lord. 15,000 and 20,000.
Really?
What my
Just a minute.
what my learned friend has been relied on the citation, that those citations, year of extent is different, my lord. And the present case on hand, year of extent is 2013. And what my learned friend has been relied on, 2018, 19s are there, man, not recent accident, my lord. Considering the status in the year 2013, and as they claimed in the claim petition and evidence, and also in appeal memo, even in the appeal memo, nothing has been prevented to them to claim more. See, nothing is while filing the appeal also, because they want an enhancement, but they have restricted their income to 10,000 only during that period also. So under these circumstances now,
Settled law, it's just compensation.
Yes.
Even in the while submitting, now also the Crown Council said 15,000 of the memo ಹಾಕಿದೆ. What to do? ಅವ್ರು ಹೇಳಿದಾರೆ ಅಂತ ನಾವು ಏನು ಕೊಡ್ಬೇಕು ಅದನ್ನ ಕೊಡ್ಬೇಕಾಗುತ್ತೆ. That's all. That is our view.
my lord,
Government, my lord,
my lord,
in
I concede, my lord,
Yes.
that I concede. I will not come in the way, but just I would like to bring my honor's notice that the income considered by the Apex Court is also taken a decision in the similar facts and circumstances of the case. So that is binding more than the High Court decisions, my lord, because the Apex Court is a decision pronounced on 2021. So there is no reason to disbelieve considering the background of this case, my lord.
The decision relied by the council also of the.
my lord, if even otherwise, this honorable court taking into account
Yes, we will consider. Next. As far as the in MFA number 20085 of 2015 is concerned, the learned counsel for the appellate submits that the tribunal erred while granting the compensation by not considering the relevant factors, that is the evidence of PW to the doctor and also the
Nature of
the injuries, the disability.
nature of injury
Okay,
sustained.
the nature of disability sustained by the injured, full stop, injured. Accordingly, he prays to allow the said appeal by enhancing the compensation. Whereas the learned counsel for the respondent submits that the tribunal has justified in granting the compensation by considering the evidence of the injured, so also the doctor,
Yes,
so
ma'am.
also the doctor and the wound certificate issued by him,
Yes.
issued by the doctor, full stop. Accordingly, he prays to dismiss the appeal, full stop. Having heard the learned counsel for the respective parties, so also perusal of the documents made available before us, the point that would arise for our consideration is whether the tribunal is justified in awarding the compensation juvenile is justified the awarding the compensation of rupees so and so in MUC number. First is the madam, in MUC number
55 or
55 of 2014. And next, whether the tribunal is justified in awarding compensation of so and so in MUC number
232 of 14.
2014. Next, point 1. As per point number 1, as per the full shop, as could be seen from records, comma, as could be seen from records, comma, it is not in dispute that the accident was caused on 13/12/2013 and 13 due to the head-on collision of the jeep in which the deceased was traveling and the truck and a lorry bearing number KA 281186. Full stop. Due to the accident, the deceased Priyanka sustained injuries and thereafter she succumbed to the injuries. Full stop. So the jurisdictional police also registered the fire in crime number 281 of 2013. Thereafter, after the detailed investigation, charge sheet has been laid by the said police against both the driver of the jeep, so also the driver of the lorry. Full stop. As such, it is clear that both the for the said accident, both the drivers of the vehicles were contributed their respective negligence. Full stop. In such circumstance, the claimant has filed the parents of the deceased Priyanka have filed the claim petition for compensation. Full stop. For compensation. It is settled principle of law by the Honorable Apex Court in the case of
Kanaya case.
Kanaya.
I'll give the
That the claimants are entitled to file claim petition against any one of the joint tortfeasor. Any one joint tortfeasor. Full stop. Joint tortfeasor. Hence the claim petition filed by the claimants cannot be rejected on that ground. And they were the respond number, and it is also not in dispute that the Mahindra Jeep was insured with the
appellant, sir. United Nations.
With the appellant in MFA number so and so. In MFA number, madam. In MFA number
200855
of 2015.
854.
2015. Full stop. In such circumstance, we are unable to accept the contention of the learned counsel for the respondent insurance company that the tribunal erred while fixing the liability to the insurance company. Full stop. As per the compensation insurance company, as per the
liability was not apportioned in this case.
Yes.
Other case, they apportioned.
As per the compensation awarded by the tribunal is concerned, it is the contention of the learned counsel for the appellant that the tribunal has not considered the aspect that the deceased was studying both her final year engineering degree. Full stop.
Not final year.
Engineering degree.
Fourth year.
However, in the claim petition and before the memorandum of the appeal in the memorandum of appeal, the claimants have stated that the salary of the deceased was at rupees 10,000.
No salary.
Tuition.
Student.
Sorry, tuition.
By tuition,
Income at rupees 10,000 per month.
They claimed.
They claimed They claimed rupees 10,000 per month. However, 10,000 per month. Full stop. Mere claiming the compensation by the claimants is not a bar to grant enhance the compensation regardless of the claim made by the claimants. claimants. This aspect was, this aspect of the matter was very much settled by the law laid down by the Honorable Apex Court in the case of Ramla and other sources, National Insurance Company Limited and others reported in 2019, Volume 2, SCC 192, wherein the Honorable Apex Court has held that held in para number 5, that there is no restriction that the court cannot award compensation exceeding the claimed amount, since the function of the tribunal or court under Section 168 of the Motor Vehicles Act 1988 is to award just compensation. The Motor Vehicle Act is a beneficial and welfare legislation. Full stop. A just compensation is one which is reasonable on the basis of evidence produced on record. It cannot be said to have become time barred. Full stop. There is no need for a new cause of action to claim an enhanced amount. The courts are duty bound to award just compensation. Just compensation. Full stop. In such circumstance, full compensation by applying the above principle laid down by the Honorable Apex Court to the fact and circumstances of this case, we are of the view that by awarding we were of the view that on that account the claimants are not barred to claim more compensation before this court in the present miscellaneous first appeal. Full stop. First appeal. Full stop.
But
as far as first appeal.
In the miscellaneous first appeal also, they are not claimed more.
Appeal member, consider. Yes. Full stop. The full stop. This court full stop. The coordinate full stop. They admittedly admittedly the deceased was a final year engineering student and the said aspect was proved by
producing
placing the
certificate
documents in exhibit
P7.
Exhibit
P7.
P7,
P7.
exhibit P7, full stop. The P7, though she, full stop. In such circumstance, though we are of the view that if she had successfully completed her course, then successfully she would have earned the income, sufficient income. Full stop. The coordinate bench of this court in MFA number 201712 of 2014, dated 11/12/2015, held that there can be many a slip between the cup and lip, ifs and buts do not form conclusive proof and conclusive proof. Full stop. The conclusive proof. Full stop. The climate, the deceased was studied till completed her 4th year.
No,
Was in the final year.
Final year engineering course. We are of the engineering course. We are of the consider view that our income has to be considered at rupees 20,000 per
one submission.
Yes.
My lord, is to be considered 20,000 rupees, my lord. The citations of our own division bench, which is disposed of 2 citations, my lord, this may kindly be referred, my lord. 2 citations are there. It has been considered here 15,000, my lord, which is disposed of on March 2020, relied by both our division bench. My lord, here
MVC, quantum are like bail orders.
My lord.
Quantum orders on quantum are like bail orders. They are not precedents in any case. It only depends on the perception of how we look at the potentiality of that student. Bail orders, can we say like that only? Quantum is cannot be relied as a precedent. What I think is different from what you think, and that's how it is. Quantum, there is absolutely no precedent in quantum. I may take 5,000, I may take 10,000.
In memo of citations.
We are aware, but we are saying you give it, we'll refer to it.
This citation.
We'll refer to it, but we're saying quantum orders cannot be used as a precedent. They are like bail orders. Yes.
I concede my lord.
Yes.
This citation may kindly be referred back.
So, yes.
Because in this case, earlier judgment of the Honorable Apex, the division, both are division bench citation, my lord.
I'm again saying, quantum, there is nothing like precedent in quantum.
We have considered the judgment, we have considered the judgment relied by the land council for the insurance company. However, on careful perusal of the fact and circumstance of this case, since this is of the water accident claims, it's a beneficial legislation, and the said benefit has to be extended to the climates, we are of the view that the rupees 20,000 would suffice to
that judgment
20,000 income. ಆಯ್ತು ನಾವು refer ಅಂತ ಹೇಳಿದ್ರೆ ಮತ್ತೆ ಎಲ್ಲೋ ಒಂದು ಬರಿಬೇಕು
ಆ judgment refer ಮಾಡಿದ್ರೆ at least
ಎಲ್ಲೋ ರೆಫರ್ ಮಾಡ್ತೀವಿ ಇದನ್ನು ಕೂಡ ಮಾಡ್ತೀವಿ.
Because in that judgment earlier judgments are referred, my lord. Otherwise there is no consistency in the judgments, my lord.
But the argument ಈ judgment 20,000 full show as such full show 20,000. Next memo ಇದೆ. Next memo ಪ್ರಕಾರ ಎಷ್ಟು ಬರುತ್ತೆ ಅಂತ ಈ ಮೆಮೊದ ಪ್ರಕಾರ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಎಲ್ಲವನ್ನ ಮೆಮೊದ ಪ್ರಕಾರ ಏನಿದೆ ಸರಳವಾಗಿ so on.
My sincere
So the only point only 20,000 ಅಷ್ಟೇ.
Yes, madam.
Rest of the things saved.
Rest of 20,000 under consortium 10,000 badly 80,000, my lord. And loss of love and affection and funeral expenses, funeral expense transportation 30,000 in
You have any
spite of
say
10.
in the other heads?
Also, my lord.
You have any say in other heads?
The tribunal has considered 50% future prospects, my lord.
40 we have
Here
done.
is a 40% is to
That I have done 40.
Same thing, no?
We have changed
Same.
40.
40%.
40 money.
40%, 50% personal expense to be deducted. Bachelor.
That has been done.
It's
That has
also
been,
deducted.
everything is done as per
So everything is
Other heads will not come in the
Same, my lord.
conventional heads.
so yes, the total account.
My only is my lord.
Since the claimants are entitled for the enhanced compensation of rupees
31 lakh 39 1 lakh 39,640.
31 lakh 39,000
640.
640 for sure. 640. The insurance company is in 640. Accordingly, the appeal allowed by the claimants are allowed. Appeal filed by the claimants are allowed, and consequently, the appeal filed by the insurance company is hereby dismissed. In that view of the matter, we answer the point raised above in the negative, and proceed to pass the following order. Then allowed in part and ಹಾಕೊಳ್ಳಿ ಹಾಕಿ.
That my judgment, my division bench judgment, recent judgment, it may kindly be referred, man.
ಎಲ್ಲವನ್ನು ರೆಫರ್ ಮಾಡ್ತೀವಿ. ಎಲ್ಲವನ್ನು ರೆಫರ್ ಮಾಡ್ತೀವಿ. ವೆಹಿಮೆಂಟ್ಲಿ ಕಂಟೆಂಡೆಡ್, ವೆಹಿಮೆಂಟ್ಲಿ ಆರ್ಗ್ಯೂ, ಏನೇನು ಎಲ್ಲವನ್ನು ಬರೀತೀವಿ ಮಾಡ್ತೀವಿ.
Lordship, in my memo of citation of number 5, this court has taken 22 on 2012 the government salary itself was 22 for minimum salary. That's clear ಬರ್ದಿದ್ದಾರೆ ಅದರಲ್ಲಿ engineering student.
Yes. Next, as per the MFA number 201126 is concerned, the tribunal. ಅದರಲ್ಲಿ ಬೇರೆ ಯಾವ್ದು ಇದಿರಲ್ಲ, ಅದರಲ್ಲಿ ಮೆಮೊ ತೋರಿಸಿದ್ದೀರಾ?
ಅದು ಕೊಟ್ಟಿದೆ.
Have you read the memo?
My lord,
36,600.
ಈಗ ಕೊಡ್ಲಾಕತ್ತಾರ ಸರ್ ಎಲ್ಲ ಕ್ಯಾಲ್ಕುಲೇಷನ್ಸ್. They have not given earlier.
36,600 ಮಾಡಿದ್ದಾರೆ ನೋಡಿ
ಅಷ್ಟೇ.
ಅಲ್ಲ 10% ಇದೆ. 10%.
ಇದ್ರಲ್ಲಿ ಏನಾದ್ರು ಸೇ ಇದೆಯಾ ನಿಮ್ದು?
Income must change.
Right.
ಸೇ ಇದ್ರೆ ಡೀಟೇಲ್ ಬರೀತೀವಿ, ಇಲ್ಲಾದ್ರೆ ಸೇಮ್ ಅದನ್ನೇ ಮಾಡ್ತೀವಿ.
Right. Yes, ma'am.
ಅಶ್ವಲಿ ಅವರೇ?
Yes, ma'am.
Yes. Accordingly, it is appeal also. Adanu allowed, the appeal filed by the claimants allowed in part. Consequently, appeal filed by the insurance company is dismissed, and the claimants are entitled for enhanced compensation of rupees 2,30,000. ಎಷ್ಟು?
2,30,000.
2,30,200. ಅಲ್ಲ 36,600.
That
is 6% interest. Full shot. However, as per the apportionment of the MO, the liability, apportionment of the liability is concerned, comma, as rightly contended by the learned counsel for the respondent, comma,
Yes.
both the driver, the owner of the truck
Yes.
and the insurance company of the jeep
Yes.
are equally liable, and
They can recover, as per
and-
Kenya case, they can recover from the,
yes, the 50% equally 50% for the compensation, and the insurance company is liable to pay and
Recover 50%.
Huh?
Recover 50%
and
from
recover 50% of the
From
amount
the owner of the lorry.
Owner of the lorry.
Yes.
Owner of the lorry. That is respondent number,
respondent number 3 before the tribunal.
respondent number 3 before the
For the
tribunal
tribunal.
in MPC number.
In
in
both the
both
MPC.
232
both
and
the MPs.
55.
In both the.
Yes.
Yes.
The cost is paid, my lord, along with acknowledgement. I'll file it before the,
Yes,
before the
Lord.
registry, my lord.
My lord, one submission.
Yeah.
Delayed paid interest is not
Accepting
entitled.
accepting the reason assigned in the
In death case, my lord,
delay cantonment order sheet, accepting the reason assigned in the affidavit accompanying to the application, comma, the delay of how many days is that? 102, 10.
no, not 102, man, but 2000. Death case more than 4 years.
ಅದು ಕಂಡೋನ್ ಆಗಿದೆ ನಿನ್ನೆ. ಇದು ಯಾವ್ದ್ರಲ್ಲಿ ಸೆಕೆಂಡ್
In death case for not sir, more 4 years delay.
200 days.
No, that is not, that is the injury case, my lord.
Hmm.
Death case, it was dismissed. 4 years delay is there, more than 4 years.
Yesterday we already passed the order.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಬಂದ್ರೆ
Yesterday we already passed the order to that effect.
yes man,
By imposing some cost,
3,000.
and not entitled for interest ಅಂತ ಕೂಡ ಹೇಳಿ.
by excluding interest ಅಂತಲೇ ಮಾಡಿದ್ವಿ.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಬಂದ್ರೆ ತುಂಬಾಕಲ್ಕೆ ಕಂಪನಿ ಅವರಿಗೆ that will be convenient for them.
Yes, yes, yes. The appellate would not be, however, it's made clear that appellate would not be entitled to the interest for period from, that is, interest for the period. ಯಾವಾಗಿಂದ
2000
dismissal
ಎಷ್ಟಿದೆ
of
ನೋಡಿ.
the appeal till the restoration, dismissal of the appeal ಯಾವಾಗ ಅಂತ ನೋಡ್ಕೊಂಡು ಬಾ. Dismissal
ಅಲ್ಲ
of the
days ಇದೆ sir, they have mentioned days.
that period. That already order has
ಅಲ್ಲ
been
ಮೇನ್
passed.
ಇದ್ರಲ್ಲಿ ಬಂದ್ರೆ we are
ಬರ್ತದೆ,
exempt. Yes.
ಬರ್ತದೆ.
2911.
From 18/7, 16 till yesterday. Na? 22nd or 22/1/2025. Please. Here you are. Next matter. First matter ಅಲ್ಲಿ Aspali to Aspali the council purpose is directed to accept notice.
ಅಲ್ಲ
R2.
yes, I will take notice.
Huh?
Yes, yes. Yes.
ಬರೀತೇವೆ ಎಲ್ಲೋ
Yes.
ಇನ್ನೊಮ್ಮೆ ಬರೀತೇನೆ ಚೆಕ್ ಮಾಡಿ ಇನ್ನೊಮ್ಮೆ
ಹೇಳು.
ಬರೀತೇನೆ. ಆಯ್ತು.
57 ಹರ್ಷವರ್ಧನ್ ಹರಮಾಳಿಪಲ್ಲಿ.
As per the directions of this honorable court, I have sought the Akarband to ascertain about the Port Kharab classification.
But this is the case where, my lord, it was listed about.
Have you looked, they've served copy on you?
Yes, my lord, I also secured the Akarband, my lord, it shows, my lord, Kharab land.
Put it. So what is the classification of the?
It is the A Kharab. now.
A Kharab.
Yes,
A Kharab means private.
yes, it belongs to the, my lord, owner of the.
2 acre 5 guntas. Last page, my lord.
Yes.
Column number 5A.
Yes. So now tell us what.
Lord,
Now it's only on that point.
Yes, my lord. My lord, insofar as, my lord, determination is concerned, my lord, this court has already, my lord, passed an award in respect of, my lord, survey number 53, acquired under the same notification, same village. Present land is, my lord, survey number 56.
This MFA number is survey number?
In MFA, this MFA cross objection 2000073, lordship may kindly turn to, my lord, internal page 5, paragraph 10. The survey number involved in this case is, my lord, 53. Of Hadanur village acquired under notification, fourth line, my lord, 14/8/2007. Mine is, my lord, 56 survey number of the same village acquired under the same notification.
Yours is also irrigated land.
Irrigated land.
Huh?
Yes.
TCR.
They were classified and awarded same sorry.
Yes, it is irrigated land.
Yes, yes.
Do you have a copy of the RTC?
My lord, that's filed, my lord, as exhibit. It's part of the record. Exhibit
P11.
P11.
You have a copy?
Yes.
It shows irrigated land.
ಖುಷಿ ಅಂತ ಅದ್ರಲ್ಲಿ ಬರ್ದಿಲ್ಲ.
But that is not disputed. The classification and the award that is made is the same.
Award itself shows irrigated land.
Yes, yes.
It says Bavi antide.
Award passed is
ಇದು ಕಾಲಮ್ 8 ನಲ್ಲಿ ಬಾವಿ ಅಂತ ಇದೆ.
Lord, the judgment that I'm relying and the present case, the SLO treated both the lands as irrigated and awarded, Lord, 34,500 per acre.
Common award.
It was a common award. Same award was awarded. After reference, my lord, both the cases, same award was made. Now, my lord, they were in appeal. I was also in appeal. That, my lord, is enhanced from 6 lakhs and odd to 12 lakhs and odd. My case also, my lord, 6 lakhs is awarded. It has to, my lord, be considered for, my lord. And that award is, my lord, accepted by the state and they have disbursed the amount. Your lordships will get it, my lord, the awards on, my lord, second page of the judgment.
You give us a copy of, these are the exhibits.
Yes.
Exhibits. Now, award of the LAO is also enclosed.
Award, my lord, is, my lord, RCL.
Now, what is this project report?
That is, my lord, to show that he was growing, my lord, irrigated crops of banana and your lordships will get the award of the SLO from the judgment itself.
Paragraph?
Paragraph 1 on the second page, my lord, page number 2 of the reference court judgment. First line, my lord, shows the land for which it was acquired. Notification is 14/8/2007 and passed an award of 34,500 per acre.
Yes.
Lord, your lordship kindly turn to, my lord, the reference court announcement that is on internal page 15, operative portion, 6,14,700. Page, internal page 15 of the judgment, running page 20, my lord.
Yes.
6,14,700 per acre.
Yes.
The operative portion, third
Yes.
line. Now, your lordship may kindly turn to the judgment which I am relying, the cross objection judgment.
Yes.
Here, my lord, your lordship may turn to page 3.
Yes.
Or else, my lord, I'll read from page 2, my lord, paragraph 3. The respondent has acquired the land of the cross objector under for the formation of tank on 14/8/2007. Notification is awarding a sum of rupees 34,500. This case also, my lord, the land had the same value per acre as compensation being agreed by so and so. It was the reference court, after hearing the parties, has enhanced the compensation from 34,500 per acre to 6,14,700 per acre.
So now, except for the Kharab,
Yes, my
it was
lord,
excluded.
that's my lord, is my lord the dispute. Here, my lord,
So in
10,
the order of the reference court, where is the finding regarding Kharab? Paragraph 19.
yes.
Huh?
Paragraph,
19.
yes.
Read.
Here the claimant has also relied on so and so, as per clause G of KLR Act so and so. Port Khara, Bombay Land Revenue Code, Port Khara meaning and right flowing from such land held. Kharab land is so called because it is not cultivable and is a classification made for the purpose of revenue exemption. Port Kharab is also capable of ownership and cannot be regarded as an adjunct to civil cultivation land, which gets transferred after along with the cultivable land. Acquisition of title of Kharab land is similar to the acquisition of title to the cultivable land. Therefore, the Port Kharab having reference to a land which is included in a assessed survey number. So here, as a principle adopted by the Honorable High Court in the above reported decision, claimant
How
is
did
also
the
entitled
court take?
to compensation of
How
2,000.
did they take 2,000?
Not that's not. There is no basis for my lord either 2,000.
It should be the same.
Same award.
Ah.
My lord, my first line of argument was that, my lord, it's not a Port Kharab, it was a cultivated land. For that, my lord, I had given evidence. I've also, my lord, placed evidence of the village accountant. Even otherwise also, if
Village
say-
accountant.
Yes.
That is
He is, my lord, PW.
PW.
So on LCR page number B3, he is PW3, my lord, one Tulajappa, who was the then, my lord, retired revenue inspector for that village, my lord, during the relevant year.
We don't have copy of the TCR. If you have, you give your evidence.
Yes.
You have, is it?
Yes, my lord.
He has stated that
It was put to, my lord, cultivation. In fact, my lord, the ROR also showed 1 acre 20 guntas as Port Kharab land, not 2 acres and odd guntas. He said, my lord, entire land was put to cultivation. Even otherwise, my lord, a cultivation land, my lord, it has to be, my lord, the owner's land and compensation has to be, my lord.
there's one judgment.
There's one circular and judgment, my lord, which I had produced, my lord. I think it's part of the record. Circular dated, my lord, 8th December 1970.
One judgment of Justice Sanjay Gowda last year, I think.
Yes.
Justice Sanjay Gowda on the revenue side.
Yes.
Stating that Kharab, just check if it is there, get it tomorrow. Check once in which A, B, unclassified has been dealt with. I vaguely remember.
Yes, but I have produced certain judgments. They are also not on the same line.
Okay. Yes.
This circular itself, my lord,
point out.
A question has been raised as to how the lands assessed as Port Kharab should be disposed of. Port Kharab lands are classified into 2 categories. So and so lands coming under category B, they are those reserved for the various public and other purposes cited therein, as are obviously not intended for disposal. Port Kharab lands defined under 21(2)(a) are those classified as unfit for agriculture at the time of survey, including the farm building or trash floor or of the holder, trash floor of the holder. As clarified by the law department, all Port Kharab lands which form part of a holding on which have not been reserved for government or assigned for any public purpose or for any purpose sanctioned in Rule 21(2)(b) of the Mysore Land Revenue Rules belongs to the owner of the survey number and not to the government.
So all that which is not reserved for the government belongs to the owner.
So the categories falling under B Kharab, if it is a B
So
Kharab
it's
land,
only reserved.
they are reserved, my lord, for public purposes, Nala and roads, my lord, and they belong to the government. A classified lands belong to the, my lord, owner of the land. And my lord, there is one judgment of 1986 where they specifically, my lord, page 22, my lord, the running page 20.
Yes, which is the judgment?
Lord, I'll go to the division bench judgment, my lord. It starts at page 22, my lord, running page 22, ink page.
Yes.
The relevant portion is at, my lord, page 31, paragraph 14. Running page 21, my lord, left hand.
Yes.
Survey was, lordship's got it, my lord. Survey was first introduced in the last century. We are informed at the bar that though the government intended to resurvey, there was only reclassification of land and fresh amounts of assessment. But there does not appear to be any resurvey conducted as per the provisions of Land Revenue Code. Therefore, to classify the land at this distinct distance of time on the basis of assessment levied on the land nearly a century ago may result in a mockery of justice. The world has been changing so fast and the techniques of agriculture has been changing so fast that it is not appropriate to determine the fertility of the land with respect to assessment levied in the last century and which might have been raised recently on account of reclassification. Therefore, the argument of so and so that the lands acquired should be classified as good, medium, or inferior only on the basis of assessment levied on them does not appeal to us in the least. We think it rather unsafe and not proper to classify the land in different categories only on the basis of assessment. This exemption, my lord, Port Kharab was classified only to seek, my lord, revenue exemptions.
Yes.
But same award could be made. Same award could be made, my lord, for the entire.
Tomorrow. I'll dictate it
Now,
tomorrow.
my lord, 10 acres, my lord, admittedly is, my lord, irrigated and, my lord, it is granted 6 lakhs. It is, the issue is only in respect of 2 acre, 5 guntas. My lord, all 12 acre, 5 guntas, my lord.
I'll have it tomorrow.
Like,
Just look at
I'll try to get that.
Justice Sanjay Gowda's last year.
I'll try.
Specifically on this, though in the context of revenue.
Right.
I think some grant land is.
Oh, I'll try to get that.
Release
No,
tomorrow.
learned jet single, my lord,
Single.
or like
Release tomorrow. Mail barle adene admission na then hostage. Yes.
memo could be taken. His memo could be taken on record.
Yes.
The Akarban
The AGA files, copy of Akarban along with memo, same is taken on record.
Please.
Yes.
Like.
Next.
Number 28. Katlur Satyanarayana Church.
Yes, settlement. Also, next.
39. Shivakumar Malipati.
Only for recalling the order.
Dismissed for?
This is for non-compliance.
Yes, who appears? The Counsel for the petitioner has filed A2 of 23 seeking recalling of the order of dismissal dated 20th February 2023. The present petition came to be dismissed in light of non-compliance of office objections within the time granted. It is submitted that subsequently petitioners complied with all office objections, and the office note to that effect is also mentions compliance of office objection. Accepting cause shown, the IA 2 of 23 is allowed, and order of dismissal dated so and so recalled, and petition is restored. Adikinta munche IA 1 of 23 is allowed, accepting cause shown, and delay in filing application to recall order of dismissal is also allowed. Relist the matter on.
A small matter, sir. Only difference of amount. The period for which he has worked as a temporary measure that has not been included in the service benefits while granting pension. Earlier, he was worked as for about 1.5 years as a temporary work in the same. Later on, he was appointed by the PSC government. There, the government rules they have passed that the person who has worked certain period as a time that may be considered while fixing the pension ಅಂತ. ಅದೊಂದು consider ಮಾಡಿಲ್ಲ ಅಂತ.
Just
Any
complete
date
the
when-
instructions next week.
Please.
Relist the matter on date code. Yes, next.
31, each anyone?
Kindly,
Yes.
kindly pass over, your lordships. I have lost the file somewhere.
Pass over.
32. Hema L. Kulkarni.
Here for CD may be considered.
IA 2 of 24 is allowed, accepting cause shown, and delay in filing the appeal is condoned. Yes,
Matter may be.
we'll have it some, huh?
Matter may be admitted, madam.
Yen writ appeal yen admit, noted. Relist the matter, date code. Next.
33, Vishal Pratap Singh.
Extension of, daily huh? Pass over, next.
Serial number 34, Government Advocate. 32 I appeal.
32. Yeah, Lord. Senior counsel is engaged and he has come, my lord. Kindly it may be taken.
Which matter?
32 minutes.
Just wait, we are passing.
Please.
Yes.
Government Advocate.
34 it will be taken 230, madam. EAG Archana madam is appearing in this matter.
Pass over.
Serial number 35, Hema L. Kulkarni.
Yes.
I am for the respondent.
Yeah. I had requested for one-time settlement, my lords. They had made excess of 5 lakhs. If they could come for some settlement, I am ready to pay the amount. And that was my submission.
You have to go
Therefore,
to them.
yes.
They will not come.
No, they are all both.
As
in the
regards
directive
one,
place.
as regards one-time settlement is concerned, my lords, these are all cooperative bank, my lords. Unless there is a permission from the RBI, we cannot, my lords, invoke one-time settlement, my lords. But it's a overdraft loan, my lords. Lords, they did not renew it, my lords. Balance was 40 lakhs. Lords, interest and all, as on today, my lords, may I pass the account details?
Put it.
OD limit was 40 lakhs, my lords.
No, so how do you propose to settle?
Lords, the-
What
my
I say, my
instructions are,
Yes. Yes.
my instructions are, my lords, if they file affidavit, lords, the 3 months, my lords, I convinced bank they can take 3 months' time and pay the balance.
Any waiver of some interest?
Lords, I am told that, my lords, penalty interest can be waived, my lords.
Penal interest.
Penal interest can be waived subject to, my lords, board decision. I will take, my lords. As regards board decision is concerned, my lords, I will convince them to waive the penal interest.
I'll convey. I'll convey and I'll calculate how much the penal interest is coming, and then I'll give an affidavit saying that I'll be paying the entire, clearing the entire amount at the end of 4th month. I'll pay the entire amount.
Fourth.
Next week, let us see, you must give at least 30 days time. The power to extend. We'll see.
My lords,
Officer,
meanwhile-
branch manager is present, my lords. If their
Yes.
party is present, we can kindly have it 2:30, my lords. We will.
Okay, let us,
Please, my lords.
pass over.
Please.
Only one request is that, my lord, because there is no interim order, they are proceeding with the further proceedings.
I'll ask
Now
them.
see what can be done.
Form
We'll
number 10.
put an end to it. Yes.
Delay of 25 days, my lord. I also sought for interim order of stay, my lord.
A1 of 25 is allowed. Accepting cause shown and delay in filing the appeal is condoned. You are the
I am appellant defendant, my lord, owner of the property, my lord.
owner.
Suit is declared, my lord.
Huh.
Suit property, my lord, measures 22 into 40. But whereas suit is declared only with regard to part of the property. Suit for specific performance.
What do you call it? RFA file. In the previous matter. So now the order
I
passed
sought for
is,
interim order of stay, my lord.
oh no, the judgment is decreed.
Decreed, my lord.
To
My lord, the
execute.
facts of the case are that
Hmm.
on 26/10/2015, the present appellant defendant, my lord, agreed to sell the property. It is open site measuring 22 into 40 feet, my lord. And by that time, there was no any acquisition proceedings. So, my lord, this is one of the recitals in the agreement that the purchaser has to, defendant has to pay a sum of rupees. He paid 10,000 rupees and balance amount, my lord, of 25 lakhs is agreed to be paid within 3 months. So readiness and willingness section 16C is not complied. And moreover, my lord, I request your lordship that no acquisition proceedings were initiated till the date of filing of the suit and even thereafter also. But he produced a map, my lord.
Anyhow,
Produced
it's
the
an
copy of the
appeal.
plan.
Anyhow, it's an appeal. We'll have to hear. We'll admit it. IA 2 of 25 has been filed. Seeking stay of the judgment and degree. Taking note of the amendments made in the application and submissions, considering suit for specific performance has been decreed, which is challenged by the owner. In light of the contentions raised, it would be appropriate to stay the judgment and decree of the trial court in OS 84 of 2017. Appeal is admitted. Paper book to be filed. This the matter.
Stay.
6 weeks. This the matter in final hearing in due course. Yes, next.
Oblige.
Yes.
Lord, this is a case where the petitioner appellant before your lordships had sought for issuance of khata from the newly formed panchayat, that is the town municipal council now. Earlier, an endorsement was issued to the petitioner stating that this land would come within the purview of the archaeological department and therefore an NOC from that department is required. That was specifically challenged and the learned single judge had set aside such an. My lords will find that earlier endorsement at annexure T, page 106.
Page 10.
106.
Yes.
This was the endorsement earlier issued by the town municipal council on 15/3/2019, where my lords will see in the last paragraph at page 106. Since the applicant did not obtain NOC from the archaeological department, which is mandatory, whereas land survey number 401 bar 5 comes under the protected area, Archaeological Department from the official memorandum, government notification, Archaeological Department's letter came to know that land survey number 401 bar 5, 2 acres 7 guntas is near excavation, comes under the area of Ashoka's inscription and ancient monument at Musky town, Musky. Hence, obtaining NOC is mandatory to the applicant to get the plan approval by the TMC Musky. Now, this was challenged
Just
before.
1 minute. Now, for the time being, you are seeking stay of para 18.
Yes,
And will issue notice, let them come.
great,
Yeah.
great.
Then senior counsel appearing on behalf of the appellant submits that the position of cost of rupees 25,000 may be stayed and notice be issued, and other matters may be considered on merits after notice to the respondents. In light of the submissions made, the observations made at para 18 in the part of the learned single judge is stayed. Issue notice, AGA accepts, GA accepts notice for respondent number 1.
And Miss Srimati Niva M. Chimkod, who had appeared before the.
Is directed to accept notice for respondent number 2 as the said counsel represented the authority before the learned single judge.
Great.
Deal with the matter week after next. Yes. Yes, government.
13 है
We had made some direction to the government to take a stand whether notice for petitioners put on notice. Okay, we'll have it next. We want that. Till that information comes, it's difficult.
Please.
The government to take note and comply with the direction of 9/1/2025. Relist the matter on date good. 13. Next.
Appear for respondent. There is direction by this court, my lord, so to keep the parties present. Respondent is present. So I am informed that appellant, my lord, so due to some personal inconvenience, he is not present today. Lordship may accommodate any other date, my lord, sir.
But you get a date when both will be present.
Yes, my lord, sir.
You contact him telephonically.
I have contacted the appellant as well as, my lord, I got to know it from the appellant counsel in the morning session.
Okay, so now
that appellant has.
We'll adjourn it.
Yes, my lord.
Date, you give it in a chit to the court officer.
Okay, please.
After consulting your colleague.
Please, my lord, sir.
Huh?
Yes, my lord.
Relist the matter on. The respondent is present.
Yes.
And the presence is taken note of.
Please, oblige.
Relist on. You give the date.
Please.
Yes, next.
41. In the
List. Week after next. Next.
serial number 42. SS Mamadapur.
To appear for the.
Kindly pass on 230.
230, we have too many matters. Criminal appeal, we, as a matter of principle, what we are following is 230, we are going to take criminal appeal. Except for small submissions, we are not going to take other matters. So this may not be possible. We'll have it on some other day. Relist on date.
Next week.
ಇಲ್ಲ
sir, liability matter, sir.
ಲೋಕ ಅದಾಲತ್ ಕಳಿಸಿ.
Liability, sir.
Liability-
Insurance company and ಎರಡು ಇದೆ, sir. Like claimants appeal, insurance appeal, both is there.
ಲೈಬಿಲಿಟಿ ಎಲ್ಲ ಕವರ್ ಆಗಿದೆ. ಇನ್ನೂ ಹೊಸ ಕ್ಯಾಟಗರಿ ಲೈಬಿಲಿಟಿ.
They claim that this vehicle was not involved in the accident on the basis of medical.
Let us.
Next week, one date.
Relist on. Yes, next.
Serial number 46. Sachin M. Mahajan.
In the LCR ಬಂದಿದೆ.
Any settlement possible, we can send it to Lok Adalat.
My lord.
Any settlement possible, we can send it to Lok Adalat.
It's a case of injury, probably, my lord, they will not come forward.
Not.
again. They will not.
You will have it on some other day. It's relist on.
11.
11, there is some personal, Salpam. Next week, if it is possible.
No. Court officer has no dates. So I cannot direct the court officer to give
That
dates.
is, 11, there is some personal inconvenience, my
So
lord.
after that,
13.
next.
Please.
Number 40. 5.
Lords, appearing for the appellant, my lords.
Lord, I am for respondent
My lords.
in
This is a corporation appeal, my lord, only quantum, my lords. The deceased was bachelor, my lords, 50% has to be deducted, but instead of that, 1/3 has been deducted. And interest 9% has been awarded, 6%,
Only 2 points.
2 points.
I am for cross objector in this. Lord, actually, he is the only bed earner in the family.
Correct, eh? So on what ground you tell us? You want enhancement on what ground?
My lord, future prospect is to be 50%, my lord. Whereas 40% has been considered.
40.
You're working as?
Working as, he's a officer in HDFC, my lord. Under contractor, my lord.
Age within that?
26, my lord.
26 years.
26 years, my lord. And
50%.
his parents and
You both sit,
Yes.
and make a common, those 2 grounds, and he's saying for future prospect because of the age and employment.
Yes.
Make one common calculation.
No, my lord, trial court has,
my lord,
trial court has rightly given 40% added, my lord, future prospectus. Now he wants 50%, my lord. That is on permanent government job, or 50 is there, my lord.
50 need.
Permanent employees, my lord. Permanent employees, that is
My lord,
50%.
he is the only bed earner.
What is the work he's doing in a bank?
HDFC, he tells amount recovery section, my lords. Recovery,
Only
What is your job?
job is recovery agent. my lord.
recovery agent.
I was into recovery, this
Is
thing,
it contractual or permanent?
based on contractual. My lord, basically, his parents are depend on him, my lord.
No,
He's the
correct.
bed earner.
We have a sympathies with you, but there is some difficulty. Now you give one memo of calculation. We may not be able to increase the. You give calculation.
My lord, also other heads is a minimum.
You tell us what heads, no?
My lord,
You put it in the calculation.
yeah, please.
No.
Yes, Mr. Shanabasappa.
Yes,
ಏನಂತ ಕೇಳ್ಕೊಂಡು memo.
yes, ma'am.
If it is there, it is there.
Please,
Please, ma'am.
Going to dismiss their appeal. ಅವ್ರದ್ರಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಂತ ನೋಡಿ.
yes, ma'am.
Huh?
Yes, ma'am.
Please, ma'am.
Next.
Number
Yes.
46. RV Nadagowda.
My lord, the appellant has been convicted for the offense punishable under section 364, 392.
Objections hacked.
ಇಲ್ಲ sir, fresh ಇದೆ.
The objections are clear.
It's 1 week. 1 week time. Please.
Yes, next.
Number 47. Kojalagi Chandrakant.
Yes, I filed in the Manatee and Guardian Act. Sale of property, 4 acre, I am asking the 2 acre is granted trial court. So kindly we will 2 acre and under granted. 4 ಎಕರೆ ಕೇಳಿದ್ವಿ ನಾವು 10 ಎಕರೆದಲ್ಲಿ 4 ಎಕರೆ 2 ಎಕರೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಇನ್ನೂ 2 ಎಕರೆ ನಮಗೆ ಬೇಕು ಫಾರ್ ಮ್ಯಾರೇಜ್ ಅಂಡ್ ಎಜುಕೇಶನ್ ಪರ್ಪಸ್.
Why is the government made a party?
ಅಂದ್ರೆ DC ಪವರ್ ಇದೆ ಅಂತ ಸರ್, ಮೈನರ್ ಗಾರ್ಡಿಯನ್ ಆಕ್ಟ್ ಒಳಗೆ ಈ DC ಪವರ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ರು.
G is directed to accept notice for that.
ಅಲ್ಲಿ ಅವರು ಇದು ಕಾಪಿ ಸರ್ ಮಾಡಿ
ತಗೊಳ್ಳಿ ಅವ್ರದ್ದು ಏನಂತ ವ್ಯೂ ಹೇಳಿ.
Week after next date.
ಅಲ್ಲ ನಾ ಮಂಡೇ ಇಟ್ಬಿಟ್ಟು ಸರ್
ಡೇಟ್ ಕೊಡ್ತೀವಿ. Good. Next.
12-2.
For 48, Ganesh Kalaburagi.
Yes,
It's
you are
a
the,
first appeal,
you
suit
are-
for specific performance is decreed.
you are the owner.
The owner defendant in the suit.
What was your defense?
The defense was it's a security document, and earlier also with the same party, there was an agreement registered and cancelled also for the purpose of loan.
Light of
And-
the contention raised. The learned senior counsel appearing for the appellant that the trial court ought not to have decreed the suit as the agreement was one of security for a loan.
Loan obtained.
Loan. Taking note of the decree of the decreeing of the suit, there would be stay of judgment and decree passed in OS so and so. PCR to be summoned. Appeal is admitted. Paper books to be filed within 6 weeks.
I will have to mention this, my lord. Through a court commissioner, a sale deed is executed, but possession is not taken. Therefore, that stay would be valid.
No, 1 minute, we'll modify it then. So, again, but the stay of judge, instead of stay of judgment and decree,
Stay of the execution, further proceedings in execution.
stay of execution further execution proceedings in execution number
Number
so
59 of 2024, I will write it.
next.
Great.
Bill filed by the insurance company, corporation, not challenging negligency point, but 50% I will deposit. I sought first.
So and so is directly. Yaro, issue notice,
House.
issue notice to respondent. Operation and execution for the reason assigned in the affidavit.
Please.
Affidavit accompanied to IA number 1 of 2025. The operation and execution of the impugned award, impugned judgment and award is hereby stayed subject to appellate depositing 50% of the award amount before this quarter, before
Please.
this court within 4 weeks.
Please.
Is the director security trial court.
J.M. Joshi.
Withdraw it, means 230 I will buy.
Huh?
The ಎರಡೂವರೆ ನಾವು withdraw ಮಾಡ್ಕೊತೀವಿ. Already ಅದು ಮಾಡಿ.
Withdraw.
230 ನಾ ಮಾಡ್ತೀನಿ.
230.
Bill number 51,
Yes,
government advocate.
List week after next week.
Hema Kulkarni.
Yes, we'll take it on some other day,
Please, ma'am.
week after next,
Bill number 53, Kuleppa Heru.
week after next.
Kuleppa
Same. 53, 50 or pass over, not a. 53, 50 or pass over.
Senior. Sir, Joyce. Sir, ಅದು 230ಗೆ ಇದು ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ತಗೊಳ್ಳೋದು ಹಿಯರಿಂಗ್ ತಗೊಳ್ಳಲ್ಲ ಅನ್ಸುತ್ತೆ. ಹಿಯರಿಂಗ್ ತಗೊಳ್ಳಲ್ಲ ತಗೊಳ್ಳಲ್ಲ. ಹಾ ಸರ್. ಅಂದ್ರೆ ನಿನ್ನೆ ಒಂದು ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಪಾರ್ಟೆಡ್ ಆಗಿದೆ ಸರ್. ನಿಮ್ಗೆ ಯಾವಾಗ ಬೇಕು ಹೇಳಿ ಸರ್? ಅಂದ್ರೆ 6th ಮೇಲೆ ಕೊಡೋಕೆ ಹೇಳಿದ್ದಾರೆ ಸರ್, ಫೆಬ್ರವರಿ ಅಂದ್ರೆ ಅಲ್ಲಿ 10th 11th ಸರ್.
ನೀವು ಆನ್ಲೈನ್ ಮಾಡ್ಬಿಟ್ರಿ ಸರ್, ಮತ್ತೆ ಆನ್ಲೈನ್ ಮಾಡ್ಬಿಟ್ರಿ, ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀನಿ ನಾನು. ಐ ವಿಲ್ ವಿಡ್ರಾ ಆಲ್ ಪರ್ಸನಲ್ ಅಲಿಗೇಷನ್ ಅಗೇನ್ಸ್ಟ್ ದ ಅಪೆಲೆಂಟ್.
ಮೊದ್ಲೇ
ಇರ್ಲಿ, ನಾ ಇಲ್ಲಿ ಇರ್ತೀನಿ ಸರ್,
10 to
ನಾ ಇಲ್ಲಿ ಇರ್ತೀನಿ.
still number 32.
ಹೌದ್ರಿ.
ಆಲ್ರೆಡಿ ಆಗಿತ್ತು ಸರ್.
ಅದೇ ಅಂದಿ ನೀವ್ ಬರ್ಲಿಕ್ಕೆ ಹೋದ್ರ ಅಂತ ಹೇಳಿ.
ನೀವು ಪಾಠ
ಎಲ್ಲಿ ನೀವು ಆನ್ಲೈನ್ ಬರ್ರಿ. ಪರ್ಸನಲ್ ಅಪ್ಲಿಕೇಶನ್ ವಿಡ್ರಾ
10 to 11 to ನೀವು ಯಾವಾಗ ಹೇಳ್ತೀರೋ ಅವಾಗ ಕೊಡಿ.
ಸರ್ ನೀವು 10 to 11 to
ಯಾವ್ದಾರು ಕೊಡಮ್ಮ.
11th ಇರ್ಲ ಸರ್. 10th ಮಂಡೇ ಇದೆ.
ಮಂಡೇ ಇದೆ, 11th ಇಟ್ಬಿಡ್ರಿ.
10th ಇಲ್ಲ.
ಅಲ್ಲ 10th ಅಂದ್ರೆ ಒಮ್ಮೆ ಫ್ಲೈಟ್ ಲೇಟ್ ಅಲ್ಲ ಸರ್. ಅಲ್ಲ ಸರ್, ಅದು ಒಮ್ಮೆ ಮಂಡೇ ಅಂದ್ರೆ ಸ್ವಲ್ಪ ಲೇಟ್ ಆಗ್ತದೆ. ನಮ್ ಫ್ಲೈಟ್ ಲೇಟ್ ಬಂತಂದ್ರ
ಯಾವುದು
ಮಂಡೇ ಮಟ್ ಇದು ಟ್ಯೂಸ್ಡೇ ತೋರಿ. ಅಲ್ಲ ಫ್ಲೈಟ್ ಲೇಟ್ ಅಂದ್ರೆ ಇವ್ರದ್ದು ಸೈಬರ್ ಫ್ಲೈಟ್ ಅವ್ರು 11:30 ಬರ್ತಾರೆ, ರೀಚ್ ಆಗ್ತದೆ ಇಲ್ಲ.
ನನ್ನ ಚೇಂಬರ್ ಕೂತ್ಕೊಂಡು ಮಾಡಕ್ ನಂಗೇನ್ ಕಷ್ಟ.
ಅಲ್ಲ ಅವ್ರು ರೀಚ್ ಆಗ್ತಿಲ್ಲ ಅಂತ ಮತ್ತೆ 11th ಇಟ್ಕೊಂಡ್ರೆ ಇಲ್ಲೇ ಇರ್ತಾರ.
ನಡೆಯಲ್ಲ ಅಂತ ಆಯ್ತದ.
ಹೌದು.
ಥ್ಯಾಂಕ್ಸ್ ಟು ಯು.
ಅಲ್ಲ ಬೇಕಾದ್ರೆ ಮೇಡಮ್ 11th ಬಿಡ್ತಾರೆ ನೋಡಿ, ಫ್ಲೈಟ್ ಅದು ಲೇಟ್ ಆಗ್ತದೆ ಮತ್ತೆ 11th.
ನನ್ನ ಪ್ರಾಬ್ಲಮ್ ಏನಿದೆ 12th
ಹೌದಾ 11th ಇಡ್ರಿ ಸರ್. ಅದೇನು 5 minutes ಕೇಸ್. ಅದೇನು ಮತ್ತೆ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರೆ ಹೇಮಾ ಮೇಡಮ್
ನಿಮಗೆ ಸೀನಿಯರ್ ಹೇಳ್ಬಿಡಿ.
39. 31.
1, 2, 30.
ಅವ್ನು ತಕೊಂಡ್ರೆ 53.
Sir, court officer? Court officer ಇದೀರಾ? ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 31 ಏನಾದ್ರು ಆಗೋಗಿದ್ಯಾ ಮುಗ್ದೋಗಿದ್ಯಾ? ಯಾಕೆಂದ್ರೆ 53 ಅಂತ ಈಗ ಬಂತು, ಬೆಳಿಗ್ಗೆಯಿಂದ 16 ಇತ್ತು. ಈಗ ನಾನು ಬೆಂಗಳೂರಿಂದ ಇದಕ್ಕೆ
31 ಫಸ್ಟ್ ಡೋರ್ ಇದೆ.
ಫಸ್ಟ್ ಡೋರ್ ಇದೆಯಾ? ಓಕೆ ಮೇಡಮ್. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
Yes.
That's the first one.
Remember? Counsel for the petitioner. Has filed the memo in light of the same.
Pastor Madam. Number 20.
I'm ready, my lord, for hearing. I verified all the files.
Huh?
I verified the records, my lord. I'm ready, my lord.
We will have it. Tomorrow be ready in the morning session itself. We'll take it. Tomorrow,
Instead of tomorrow, my lord, we'll also Monday, my lord.
Monday. Right?
Records is not already taken the copies of.
My lord.
Well, ಆಯ್ತು. Get ready.
We'll keep.
ಅಲ್ಲ Saturday working day ಇದೆ, my lord.
Huh?
Saturday working day ಇದೆ. Even
ನಮ್ ಬೇರೆ ಕೆಲಸನೂ ಇರುತ್ತಲ್ಲ. ಬೇರೆ we are keeping Saturday for either Bangalore matters, part heard, ಅದು ಇದು. We will have it on Monday.
Please.
Monday. Now you have got photos of whatever page you want, you have got, isn't it?
my lord, I have a good case on merits, my lord.
We'll hear.
Already they have no motion is made, my lord. If today I succeed, my lord, 26th January ಇದೆ ಅಧ್ಯಕ್ಷ ಮತ್ತು ಅವರು ಮುಂದಿನ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅದು ಲೈಕ್ ಮಾಡ್ತಾರೆ. ಅಧ್ಯಕ್ಷ ಈಗ ಅವ್ರು ನೋ ಮೋಷನ್ ಮಾಡಿಂದ ಅವ್ರಿಗೆ ಏನು ರೈಟ್ಸ್ ಇಲ್ಲ. ಸಬ್ಜೆಕ್ಟ್ ರೆಕಾರ್ಡ್ ಆಗಿದೆ, ರಿಸಲ್ಟ್ ಆಗಿದೆ. ಇಫ್ ಐ ಟುಡೇ ಐ ವಿನ್ ದ ಮ್ಯಾಟರ್, ಟುಮಾರೋ ದ ಪ್ರೆಸಿಡೆಂಟ್ ಮೇ ಅಲ್ಲಿ ಫ್ಲಾಗ್ ಹೋಸ್ಟಿಂಗ್ ಮಾಡ್ಬೋದು ಅವರು. We need the order, my lord. If I have a merit, my lord, my status it abate, my lord.
But no confidence.
If I have good case, your lordship may allow the case. Otherwise, dismiss the case.
Maybe heard on merit, your lordship. The only contention which they have taken before the learned single judge is with regard to your lordships.
Because of no motion, my lord.
Not for this. ಇದೇನ್ ಸ್ಟೇಟಸ್ ಅಲ್ಲ.
ಇರ್ಲಿ ಅಧ್ಯಕ್ಷರಿದ್ದಾರೆ, ಅವ್ರು ನೋ ಮೋಷನ್ ಅಂತೇಳಿ ಮನೇಲಿ ಕೊಡಿಸ್ಬಿಟ್ರೆ ಅವ್ರಿಗೆ ಪಾಪ
ಏನಲ್ಲ. ಇದೆಲ್ಲ ಈಗೋ ಇಶ್ಯೂ ಅಲ್ಲ.
ಅಷ್ಟೇ.
ನಿಮ್ಮ ಅವ್ರ ಕಣ್ಣಲ್ಲಿ ಏನೋ ಈಗೋ ಇಶ್ಯೂ ಇರ್ಬೋದು. in our eyes, it's only a matter of law. We'll have it on Monday.
Lord, at least till passing any further orders, further proceedings may be stayed, my lord.
Orally,
ಅವರೇ ಟೈಮ್ ತಗೋತಿದ್ದಾರೆ, my lord.
orally, Mallikarjun is telling us that it's not possible to issue notification.
ಅಲ್ಲ, orally agree, my lord. I wait for the period, my lord. Even for 1 month, I will wait.
No. Why?
ಅಲ್ಲ,
If something happens, you move immediately, I'll stay. Monday.
Tomorrow, my lord, tomorrow, now I am ready, my lord, tomorrow. Otherwise, the interim order may be, no further action to
Your
be taken.
lordships,
ಇಲ್ಲ, ಈಗೇನಾಗುತ್ತೆ, ಅವ್ರು ಫರ್ದರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಮಾಡ್ಬಿಟ್ರು, ಹಾಗೆ ಉಳಿತಂದ್ರೆ
ಏನಾದ್ರು ಮಾಡಿದ್ರೆ
ಅಲ್ಲ, ಒಂದು ತಾವೊಂದು ನೋಟ್ ಹಾಕಿದ್ರೆ ಸ್ಟೇಟಸ್ ಕೋ ಆದ್ರೆ ಪಾಸ್ ಮಾಡಿದ್ರೆ.
No interim order. We'll have it on Monday. If the government passes, we'll see what is to be done.
Please.
Nothing
ಇಲ್ಲ,
will
ಅವ್ರಿಗೆ
happen.
ಅಟ್ಲೀಸ್ಟ್ ಡೈರೆಕ್ಷನ್ ಅದು ಏನು ಮಾಡಬೇಡಿ ಅಂತ ತಿಳಿಸ್ಬೋದಲ್ಲ.
ಮಲ್ಲಿಕಾರ್ಜುನ್ ಹೇಳಿದಾರಲ್ಲ, ಏನು ಆಗಲ್ಲ ಅಂತ.
2 days ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ?
ಪ್ಲೀಸ್.
ಕಡ್ಲೂರ್ ಸತ್ಯನಾರಾಯಣಾಚಾರ್.
Time come up with a proposal to give one building, entire building complex. And that was not accepted, and we also increased by another 5 acres of land.
Settlement.
Ismail.
Negotiations failed, my lord.
Failed.
What has happened is we have proposed it and they have rejected. My party is always, last time also he was present. If the respondent comes and one can find out something, what is her name? She is giving a list of list. We are ready to give entire complex, having a 30 by 80 conference hall and 14 shops and 5 acres of land. I increased again 5 acres of land.
What is your stand?
Their stand is, my lord, daughter was sent for, my lord, higher studies, which incurred, my lord, 30 lakhs as an expenditure.
30 lakhs.
30 lakhs. His loan is availed through the bank.
Yes. Then
half of the land. 30 acres land, my lord, they want half land, half of the land, 15 acres.
Which land?
My lord,
Survey
survey
number
number
three.
3.
Survey number 3.
My lord, then my lord, towards wedding, my lord, the expenses of a daughter, my lord, some, they have quoted some amount, but it could, I would like to, my lord, leave it to the discretion of the court.
Then
Then, my lord, towards alimony, she is demanding 50 lakhs.
50 lakhs alimony. So this is their counter offer.
Earlier, we had offered 30,000 alimony, 10 acres of land to daughter, and we had taken the responsibility of entire loan, the education loan. We were ready to discharge that education loan. That was not accepted. And also the purchasers had offered to give 8 lakhs each. That was not accepted. Then we came
That
with
we have agreed.
another proposal to give the entire complex with more than 4 crores worth, and also 5 acres of land. Now that is also not accepted. They are coming with another proposal.
You know, the examine ಮಾಡಿ ಇಲ್ಲಾಂದ್ರೆ merits ಮೇಲೆ ಮಾಡೋದು.
That's what my submission is. If the party is asked to come down, then we can have fourteenth.
On
14th.
14th of February. Both parties,
Function is.
both sides to keep their party present. Parties.
Yes, ma'am.
Yes.
P. Srinivas.
I appear for appellant in this case, my lord.
Appearing
My
for
lord,
the
I appear for appellant in this case.
Yes.
appearing for the
Right.
respondents, I had sought passover because I had brought the file, but someone has by mistakenly taken the file from here, your lordships. The file is not found in the court hall.
We'll have it tomorrow.
A week's time may be granted. If the file is not found, I can at least take the copies of the file from learned counsel for the appellant, your lordships. I will file objection to the.
Already a stay, is it?
Already there is a stay, my lord. There is a stay. I have subject to that, my lord. I have also deposited the amount, my lord, 30% amount. Acknowledgement also I have produced, my lord.
We'll have it next week.
Please, your lordships. Meanwhile, I will file the objections for the.
My lord, not on 28th and 29th, my lord, because I will be out of station, my lord.
Yes, yes, yes. Week after next.
Any date may be given?
Date good. After 10. 11th of February. Meanwhile, if there's any possibility of settlement, you have a look at it, both of you.
Obliged.
Vishal Pratap Singh.
Much obliged.
Filed an objection.
Objection is filed, minutes. In this case, minutes, the case of the prosecution is that this appellant, a young man of hardly 23 years, is working in a dhaba as a server. Apparently, it happened that the deceased, Muhammad Ismail, who is aged about 48 years, minutes, had asked for a sum of rupees 200 rupees in the morning. And in the night time, when this boy asks him to return the money, prosecution says that he refused to return and he used a very, very abusive language to the bringing her mother in the picture of the scene.
Yes, yes, PP.
Yes, my lord. The
Same.
PW3, when the, in page number 20, he has supported the case of the prosecution. And thereafter in the cross-examination, my lords,
Cross examination, he turned hostile.
hostile, but
Hmm.
eliciting some things from the cross-examination is different, my lords. But the person who is said to be the eyewitness to the incident, and he himself has turned hostile that ನಾನು ಹೇಳಿದ್ ಮೊದಲು ಹೇಳಿದ್ ತಪ್ಪು ಈಗ ಹೇಳಿದ್.
That is the only witness.
That is the
He
only
is the
witness.
only witness.
Yes, my lord. And also, my lord, the owner of the dhaba. Death is a homicide, it has been proved.
They are staying together.
Yes,
Even if the incident accepted on its face value,
and also, my lord,
what is the offense may attract? Which offense may attract according to you?
pardon, sir.
Even if the entire incident accepted as per your evidence, as per the prosecution case, then also whether they not to attract.
It's not for part 2, part 1. This matter may kindly posted for final hearing. Any of he's been in custody, he was not on bail since today.
How long?
6
He
years.
is in
only.
custody from
From
that's,
19.
2019. But appeal is of
So
the
that
year
would be good, my
2024.
lords.
9 years, 10 years alle ide allo.
They are all of the 4-5 matters have been only left, my lords.
I'll
This
correct-
may be taken because, my lords, he's not been,
No,
he has not,
no,
my lords,
Sibling Patil,
my lords,
this bench is taking.
yes.
ಅಷ್ಟೇ.
In this bench only,
ಅದಕ್ಕೆ we
I
got-
do agree, my lords.
ಅಲ್ಲ, so from 10, we want to bring it to
Yes.
8. So again, it will go to 10.
Yes,
Again, it will.
yes, man. I do agree, but into that, my lords. Tell you to the honorable court.
Order on IA number 1 of IA number 2 of 2024. The application filed under section 389 of CRPC seeking suspension of sentence and grant of bail. Full stop. The applicant is the appellant in the main appeal and challenged the judgment of conviction and order of sentence dated 18/4/2024, passed in SC number 19 of 2020 by the second additional district and session judge Bidar, sitting at Basava Kalyana, wherein the learned session judge has convicted the accused for the offense punishable under section 506, 307, 302 of IPC and sentenced the accused for life imprisonment for the major offense 302 of
302.
IPC. Full stop. IPC. They have heard the learned counsel for the appellant, so also the learned additional SPP. Full stop. It is the primary contention of the learned counsel for the appellant that the session judge erred while convicting the accused for the charges leveled against him only based on the evidence of
PW3.
PW3 who partly turned hostile to the prosecution case.
In chief examination, he has fully supported and thereafter he
PW3
turned.
Though he supported the case of prosecution in the chief examination, however,
evidence.
turned hostile during the cross-examination. Full stop. You would further contend that the other witness examined by the prosecution are also not fully supported the case of prosecution. Full stop. Full stop. The counsel further submit that the appellant is in custody from last 6 years.
From 6 years.
From last 6 years, 6 years, and this appeal is of the year 2024, 24, considering the same, he may be, the sentence may be suspended and appellant may be enlarged on bail. Full stop. Per contra, the learned SPP vehemently opposed the application for the grant of application. Full stop. He would submit that, the session judge has passed the well-reasoned judgment after meticulously examining the entire evidence on record, full stop. You would submit a record, full stop. We have carefully perused the impugned judgment, so also the other materials placed before us. On careful perusal of the impugned judgment, on perusal of the same, the learned session judge has predominantly relied the evidence of PW3 to convict the accused.
And PW9 also.
PW3 and PW9, full stop. However, they said, the PW3, though supported in the, supported the prosecution in the chief examination, he totally turned, he has given a go-by to the prosecution case during the cross-examination, full stop. The other witness examined before the, by the prosecution are also not fully supported the case of prosecution. Be that as it may, without expressing any opinion of the merits of the case, since as rightly contended by the learned counsel for the appellant, this appeal is of the year 2024 and the appellant is already custody for the last 6 years, the relying on the law laid down by the Honorable Apex Court in the case of Kashmir Singh versus State of
Punjab.
State of Punjab, reported 1977.
Yes.
Volume
Bhagwatis.
1977, we are of the 1977 full job. We are of the considered view that the application will be considered and the appellant may be the sentence may be suspended and the appellant may be enlarged on bail by imposing condition. Accordingly, IA 2 of 2024 is allowed subject to the condition that the appellant shall execute a personal bond for ₹1 lakh with 2 sureties for the like sum to the satisfaction of the trial court, session court, full stop. But he shall deposit the entire fine amount before the trial court.
My
Fine
humble
amount
request,
may be
my lords.
enhanced.
My lords,
Fine amount may be
Fine.
enhanced.
fine amount may be reduced by 50%. They are BPL card holders, my lords.
At least.
They are BPL card holders. They are very poor people.
Yes.
Grateful minutes.
Obliged.
Third admit. Registry is directed to secure the TCR.
Paper book. Directed to prepare the paper book.
And also to prepare the paper.
34, government advocate.
Your Lordship, so this is the regular first appeal against the judgment and decree passed in OS number 214 of 2006 dated 18/4/2009, wherein the plaintiff had filed a suit, Your Lordship, for declaration, possession and injunction. The brief facts of the case are that, Your Lordships, that the
submission, there is delay of 15 years and odd.
3
That
30
has to
years,
be.
more than 13 years.
I calculated
9
15
months,
years
6
and
days.
5 days, 15
9 months,
years,
6 days, Your Lordships.
5 months delay is there. The grounds and the reasons stated are so, I cannot say, my lord, transfer of the officers, 7 officers are transferred. And DGP has not intimated.
Your Lordships, a detailed.
There must be some reasonableness to claim it. And more so, the building itself, prison building itself is shifted from there. They have taken a 5 acres land, constructed, yet to open, the shifting.
The land is the sterilized zone, Your Lordships. The land is the sterilized zone of 60 feet around the jail. And under that condition, the any order was granted by the Deputy Commissioner in the year 1970. And that has remained unchallenged till this day, till the filing of this OS in the year 2006. The owner was the husband of the plaintiff number 1 and father of 2 and 3. He was staying in Muscat. At that time, it was a joint family of about 33 acres and more, Your Lordships. And that was surrounding, and it was, I think the occupancy rights of, in respect to the said land were granted in the year 1962, Your Lordships, on 23/11/1962. Earlier, it was an Enam land. After the abolition of the Enams Act, and the occupancy rights were granted in the year 23/11/1962. He had filed an application, Your Lordship, for conversion of the land in the year 1970. And the Deputy Commissioner passed the order on 28/2/1970, converting the extent of 9 acres, 9 guntas. And I think as LCR has not come, wherein he has made a mention, Your Lordships. He admits that there is a government land, Your Lordships. That is the exhibit wherein the conversion order is passed. There is a specific contention that they'll not be claiming this land in future. The order of the Deputy Commissioner. May I read the order, Your Lordships? I have the.
But that order of the Deputy Commissioner,
It's remained unchallenged, wherein it says that they'll not claim that land in future. The claimant will not have no claim of ownership over the area of 30 feet around the present jail building.
If jail is there, jail is not there, jail is already shifted.
That instructions, I don't have whether the jail is in existence or as per
You
the
are a
record, it's there.
You are a
This
state,
is-
you don't
This
have
is what is the
information, means-
instructions given to me. The jail is in existence and there is an area of 90 feet around.
I will
The
give,
sterilized zone where construction permission cannot be granted. The remaining portion of the land, any orders granted, they have sold the land.
no, now you get ready on the merits
Yes, Your Lordships.
also and give us all judgments.
Yes, Your Lordships. I'm ready with the arguments.
Keep,
First of all, the suit itself would have been not maintainable. The period for filing a suit for declaration is 12 years from the date that dispossessed from that land. So 1970 is the order passed. Until 2006, they remained, the suit is filed in the year 2006. I'm making it clear to them. That will be my ground.
I will file objection for a
And the
delay, 15
recent
years.
judgment of the apex court, that point also have.
learn the council appearing to the caveat seeks time to file objections for IA of 24. Relist the matter on dateful.
Your Lordships.
Dateful.
Your Lordships, 31st to 8th, and I'm not there. After that, any date.
8th,
11.
11.
But 35
Some,
came out.
my name is not correctly written, so it's not shown, my lord.
Office to show the name of learned counsel Manavendra Reddy correctly as so and so instead of.
Yes, sir.
35. Yeah, emails.
I am for the respondent.
They have negotiated, my lord.
Just not this.
So I am for the respondent.
The proposal was that, my lord, penal interest would be waived off and on or before 30th April, I would pay the entire amount. That is the proposal I made.
I am told that, my lords, before 29th, my lords, if they pay entire loan, it's
29th of January.
March,
Before 29th of.
March, year ending, my lords. If that is the case, my lords, they have power to waive the penal interest. Lords, if they pay after 29, my lords, there is a difficulty, my lords, while auditing, they carry it to the next assessment year, my lords. Then, my lords, there are several audits, NABARD audits, state government audits, and my lords, they make a serious objection on it.
Just see the 1 month difference, 1 month difference.
30th March,
29th March.
29th. I've asked him, my lord, he says he'll try to make payment by March 29th. So he'll be entitled for a waiving of parent interest. If he defaults or if he is unable to pay, my lord, by April 30th, he is ready for whatever reason. If they are unable to waive off parent interest, he can't help, because if he is unable to pay by 29th
You
March,
file an affidavit.
I'll file,
When do you want?
saying that tomorrow I'll file.
Tomorrow.
Saying that if he clears by 29th of March, he would be entitled for the waiving of penal interest. In case if he pays on March 30th April, my lords, he will not be entitled for penal interest, but the time is till April 30th. He may pay it on or before 30th April.
Fair submission.
Please.
Tomorrow.
My lord, so appearing for appellant, my lord, calculation is not working, my lord. He says 50% prospectus to be added, future prospectus, and 1/4 to be deducted. That is the challenge before this honorable court. You want to modify or enhance that amount, he is telling. Our calculation, it will come to 26,80,400, my lords. Lordship. But his calculation comes to
But
35 lakhs to 54 lakhs. He is seeking enhancement. My
My
lord.
lord, in other heads also, my lord, in other heads also.
Monday.
Yes.
Monday.
Please, my lord, after 30th month. Please. Yes. Please.
Please.
Puleppa Heru.
Urdu teacher. Yes, government. Urdu teacher.
My lord,
Urdu teacher, mathematics,
ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ, ಏನು ಬಂದಿಲ್ಲ. Information.
What we wanted you to find out,
My lord,
ಅದು ಬೇರೆ ಎಲ್ಲಿ ಪೋಸ್ಟಿಂಗ್ ಕೊಡ್ತೀರಾ?
ಇತ್ತಂದ್ರೆ ಅಲ್ಲಿ ತಾವು ಆದೇಶ
You'll have to go.
ಆದೇಶ ಮಾಡ್ಬಿಟ್ರೆ ಅದ್ರ ಪ್ರಕಾರ ಅವ್ರು ಎಲ್ಲಿದೆ ಅಕಾಮಡೇಟ್ ಮಾಡ್ಬೋದೇನೋ ಅಂತ.
ಆಯ್ತು, ಬರ್ಲಿ ಅವ್ರು ಯಾರು ಇನ್ನೊಂದು ಮೂವ್ ಮಾಡಿದ್ದಾರೆ. ಇನ್ ಕೇಸ್ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಸ್ಟಾರ್ಟ್ಸ್, ಯು ಕ್ಯಾನ್ ಕಮ್ ಲೇಟರ್.
Please. My lord, my one request, my lord, in serial number 41, my name be deleted. I have filed the, my lord, appeal 41 ನಲ್ಲಿ 40 ಅದರಲ್ಲಿ ಲ್ಯಾಂಡ್ ಓನರ್ ಕಡೆಯಿಂದ ನಾನೇ ಅಪೀಲ್ ಹಾಕಿದ್ದೆ. ಈಗ ಐ ಹ್ಯಾವ್ ಗಿವನ್ ನೋ NOC. My name be deleted.
ಆಫೀಸ್ ಟು ಯಾವ್ದ್ರಲ್ಲಿ?
41.1.
Delete. Name of learned counsel, Shiv Kumar R. Tingli. As another counsel has already put in appearance for the appellant.
Please.
Bandi.
Number 53.
Lord, those matters where
Where is
English.
that order? Where is that order? Order that we have passed in those other matters. We have passed similar orders.
Yes, my lord, yes, yes.
Identical order, ಏನಾದ್ರು change ಇರುತ್ತಾ?
Same, Lord. Para 5.
Just take us through that order.
Cyber.
Identical, huh?
Yes,
Huh?
yes.
Any change? No.
In 53, my lord will see
50?
53.
Hmm.
Item number 53.
Hmm.
I am asked to teach basically I am a Urdu teacher.
Hmm.
I am asked to teach mathematics.
Where is your representation?
Representation not me, it is counseling. Representation shall be, I request my lord, representation directed by KAT is to give representation, in turn respondents will consider. Unless this order is set aside, that process cannot be done. My lord will see para 5, my lord's order. That has been set aside. Only after that, this process starts. And that is pending, I cannot give representation. Lord will see operative portion, page number 33. Application is disposed of. Directing the applicant to submit representation to the authority indicating the vacancies available and also mentioning that he is Urdu teacher and now he is posted and working as mathematics teacher, post in Urdu medium and provide. Unless this goes, my lord's order, para 5, that is the crux of the case. If annexure A3 is set aside and orders, that will
Only to that extent. A3.
annexure A3, it has to go.
Correct. But in counseling, why did you choose mathematics? Counseling alle by mistake you chose.
Illa. Our mistake, nandalla. I have chosen the place.
Please,
Place I have chosen.
Correct. What they are saying, para 8 of the KT order, that while in the counseling process, you chose the place.
Place. I have chosen the place, not the subject.
In counseling, only the place is.
Yes, only place and convenience of the applicants.
Place and subject ಎರಡು ಇರುತ್ತೆ.
Filling ನಲ್ಲಿ. Whether they choose mathematics or not, still they can't be given mathematics. Isn't it?
My lord, if it is the whole, my lord, school is Urdu medium, the Urdu teacher has to teach every subject in Urdu only. Here, if he is posted for Urdu, in mathematics also has to teach in Urdu.
I am Urdu language teacher.
Urdu language teacher.
I am Urdu language teacher.
Urdu language.
Yes, my lord.
ಅಷ್ಟೇ ನೀವೇನ್ ಮಾಡ ಇದು ನಮ್ಮ ರೋಸ್ಟರ್ ತರ ಅಲ್ಲ, ಇಲ್ಲಿ ನಾವು ಬೇಲ್ ಮಾಡ್ಬೇಕು, ಟ್ಯಾಕ್ಸ್ ಮಾಡ್ಬೇಕು, ಅಲ್ಲ ಆಗಲ್ಲ, ತಪ್ಪಾಗುತ್ತೆ. ಸೊ ನಾವು A3 will have to be
yes. If A3 goes, I am satisfied.
The petitioner has called in question correctness of the order of KAT only in so far as the tribunal has refused to set aside the order at annexure A3.
Yes.
Though the partial relief has been granted, permitting the petitioner to make out a representation for appropriate posting. The case of the petitioner is that the petitioner who is an assistant teacher Urdu in Urdu language. Huh?
Yes, ma'am.
had taken part in the counseling process and had taken part in the counseling process after having a completed tenure in the earlier institution. Full stop. Next, it is submitted that after completion of the prescribed period in CRC post, petitioner was transferred and posted as mathematics Urdu teacher as per the order at annexure A3, and the petitioner was aggrieved by such posting. Full stop. The tribunal, in its detailed order, has considered the position that the petitioner cannot be asked to teach mathematics, as the petitioner is a assistant teacher in Urdu language.
Urdu language.
Accordingly, the tribunal has allowed the application in terms of the order extracted below. The Roman 1, 2, and 3 at page 2 and 33. Next. The said order of the KET is not challenged by the state. And accordingly, the direction of the tribunal in terms of para Roman 2 has attained finality. Full stop. Next. Only contention of the petitioner is that the question of submitting representation to the authority and its consideration as regards the post to which the petitioner is qualified to teach, that is assistant teacher Urdu,
Yes.
can be considered by the state only if the previous order of posting at annexure A3 is set aside. In light of the limited prayer made out, in light of the findings of the KAT, annexure A3
Set aside.
is set aside, and the remaining findings
As it
and
is.
relief granted by the tribunal, remaining findings and relief granted by the tribunal are affirmed. Accordingly, petition is dismissed.
Yes. Great.
Next. What is this matter?
Next, my lord, A2. Kindly see,
Uh,
annexure A2, page number 16.
One nimsh. Needless to state, if representation as indicated in Roman 2 of the order of the KT is made, state to consider the same expeditiously. Ashtena? Okay, next.
Yes.
And this one?
Next matter. Next matter, Lord will find annexure A2, page number 16.
A2,
A2, page number 16.
the same order.
Same. I am Kannada teacher. I am asked to teach English.
The petitioner.
ದಯವಿಟ್ಟು annexure A2 ಬನ್ನಿ, page number 16.
The petitioner has challenged the order of the tribunal, aggrieved by the order only insofar as the tribunal has not set aside the order of transfer at annexure A2, whereby the petitioner was an assistant teacher in Kannada language, was posted to teach
English.
Posted as an English language teacher. The petitioner, on being posted to teach English language, I challenge the same before the tribunal. The tribunal has passed a detailed order and the observations made And the tribunal has accepted the contention of the petitioner and disposed of the application in terms of the observation in the operative portion of the order, which is extracted below, page 28, 29. The counsel of petitioner has also relied on the observation made in WP 202279 of 2024 at paragraph number idರಲ್ಲಿ
Alert.
ಇದರಲ್ಲಿ ಯಾವ paragraph number? At paragraph number 4 and 5. 4 and 5. Stop. Next. In light of the said paragraph, the said observations passed in WP 202279 of 2024 are extracted below. Next. In light of the limited prayer made. In light of the limited prayer made. Contending that no doubt the tribunal has directed the respondent authority to consider the representation. However, such consideration cannot be made without setting aside the order of transfer at annexure A2.
Annexure A2.
Accordingly, the order at annexure A2 is set aside. The remaining observations, findings and relief granted by the tribunal are affirmed, and accordingly petition is disposed of. The respondent, if the representation is made, to consider the same and pass appropriate orders expeditiously.
Right.
It is noticed that one mail actually noticed that the order of the tribunal to the effect that the petitioner cannot be posted to teach English language has not been challenged by the state and has attained finality.
List number 2, Uleppa Heru.
Yes.
Lord, this is a petition filed with the petitioner having aggrieved by the order of KT passed on 30th December 2024. Though the order is passed on 30th December 2024, till yesterday,
It was not released.
no, not received. It was not available in the website nor in the office. Yesterday, I have come to know immediately. I obtained the copy and approached my lords. From 30 to my lord may see, from 30th December to 7th January, courts were on, I don't say vacation, holidays. Surprisingly, when I came to know yesterday, immediately I obtained the copy and I am before my lords.
What is the order?
Lord, I am working as a district development cell, project director, district development cell at Bida. I am here on deputation. My lord will find annexure A1, where the authorities have, by seeing my performance, by seeing my merit, I was in Mysore. From Mysore, they have brought me to Bida. My lord will find annexure A1, page number 23. On 20th September 2021, I have been deputed to work at Bidar DC office as a project director. Lord, thereafter, on 24th September, annexure A2, I joined the duties. A3 is my CTC. Annexure A4, a person of their choice by name Khalil Sabji KM has been brought in my place. It was not even 2 years for over. I immediately approached service tribunal. After approaching service tribunal, my lord will find annexure A5, page number 28. They have withdrawn the order.
They withdrawn
Order of repatriation. They have withdrawn the order. And I also withdrawn my application before KT.
Annexure
Annexure A5. Annexure A5. Page number 28.
They withdrawn.
They have withdrawn.
Then what happened?
Then, my lord, I have continued to work. And my application also have withdrawn from KT. Annexure A6, page number 29. Since they have withdrawn, I have also withdrawn my application. Thereafter, my lord, I was peacefully working with my family at Bidar. I have admitted my children in a school at Bidar. Annexure A7 is my son's admission card. In that, my lord will see.
No, now you have worked there for 3 years.
Lord,
on deputation, you have worked for 3 years.
Deputation, but there is no definite period. It may be 6 months, 1 month. or till the project is over. They have sent me for particular project.
For 1 year.
1 year, 2 years, there is no definite period.
What is the minimum tenure guaranteed?
My lord.
What is the security of tenure for you? Group A, Group B?
So group B.
I'm Group A.
Group A.
Group A officer.
What is the security tenure under the?
In the transfer guidelines, 2 years.
2 years.
2 years.
Transfer guidelines, 2 years. When they have withdrawn, my lord, my repatriation order, I have admitted my children. Lord will see annexure A7, page number 32. Page number 33, annexure A8.
No, correct, sir, but now that minimum period is taken care of. You have finished 2 years. Sir.
Minimum period, my lord, transfer guidelines as per that, 2 years as a Group A officer. As far as deputation is concerned, even 6 months also they can send me back. There is no definite period.
Correct,
No,
sir.
I am not on that.
Hmm.
Kindly permit me. I am not on that. Now, in the midst of the years, I have admitted my children. My wife is also admitted for diploma in pharmacy. By academic year, I will give undertaking. Kindly, I will give undertaking. By end of academic year, I am ready to go and report my parent department. That is all my submission.
April.
2 ತಿಂಗಳು ಅಷ್ಟೇ. ಏಪ್ರಿಲ್ ಎಂಡಿಗೆ ಹೋಗ್ಬಿಡ್ತೀನಿ ನಾನು. I am ready.
March 31st.
No, not 31st, April 10 is the result. Let there be April end. I am ready. I will give undertaking.
Right. Affidavit must be filed. We'll have.
Yes, yes, yes. I am ready.
Tomorrow you file affidavit. Tomorrow file affidavit.
Tomorrow.
You file affidavit.
Yes, yes, yes. Grateful.
37. Chambuling Saliman.
Now that the dismissal of KT order, let there be formal interim order. Formal. Because they may.
Petitioner not to be relieved till the next date.
No, not relieved. I am not relieved.
Not to be relieved.
Yes.
Till the next date, release tomorrow.
Grateful.
You file an affidavit clear.
Tomorrow I will file. Tomorrow I will file. Matter may be disposed of tomorrow.
AG accepts notice for the respondents. Now, but anybody else is involved in this?
Nobody is posted.
Not yet.
Nobody is posted. Or return reply statement ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ. Intending to post.
ಆಯ್ತು. Tomorrow.
37. Chambuling Saliman.
This appeal is filed against the order passed by the district session judge that Bidar charges against the accused offense under section 302 and 201 of IPC, Your Lordship. The accused is convicted under section 302 for life and 201 for 3 years. Evidence for discard under the evidence sector, Your Lordship. The accused is accused killed his father, one father in the land of CW 23. Yet the brief allegation is as per the charge sheet against the accused or that on 7/12/2015 at about 1:30 hours, the deceased complainant Arjun Prasad, father of the deceased, was working in the land of CW 23, and at that time, accused went to him and asked for giving money. And when his father had refused for giving the money,
Then the accused had assaulted him with kamakatti on his head on left ear, and due to which the said Arjun Prasad had sustained grievous injuries, succumbed to injuries, and died on the spot. It is further alleged that the deceased burnt and dead body of the deceased for purpose of causing the disappearance of evidence of murder in order to screen himself from legal punishment. The accused is
Just a minute. Yes, sir.
the credible information received by the Sub-Inspector Janwada Police Station in the complaint given by the.
Do one thing, read the complaint.
Yes.
Bit P1.
Yes, sir.
Bani, complaint even.
ಪೊಲೀಸ್ ಉಪನಿರೀಕ್ಷಕರು ಜನವಾಡ ಪೊಲೀಸ್ ಠಾಣೆ ದಿನಾಂಕ 7/12/2005 ನನ್ನ ಗಂಡ ಅರ್ಜುನ್ ತಂದೆ ಬಂಡೆಪ್ಪ ಪ್ರಸಾದ್ ವಯಸ್ಸು 58 ವರ್ಷ ಸಾಕಿನ ಜನವಾಡ ಇವರಿಗೆ ದಿನಾಂಕ 7/12/2015 ಮಧ್ಯಾಹ್ನ 1:30 ಗಂಟೆ ಸುಮಾರಿಗೆ ನನ್ನ ಮಗ ಶಿವಕುಮಾರ್ ಪ್ರಸಾದ್ ಈತನು ಕೊಲೆ ಮಾಡಿ ಮೃತದೇಹವನ್ನು ಬೆಂಕಿ ಹಚ್ಚಿ ಸುಡಲು ಪ್ರಯತ್ನ ಮಾಡಿದ ಬಗ್ಗೆ ದೂರು. ಮಾನ್ಯರೇ, ಈ ಮೇಲ್ಕಂಡ ವಿಷಯದ ಅನುಗುಣವಾಗಿ ನಾನು ಗೋದಾವರಿ ಗಂಡ ಅರ್ಜುನ್ ಪ್ರಸಾದ್ ವಯಸ್ಸು 55 ವರ್ಷ ಜನವಾಡ ಗ್ರಾಮದ ನಿವಾಸಿಯಾಗಿದ್ದು ನಾನು ನನ್ನ ಗಂಡನಿಗೆ 2ನೇ ಹೆಂಡತಿಯಾಗಿರುತ್ತೇನೆ. ನನ್ನ ಗಂಡನವರು ಲಕ್ಷ್ಮಿ ಇವಳನ್ನು ಮೊದಲನೇ ಮದುವೆ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಆಕೆಗೆ ವಿಜಯಕುಮಾರ್ ಎಂಬುವರು ಗಂಡು ಮಗ ಇರುತ್ತಾರೆ. ಈತನು ಸದ್ಯ ಕಾಶಂಪುರ ಗ್ರಾಮದಲ್ಲಿ ತನ್ನ ಹೆಂಡತಿಯೊಂದಿಗೆ ಅಲ್ಲಿಯೇ ವಾಸವಾಗಿರುತ್ತಾನೆ. ನನ್ನ ಗಂಡನ ಮೊದಲನೇ ಹೆಂಡತಿ ಲಕ್ಷ್ಮಿ ಇವಳು 2011ರಲ್ಲಿ ಮರಣ ಹೊಂದಿರುತ್ತಾಳೆ. ನನ್ನ ಗಂಡನವರು ತನ್ನ ಮೊದಲನೇ ಹೆಂಡತಿ ಇರುವಾಗಲೇ ನನಗೆ 2ನೇ ಮದುವೆ ಮಾಡಿಕೊಂಡಿದ್ದು. ನನಗೆ ಒಟ್ಟು 6 ಜನ ಮಕ್ಕಳಿದ್ದು. ರಾಜಕುಮಾರ, ಶಿವಕುಮಾರ, ಮೀನಾಕ್ಷಿ, ರಾಹುಲ, ಸ್ವರೂಪ ಮತ್ತು ಪ್ರಿಯಾಂಕಾ ಇದ್ದು 3 ಗಂಡು ಮಕ್ಕಳು 3 ಹೆಣ್ಣು ಮಕ್ಕಳು, ಹೀಗೆ ಒಟ್ಟು 6 ಜನ ಮಕ್ಕಳಿರುತ್ತಾರೆ. ಹೆಣ್ಣು ಮಕ್ಕಳಾದ ಮೀನಾಕ್ಷಿ ಹಾಗೂ ಪ್ರಿಯಾಂಕಾ ಇವರು ಮದುವೆ ಮಾಡಿಕೊಟ್ಟಿದ್ದು. ಇವರಿಬ್ಬರು ತಮ್ಮ ತಮ್ಮ ಗಂಡನ ಮನೆಯಲ್ಲಿ ಇರುತ್ತಾರೆ. ಇನ್ನುಳಿದ 3 ಜನ ಗಂಡು ಮಕ್ಕಳು ಹಾಗೂ ಸ್ವರೂಪ ಹಾಗೂ ನನ್ನ ಗಂಡ ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಒಟ್ಟಿಗೆ ಇರುತ್ತೇವೆ. ನನ್ನ ಗಂಡನವರು ಉಪ್ಪಾರ ಕೆಲಸ ಹಾಗೂ ಜೊತೆಯಲ್ಲಿ ಊರಲ್ಲಿ ಯಾರಾದರೂ ಸತ್ತರೆ ಶವ ಸಂಸ್ಕಾರ ಹೆಣ ಸುಡುವ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರು. ನನ್ನ ಗಂಡನ ಜೊತೆಗೆ ನನ್ನ 2ನೇ ಮಗನಾದ ಶಿವಕುಮಾರ್ ಈತನು ಸಹ ಆವಾಗ ನನ್ನ ಗಂಡನ ಸಹಾಯಕ್ಕಾಗಿ ಹೆಣ ಸುಡಲು ಹೋಗುತ್ತಿದ್ದನು. ಊರಲ್ಲಿ ಯಾರಾದರೂ ಸತ್ತರೆ ಆ ಹೆಣವನ್ನು ಸುಡಲು ನನ್ನ ಗಂಡನಿಗೆ 500ರಿಂದ 600 ರೂಪಾಯಿ ಹಣವನ್ನು ಕೊಡುತ್ತಿದ್ದರು. ಈ ಹಣದಲ್ಲಿ ನನ್ನ ಗಂಡ ಶಿವಕುಮಾರನಿಗೂ ಸಹ ಸ್ವಲ್ಪ ಹಣ ನೀಡುತ್ತಿದ್ದನು. ಒಂದು ವೇಳೆ ಹಣ ಕೊಡದೇ ಇದ್ದಾಗ ಆತನು ಅದಕ್ಕಾಗಿ ನನ್ನ ಗಂಡನೊಂದಿಗೆ ಜಗಳ ಮಾಡುತ್ತಿದ್ದನು. ಈ ಹಿಂದೆ ಹಣ ಕೊಡದೇ ಇದ್ದಿದ್ದಕ್ಕೆ ಸುಮಾರು 2-3 ಸಲ ಜಗಳ ಮಾಡಿದ್ದು ಇದೆ. ಸದ್ಯ ಶಿವಕುಮಾರ್ ಈತನು ಯಾವುದೇ ಕೆಲಸ ಮಾಡದೆ ಬೇಕಾರದಿಂದ ಓಡಾಡುತ್ತಿದ್ದನು. ಅವನಿಗೆ ಚುಟ್ಟ ಬಿಗಿಯುವುದು, ಬೀಡಿ ಬಿಗಿಯುವುದು ಚಟವಿದ್ದು ಮನಸ್ಸಿಗೆ ಬಂದಾಗ ಕೂಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿರುತ್ತಾನೆ. ಅಲ್ಲದೆ ಮೇಲಿಂದ ಮೇಲೆ ನನ್ನ ಗಂಡನ ಜೊತೆ ಮತ್ತು ನನ್ನ ಜೊತೆ ನನಗೆ ಬೀಡಿ ಸೇದಲು ಹಾಗೂ ಚುಟ್ಟ ಬಿಗಿಯಲು ಸಹ ಹಣ ಕೊಡು ಅಂತ ಜಗಳ ಮಾಡುತ್ತಿದ್ದನು. ನಿನ್ನೆ ದಿನಾಂಕ 6/12/2015 ನಮ್ಮೂರಿನಲ್ಲಿ ರವಿಚಂದ್ರ ಲವಟೆ ಇವರು ವಯಸ್ಸಾಗಿ ಸತ್ತಿದ್ದರಿಂದ ನನ್ನ ಗಂಡನವರಿಗೆ ಹೆಣ ಸುಡಲು ರವಿಚಂದ್ರ ಲವಟೆ ಇವರ ಮನೆಯವರು ಕರೆದಿದ್ದು ನನ್ನ ಗಂಡನವರು ಬರುತ್ತೇನೆ ಅಂತ ಹೇಳಿರುತ್ತಾರೆ. ಇಂದು ದಿನಾಂಕ 7/12/2015 ಮುಂಜಾನೆ 11 ಗಂಟೆಗೆ ಸುಮಾರಿಗೆ ನಾನು ಹಾಗೂ ನನ್ನ ನಾದನಿ ಮುಕ್ತಮ್ಮ, ನನ್ನ ಮಗಳಾದ ರಾಹುಲ್, ಮಗಳಾದ ಸ್ವರೂಪ ಎಲ್ಲರೂ ಮನೆಯಲ್ಲಿದ್ದಾಗ ನನ್ನ ಗಂಡನವರು ಜನವಾಡ ಗ್ರಾಮದ ರವಿಚಂದ್ರ ಲವಟೇರವರು ಸತ್ತಿದ್ದು ಹೆಣ ಸುಡಲು ಕರೆದಿದ್ದರಿಂದ ಅವರ ಹೊಲದ ಕಡೆಗೆ ಹೋಗಿ ಹೆಣ ಸುಟ್ಟು ಬರುತ್ತೇನೆ ಅಂತ ಹೇಳಿ ಹೋಗಿರುತ್ತಾರೆ. ನಂತರ ನನ್ನ ಮಗನಾದ ಶಿವಕುಮಾರನು ಮನೆಗೆ ಬಂದು ಅಪ್ಪ ಎಲ್ಲಿ ಅಂತ ಕೇಳಿದ್ದರಿಂದ ನಾನು ರವಿಚಂದ್ರ ಲವಟೆಯವರು ಸತ್ತಿದ್ದು ಅವರ ಹೊಲಕ್ಕೆ ಹೆಣ ಸುಡಲು ಹೋಗ್ಯಾರ ಅಂತ ಹೇಳಿದೆ. ಆಗ ಅವನು ನಾನು ಹೋಗ್ತೀನಿ ಅಂತ ಹೇಳಿ ಹೋದನು. ನಂತರ ಮಧ್ಯಾಹ್ನ 2 ಗಂಟೆ ಸುಮಾರಿಗೆ ಚಂದ್ರಕಾಂತ್ ತಂದೆ ಮನೋಹರ್ ಪದ್ದಾರ್ ಇವರು ಗಡಿಬೇಡಿಯಲ್ಲಿ ನಮ್ಮ ಮನೆಗೆ ಬಂದು ನನ್ನ ಗಂಡ ಅರ್ಜುನ್ ಈತನು ಲವಟೆ ಇವರ ಹೊಲದಲ್ಲಿ ರಕ್ತ ಗಾಯವಾಗಿ ಬಿದ್ದಿರುತ್ತಾನೆ, ಅವರಿಗೆ ಏನಾಗಿರುತ್ತದೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳಿದಾಗ ನಾನು ಹಾಗೂ ನನ್ನ ನಾದನಿ ಮುಕ್ತಮ್ಮ, ಮಗಳಾದ ಸ್ವರೂಪ, ಮಗನಾದ ರಾಹುಲ್ ನಾವೆಲ್ಲರೂ ಕೂಡಿಕೊಂಡು ಲವಟೆ ಇವರ ಹೊಲಕ್ಕೆ ಹೋಗಿ ನೋಡಲಾಗಿ ನನ್ನ ಗಂಡನವರು ಮೈಮೇಲೆ ಅಲ್ಲಲ್ಲಿ ಸುಟ್ಟ ಗಾಯಗಳಾಗಿದ್ದು.
ಯಾರು ಚಂದ್ರಕಾಂತ ತಂದೆ ಮನೋಹರ ಪುದ್ದಾರ?
He is eyewitness of this case, Your Honor.
Examined as PW?
No, my lord.
No, no examined.
CW 16.
CW6 not examined, huh?
Yes, no.
Not examined.
Chandrakant is not
13,
examined.
14, 15 and 16 are the eyewitness, my lords. CW 14 and 15 have been as PW. 7 and
Chandrakant is not examined. He is eyewitness of this case.
ಓದಿ ಮುಂದೆ ಓದಿ.
ಹೇಳಿದಾಗ ಏನಾಗಿರುತ್ತೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳಿದಾಗ ನಾನು ನನ್ನ ನಾದಿನಿ ಮುಕ್ತಮ್ಮ, ಮಗಳಾದ ಸ್ವರೂಪ, ಮಗನಾದ ರಾಹುಲ್ ನಾವೆಲ್ಲರೂ ಕೂಡಿಕೊಂಡು ಲವಟೆಯವರ ಹೊಲಕ್ಕೆ ಹೋಗಿ ನೋಡಲಾಗಿ ನನ್ನ ಗಂಡನವರ ಮೈಮೇಲೆ ಅಲ್ಲಲ್ಲಿ ಸುಟ್ಟ ಗಾಯಗಳಾಗಿದ್ದು ಅಕ್ಕಪಕ್ಕ ಹುಲ್ಲು ಸಹ ಅಲ್ಲಲ್ಲಿ ಸುಟ್ಟಿದ್ದು ಇರುತ್ತದೆ. ನಂತರ ನಾವೆಲ್ಲರೂ ಅಳುವುದು ಚೀರಾಡುವುದು ನೋಡಿ ನಮ್ಮೂರ ಭಾಸ್ಕರ್ ತಂದೆ ಬಸಪ್ಪ ಹಾಗೂ ತುಳಸಿರಾಮ್ ತಂದೆ ನರಸಪ್ಪ, ಸಾಗರ ಹಾಗೂ ಇತರರು ಸಹ ಅಲ್ಲಿಗೆ ಬಂದು ನೋಡಿರುತ್ತಾರೆ. ನಂತರ ನನಗೆ ಗೊತ್ತಾಗಿದ್ದೇನೆಂದ್ರೆ ನನ್ನ ಮಗನಾದ ಶಿವಕುಮಾರ್ ಈತನು ನನ್ನ ಗಂಡನೊಂದಿಗೆ ಹಣಕ್ಕಾಗಿ ಜಗಳ ಮಾಡಿ ಅವರ ಎಡಕಿವಿಯ ಕೆಳಗಡೆ ಯಾವುದೋ ಒಂದು ಚೂಪಾದ ವಸ್ತುವಿನಿಂದ ಹೊಡೆದು ಭಾರಿ ರಕ್ತಗಾಯ ಮತ್ತು ತಲೆ ಹಿಂದೆ ಕತ್ತರಿಸಿದ ಭಾರಿ ರಕ್ತಗಾಯ ಪಡಿಸಿ ಕೊಲೆ ಮಾಡಿ ಅವರ ದೇಹವನ್ನು ಅಲ್ಲಿಯೇ ಸುಟ್ಟು ಸಾಕ್ಷಿ ಪುರಾವೆ ನಾಶಪಡಿಸಲು ಪ್ರಯತ್ನ ಮಾಡಿರುತ್ತಾನೆ. ಈ ಘಟನೆ ಅಂದಾಜು ಸುಮಾರು ಇಂದು ದಿನಾಂಕ 7/12/2015 ಮಧ್ಯಾಹ್ನ 1:30 ಗಂಟೆಗೆ ಸಂಭವಿಸಿರುತ್ತದೆ. The exact death of the time of the deceased is not stated in the any prosecution witness, Your Honor.
At what time this complaint lodged?
ಕಂಪ್ಲೇಂಟ್ ಅದೇ ದಿವಸ 4 ಗಂಟೆಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. 4 ಗಂಟೆ.
ಹೇಗೆ ಗೊತ್ತಾಯ್ತು ಅಂತ? ನನಗೆ ಗೊತ್ತಾಯ್ತು ಅಂತ ಹೇಳ್ತಾರಲ್ಲ, ಹೇಗೆ ಗೊತ್ತಾಯ್ತು ಅಂತ ಯಾರು ಹೇಳಿದ್ರು?
ಅದೇ ಚಂದ್ರಕಾಂತ್ ಬಂದ್ರ ಅಂತ ಹೇಳಿದ್ರು ಮನೆಗೆ. ಚಂದ್ರಕಾಂತ್ ಮನೋಹರ್ ಪದ್ದಾರ್
ಆರೋಪಿ ಮಾಡ್ತಾರೆ, ಯಾರು ಹೇಳಿದ್ರು?
CW 16. CW 16 informed to the company.
ಚಂದ್ರಕಾಂತ ಗಡಿಬಿಡಿಯಲ್ಲಿ ಮನೆಗೆ ಬಂದು
ಒಬ್ಬನೇ ರೀ
ಬಿದ್ದಿರ್ತಾನೆ ಅಂತ ಏನಾಗಿದೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳಿದಾಗ ನಂತರ ನನಗೆ ಗೊತ್ತಾಯ್ತು ಅಂತ ಹೇಳ್ತಾರಲ್ವಾ?
And that Deepak and Dilip.
Where is their statement? When their statement was recorded?
Their statement were recorded on, my lords,
How the police laid hand on these
on 7/12. On 7/12 it's.
7/12 their statement
Yes,
recorded.
yes.
They informed PW1.
Thereafter.
They informed. It is not stated in the complaint anyhow.
That is not there, my lords. Shall I read or that Dilip and
ನನಗೆ
Deepak?
ಗೊತ್ತಾಗಿದ್ದೇನೆಂದರೆ ಸರಿ, ಹೆಂಗೆ ಗೊತ್ತಾಯ್ತು ಅಂತ ಯಾರು ಹೇಳಿದ್ರು ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ ಅವರು. ಓಕೆ, ಆಯ್ತು. Now their statement also recorded. Yes.
On the same date.
ಆಯ್ತು, ಹೇಳಿ.
ಇದು ಬೇರೆ
ಕುಮಾರ್ ಹೇಳಿ, ಏನು ನೆಕ್ಸ್ಟ್?
ಈ ಕೇಸಿನ ಪೇಪರ್ ಬುಕ್ ಕೊಟ್ಟಿಲ್ಲ ಸರ್, ಬೇರೆ ಕೇಸಿನ ಕೊಟ್ಟಾರ್ರಿ. ಇಷ್ಟೇ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಾರ್ರಿ, ಇದರ ಪೇಪರ್ ಬುಕ್ ಆದಂತ ಹೇಳಕತ್ತಾರೆ ಅವ್ರು.
ಅದರಂತೆ ಹೇಳಿ.
ಈಗ ಐ ವಿಟ್ನೆಸ್ ಯಾರೆಲ್ಲ ಇದ್ದಾರೆ?
ಐ ವಿಟ್ನೆಸ್ ಅದೇ ಇವರೇ 3 ಸರ್ ಹೇಳ್ತಾ ಇದ್ದಾರಲ್ರ ಅವರು. ಚಂದ್ರಕಾಂತ್,
Dilip, Deepak.
PW
7 and 8.
PW 7 and 8.
ಹಾ ಸರ್.
PW 7 ಓದಿ ಎವಿಡೆನ್ಸ್ ನೋಡಿ ಏನ್ ಹೇಳ್ತಾರೆ.
PW 7 ಇವರು ಕೋಲಾರ್ಸಿ. ದಿಲೀಪ್ ಸರ್ಕಾರಿ ಅವರಿಂದ ನನಗೆ PW1 ಗೊತ್ತು, PW1 ಇವಳ ಗಂಡ ಮೃತ ಅರ್ಜುನ್ ಗೊತ್ತು, ನನ್ನ ಹಾಗೂ PW1 ಊರು ಜನವಾಡ ಇರುತ್ತದೆ. ನನಗೆ CW13, CW15, CW16 ಗೊತ್ತು, ಆರೋಪಿ ಗೊತ್ತು, ಮೃತ ಅರ್ಜುನ್ ಈತನ ಉಪ್ಪರ ಕೆಲಸ ಹಾಗೂ ಊರಿನಲ್ಲಿ ಯಾರಾದರೂ ಸತ್ತರೆ ಕುಣಿ ತೆಗೆಯಲು, ಹೂಳಲು, ಸುಡಲು ಹೋಗುತ್ತಾನೆ. ಆರೋಪಿತನ ಮೃತ ಅರ್ಜುನ್ ಮಗ. ನನಗೆ ನಮ್ಮ ಊರಲ್ಲಿ ರವಿಚಂದ್ರ ಲವಟೇರ್ ಅವರು ಸುಮಾರು ಈಗ 1.5 ವರ್ಷದ ಹಿಂದೆ ಮೃತಪಟ್ಟಿರುತ್ತಾರೆ. ಸದರಿ ರವಿಚಂದ್ರ ಲವಟೆ ಮೃತಪಟ್ಟಿದ್ದು, ಅವರ ಶವ ಸುಡಲು ಮೃತ ಅರ್ಜುನ್ ಹೋಗಿದ್ದು, ಆಗಾಗ ಆರೋಪಿಸ ಆತನ ತಂದೆ ಜೊತೆ ಶವ ಸುಡಲು ಹೋಗುತ್ತಿದ್ದ. ನಾನು ಚಾಸ 15, 13 ಹಾಗೂ ಇತರರು ಸಹ ರವಿಚಂದ್ರ ಲವಟೆ ಅವರ ಅಂತ್ಯ ಸಂಸ್ಕಾರಕ್ಕೆ ಮಾಡಲು ಹೊಲಕ್ಕೆ ಹೋಗಿದ್ದೇವೆ. ಮಧ್ಯಾಹ್ನ 3ರಿಂದ 4 ಗಂಟೆಗೆ ಆರೋಪಿತನು ಹಾಗೂ ಮೃತ ಅರ್ಜುನ್ ದುಡ್ಡಿನ ವಿಷಯವಾಗಿ ಜಗಳ ಮಾಡಿಕೊಳ್ಳುತ್ತಿದ್ದರು. ದಿಸ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್ ಪಾಯಿಂಟ್ ಸರ್. ಇವ್ರು ಹೇಳ್ತಾರೆ 3ರಿಂದ 4 ಗಂಟೆಗೆ ಇವರು ದುಡ್ಡಿನ ವಿಷಯ ಜಗಳ ಮಾಡ್ತಿದ್ದಾರೆ. ಇಲ್ಲಿ 2 ಗಂಟೆಗೆ 1.5 ಗಂಟೆಗೆ ಸತ್ತಾನಂತ ಇದರಲ್ಲಿ ಇದೆ. ಇವ್ರ ಐ ವಿಟ್ನೆಸ್ ಯಾರ ದಿಲೀಪ್ ಇಸ್ ಆಲ್ಸೋ ಐ ವಿಟ್ನೆಸ್ ಆಫ್ ದಿಸ್ ಕೇಸ್. ಈ ಸ್ಟೇಟೆಡ್ ದಟ್ 3ರಿಂದ 4 ಗಂಟೆಗೆ ಆರೋಪಿತನು ಹಾಗೂ ಮೃತ ಅರ್ಜುನ್ ದುಡ್ಡಿನ ವಿಷಯವಾಗಿ ಜಗಳ ಮಾಡಿಕೊಳ್ಳುತ್ತಿದ್ದರು.
ನೆಕ್ಸ್ಟ್
ಆರೋಪಿತನು ಮೃತ ಅರ್ಜುನ್ಗೆ ಕಾಮ ಕತ್ತಿಯಿಂದ ಕಿವಿಯ ಹತ್ತಿರ ಹೊಡೆದು ಗಾಯಪಡಿಸಿರುತ್ತಾನೆ. ನಾನು ಕೂಡ ಎದುರು ಓಡಿ ಮನೆ ಕಡೆಗೆ ಬಂದಿರುತ್ತೇನೆ. ಆರೋಪಿ ಹೊಡೆದಿದ್ದರಿಂದ ಅರ್ಜುನ್ ಮೃತಪಟ್ಟಿರುತ್ತಾನೆ. ನಾನು ಚಾಸ 13, 15 ಇತರರು ಘಟನೆಯನ್ನು ನೋಡಿರುತ್ತೇವೆ. ಇವರು ಮೂರೇ ಜನಗಳು.
ಚಾಸ 13 examined as
PW ಮಾಡಿಲ್ಲ. ಈಸ್ ನೋಡಿದ್ವಿ.
ಚಾಸ
13 ಇಲ್ಲ.
not examined.
Not ex.
ಚಾಸ 15
ಚಾಸ PW8.
PW8.
ಕಾಮಕತ್ತಿ ನೋಡಿ ಗುರುತಿಸ ಅದನ್ನು ಈಗಾಗಲೇ ಮುದ್ದೆಮಾಲು 1 ಎಂದು ಗುರುತಿಸಲಾಗಿದೆ. ಪೊಲೀಸರು ನನ್ನನ್ನು ವಿಚಾರಣೆ ಮಾಡಿ ಹೇಳಿಕೆ ಮಾಡಿಕೊಂಡಿಲ್ಲ. He turned hostile witness in that time. ಪಾರ್ಟಿ ಸವಾಲು. ಕಾಮಕತ್ತಿಯಿಂದ ಹೊಡೆದರಿಂದ ಮೃತ ಅರ್ಜುನ್ ನೆಲಕ್ಕೆ ಬಿದ್ದಿರುತ್ತಾನೆ ಎಂದರೆ ಸರಿ. ಆರೋಪಿತನು ಮೃತನ ಅಂಗಿಗೆ ಬೆಂಕಿ ಹಚ್ಚಿರುತ್ತಾನೆ. ಆದ್ದರಿಂದ ಮೃತನ ಅಂಗಿ ಪ್ಯಾಂಟ್ ಅರ್ಧಂಬರ್ಧ ಅಕ್ಕಪಕ್ಕದ ಹುಲ್ಲು ಸಹ ಸುಟ್ಟಿದ್ದನ್ನು ಸಹ ನಾನು ನೋಡಿರುತ್ತೇನೆ. ಪಾರ್ಟಿ ಸವಾಲು. ಮೃತ ಅರ್ಜುನ್ ಮನೆ ನಮ್ಮ ಮನೆ ಎಷ್ಟು ದೂರ ಇದೆ ಎಂದರೆ ಸಮೀಪ ಇರುತ್ತದೆ. ನಮ್ಮ ಮನೆ ಮತ್ತು ಅರ್ಜುನ್ ಮನೆ 7-8 ಮನೆಗಳ ಅಂತರ ಇರುತ್ತದೆ. ನಮ್ಮ ಊರಿನಲ್ಲಿ ಯಾರಾದರೂ ತೀರಿಕೊಂಡಿದ್ದರೆ ಮೃತ ಅರ್ಜುನನಿಗೆ ಕರೆಯುತ್ತಿದ್ದರು. ಗುಂಡಿ ತೊಡಲು ಇಬ್ಬರು ಬೇಕಾಗುತ್ತದೆ. ರವಿಚಂದ್ರ ಲವಟೆ ಅವರ ಶವ ಸಂಸ್ಕಾರ ಅವರು ತೀರಿಕೊಂಡ ದಿವಸ ಮಾಡಿರುತ್ತಾರೋ ಅಥವಾ ಮರುದಿವಸ ಮಾಡಿರುತ್ತಾರೆ ಅಂದ್ರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ರವಿಚಂದ್ರ ಲವಟೆ ಅವರ ಶವ ಸಂಸ್ಕಾರಕ್ಕೆ ಯಾರೂ ಹೇಳಿಲ್ಲ, ನಾನೇ ಹೋಗಿದ್ದೇನೆ. ರವಿಚಂದ್ರ ಲವಟೆ ಅವರ ಸುಟ್ಟ ಜಾಗಕ್ಕೂ ನಮ್ಮ ಮನೆಗೂ ಸ್ವಲ್ಪ ದೂರ ಇರುತ್ತದೆ. ನಾವು ಸ್ಥಳಕ್ಕೆ ಹೋಗಿದಾಗ ಬಹಳ ಜನರು ಇದ್ದರು. ಮೃತ ಅರ್ಜುನ ನಾವು ಅಲ್ಲಿಗೆ ಹೋಗುವ ಪೂರ್ವದಲ್ಲಿ ಹೋಗಿದ್ದ, ಅಲ್ಲೇ ಇದ್ದ. ಮೃತ ಅರ್ಜುನ್ ಹಾಗೂ ಆರೋಪಿ ಇಬ್ಬರು ಜೊತೆಯಲ್ಲಿ ಸ್ಥಳಕ್ಕೆ ಹೋಗಿರುತ್ತಾರೆ. ಸ್ಥಳಕ್ಕೆ ಹೋಗಿರ್ತಾರೆ ಅಂತ ಹೇಳ್ತಾನೆ. ಅಲ್ಲಿ ಅವರು ಮದರ್ ಏನದಪ್ಪ ಅಂದ್ರೆ ಒಂದು 11:30 ಗಂಟೆಗೆ ಹೋಗ್ಯಾನ ಮನೆ ಅಂತ ಮದರ್ ಹೇಳ್ತಾರೆ. PW1 ಇವರಿಬ್ರು ಜೊತೆಯಲ್ಲೇ ಹೋಗಿದ್ದಾರೆ ಅಂತ ಇವ್ರು ಹೇಳ್ತಾರೆ. ರವಿಚಂದ್ರ ಲವಟೆ ಅವರ ಅಂತ್ಯ ಸಂಸ್ಕಾರ ಮಾಡಿರುತ್ತಾರೆ ನನಗೆ ಹೇಳಲು ಬರುವುದಿಲ್ಲ. ಆರೋಪಿ ಏನು ಕೆಲಸ ಮಾಡುತ್ತಿರಲಿಲ್ಲ, ತಿರುಗಾಡುತ್ತಾ ಇದ್ದ. ಸದರಿ ರವಿಚಂದ್ರ ಅವರ ಸಂಬಂಧಿಕರು ಮೃತ ಅರ್ಜುನನಿಗೆ ಎಷ್ಟು ಹಣ ಕೊಡುತ್ತಾರೆ ನಾನು ನೋಡಿಲ್ಲ. ಮೃತ ಅರ್ಜುನ ಸರಾಯಿ ಕುಡಿಯುವ ಅಭ್ಯಾಸ ಇತ್ತು. ಆ ದಿವಸ ಮೃತ ಅರ್ಜುನ ಹೆಚ್ಚಿಗೆ ಕುಡಿದಿದ್ದ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಶವಕ್ಕೆ ಬೆಂಕಿ ಹಚ್ಚಿದ ಮೇಲೆ ಸಂಬಂಧಿಕರು ಹೋಗುತ್ತಾರೆ. ಅವರ ಮನೆಯವರು ಸ್ವಲ್ಪ ದೂರದಲ್ಲಿ ನಿಂತು ಹೋಗುತ್ತಾರೆ. ಮೃತ ಅರ್ಜುನ ಅಲ್ಲೇ ಇದ್ದ, ಬೆಂಕಿ ಸರಿಪಡಿಸುತ್ತಿದ್ದ. ಮೃತ ಅರ್ಜುನ ಕುಡಿಯುತ್ತ ಆತ ಆಯ ತಪ್ಪಿ ಬೆಂಕಿಗೆ ಬಿದ್ದಿರುತ್ತಾನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆತ ಬೆಂಕಿ ಹತ್ತಿದ ಮೇಲೆ ಕಟ್ಟೆ ಕಡೆಗೆ ಬಂದಿರುತ್ತಾನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಅಲ್ಲಿ ಗಿಡಗಳು ಕಡಿದ ಗುಂಡುಗಳು ಇದ್ದು ಅದರ ಮೇಲೆ ಮೃತ ಅರ್ಜುನ್ ಬಿದ್ದು ಪಡಿಸಿಕೊಂಡಿದ್ದ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಈ ಅಡಕ್ಟಿಂಗ್ ದಿ alcohol your lordship disease. PW8, your lords.
8.
Deepak. CW15. ನನಗೆ PW1 ಗೊತ್ತು, PW1 ಇವಳ ಗಂಡ ಅಮೃತ ಅರ್ಜುನ್ ಗೊತ್ತು, ನನ್ನ ಹಾಗೂ PW1 ರವರ ಊರು ಜನವಾಡ ಇರುತ್ತದೆ. ನನಗೆ CW13, PW7, CW16 ಗೊತ್ತು. ಆರೋಪಿ ಗೊತ್ತು, ಮೃತ ಅರ್ಜುನ್ ಈತನು ಉಪ್ಪಾರ ಕೆಲಸ ಹಾಗೂ ಊರಿನಲ್ಲಿ ಯಾರಾದರೂ ಸತ್ತರೆ ಕುಣಿ ತೆಗೆಯಲು, ಹೂಳಲು, ಸುಡಲು ಹೋಗುತ್ತಾನೆ. ಆರೋಪಿತನು ಮೃತನ ಅರ್ಜುನನ ಮಗ. ಆರೋಪಿಯ ಊಟ ಮಾಡಿ ಯಾವುದೇ ಕೆಲಸ ಮಾಡುತ್ತಿರಲಿಲ್ಲ. ನಮ್ಮ ಊರು ರವಿಚಂದ್ರ ಲೌಟೆ ಗೊತ್ತು, ಅವರು ಸುಮಾರು ಈಗ ಡಿಸೆಂಬರ್ 2015ರಲ್ಲಿ ಮೃತಪಟ್ಟಿರುತ್ತಾರೆ. ಸದರಿ ರವಿಚಂದ್ರ ಲೌಟೆ ಮೃತಪಟ್ಟಿದ್ದು, ಅವರ ಶವ ಸುಡಲು ಮೃತ ಅರ್ಜುನ್ ಹೋಗಿದ್ದು, ಆಗಾಗ ಆರೋಪಿಸ ಆತನ ತಂದೆ ಜೊತೆ ಶವ ಸುಡಲು ಹೋಗುತ್ತಾ. ನನಗೆ ಖಚಿತ ಸಮಯ ಗೊತ್ತಿಲ್ಲ. ಮಧ್ಯಾಹ್ನ 1ರಿಂದ 1:30 ಗಂಟೆ ಮೇಲಾಗಿತ್ತು. ಅವ್ರು 3-4 ಗಂಟೆಗೆ ಅಲ್ಲಿ ಜಗಳ ಆಡ್ತಾ ಇದ್ರು, ದುಡ್ಡಿನ ವಿಷಯ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ. 1:30 ಗಂಟೆಗೆ ಮೇಲಾಗಿತ್ತು ಅಂತ ಇವ್ರು ಹೇಳ್ತಾರೆ. ನನಗೆ ಮೇಲಾಗಿತ್ತು. ಆರೋಪಿತನು ಮೃತ ಅರ್ಜುನ್ ಗಲಾಟೆ ಮಾಡಿಕೊಡುತ್ತಿದ್ರು. ಏಕೆ ತಕರಾರು ಮಾಡಿಕೊಳ್ತಿದ್ರು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಆರೋಪಿತನು ಅರ್ಜುನ್ ಪ್ರಸಾದನಿಗೆ ಕಿವಿ ಹತ್ತಿರ ಕಾಮಕತ್ತಿಯಿಂದ ಹೊಡೆದು ಗಾಯಪಡಿಸಿರುತ್ತಾನೆ. ನಂತರ ಆರೋಪಿತನು ಮೃತನ ಬಟ್ಟೆಗೆ ಬೆಂಕಿ ಹಚ್ಚಿರುತ್ತಾನೆ. ನಾನು ಚಾಸ 13, PW7 ಚಾಸ 16 ಘಟನೆಯನ್ನು ನೋಡಿರುತ್ತೇವೆ. CW13 and PW7, CW16. These are the eyewitness of this case, Your Honor. CW13, PW7 and CW16.
PW7, PW8 ಮತ್ತೆ ಯಾರು?
CW16.
CW ಬೇಡ, ಈಗ ಎಕ್ಸಾಮಿನ್ ಆದವರನ್ನು ಹೇಳಿ. PW7 and 8.
Chandrakanth is not examined.
PW7 and 8.
Yes.
Eyewitness.
Eyewitness.
ಮತ್ತೆ ಯಾರು ಲಾಸ್ಟ್ ಸೀನ್ ಯಾರಿದ್ದಾರೆ? ತಾಯಿ ಇದ್ದಾರಾ?
ತಾಯಿ ಇದ್ದಾರೆ. PW1 ನೀವು. PW1. ತಾಯಿ PW1. ಇವ್ರು ಐ ವಿಟ್ನೆಸ್ ಅಲ್ಲ, ಇವರು ಐ ವಿಟ್ನೆಸ್ ಅಲ್ಲ, ಲಾಸ್ಟ್ ಸೀನ್.
ವಿಟ್ನೆಸ್ ಅಲ್ಲ, ಲಾಸ್ಟ್ ಸೀನ್. ಏನ್ ಹೇಳ್ತಾರೆ?
ಆರೋಪಿ ನನ್ನ ಮಗ, ಚಾಸ 10 ನನ್ನ ಮಗ, ಚಾಸ 11 ನನ್ನ ಮಗಳು, ಚಾಸ 12 ನನ್ನ ಗಂಡನ ತಂಗಿ ನಾದನಿ. ನನಗೆ ಚಾಸ 13ರಿಂದ 16 ಗೊತ್ತು. ಚಾಸ 17 ನನ್ನ ಮಲಮಗ, ಚಾಸ 18 ನನ್ನ ಮಗ, ಚಾಸ 19 ಮೀನಾಕ್ಷಿ ನನ್ನ ಮಲಮಗಳು, ಚಾಸ 20 ನನ್ನ ಮಗಳು, ಚಾಸ 21, 22 ಗೊತ್ತು. All are the relative witness for your last. Only except 21 and 22. ಮೃತ ಗಂಡ ಅರ್ಜುನ ಪ್ರಸಾದ್ ಗೂಡೆ ಕಟ್ಟುವ ಕೆಲಸ ಮತ್ತು ಊರಿನಲ್ಲಿ ಯಾರಾದರೂ ಕುಣಿ ತೊಡುವುದು, ಶವ ಸುಡುವ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದ. ಅದಕ್ಕೆ ಮೃತನಿಗೆ ಹಣ 500ರಿಂದ 600 ಕೊಡುತ್ತಿದ್ದು. ಆರೋಪಿ ಯಾವುದೇ ಕೆಲಸ ಮಾಡುತ್ತಿರಲ್ಲ. ತಂದೆ ಜೊತೆಗೆ ಯಾವಾಗಲೂ ಹೆಣ ಸುಡಲು ಹೋಗುತ್ತಿದ್ದ. ಸುಮಾರು 1 ವರ್ಷ 4 ತಿಂಗಳ ಹಿಂದೆ ನಮ್ಮ ಊರಿನಲ್ಲಿ ರವಿಚಂದ್ರ ಲೌಟೆ ಅವರ ಮೃತಪಟ್ಟಿದ್ದರು. ರವಿಚಂದ್ರ ಲೌಟೆ ಮೃತಪಟ್ಟಿದ್ದರಿಂದ ಅವನ ಶವ ಸುಡಲು ಮುಂಜಾನೆ 11 ಗಂಟೆಗೆ ನಮ್ಮ ಮನೆಗೆ ಬಂದು ನನ್ನ ಗಂಡನಿಗೆ ಶವ ಸುಡಲು ಹೇಳಿದರು. ನನ್ನ ಗಂಡ ಅವರು ಹೇಳಿದ ನಂತರ ಶವ ಸುಡಲು ಹೋಗಿರುತ್ತಾರೆ. ಆಗ ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಚಾಸ 11 ನನ್ನ ಮಗಳು, ಪಕ್ಕದ ಮನೆಯಲ್ಲಿ ನನ್ನ ನಾದಿನಿ. ನಂತರ ಸುಮಾರು ಅರ್ಧ ಗಂಟೆ ನಂತರ, ಅಂದರೆ 11:30 ಗಂಟೆಗೆ ಆರೋಪಿತನು ನಮ್ಮ ಮನೆಗೆ ಬಂದು, accused came to his house at 11:30. ನನ್ನ ತಂದೆ ಎಲ್ಲಿಗೆ ಹೋಗಿದನು ಎಂದು ಕೇಳಿದನು. ರವಿಚಂದ್ರ ಲೌಟೆ ಮೃತಪಟ್ಟಿರುತ್ತಾನೆ, ಅವನ ಶವ ಸಂಸ್ಕಾರಕ್ಕೆ ಹೋಗಿದಾಗೆ ನಾವು ತಿಳಿಸಿರುತ್ತೇವೆ. ಆತನು ಸಹ ಶವ ಸಂಸ್ಕಾರಕ್ಕೆ ಹೋಗುತ್ತೇನೆ ಎಂದು ಹೇಳಿ ಹೋಗಿರುತ್ತಾನೆ. ರವಿಚಂದ್ರ ಲೌಟೆ ಅವರ ಶವ ಸಂಸ್ಕಾರ ಮಧ್ಯಾಹ್ನ 12:30 ಗಂಟೆಗೆ ಆಗಿರುತ್ತದೆ. ಶವ ಸಂಸ್ಕಾರ ಆದ ನಂತರ ಶವ ಸಂಸ್ಕಾರ ಹೋದ ಜನರು ಮರಳಿ ಊರಿಗೆ ಬಂದಿರುತ್ತಾರೆ. ನನ್ನ ಗಂಡ ಬರಲಿಲ್ಲ ಎಂದು ನಾನು ದಾರಿ ನೋಡಿರುತ್ತೇನೆ. ಮಧ್ಯಾಹ್ನ 1 ಗಂಟೆಗೆ ಚಾಸ 16 ಚಂದ್ರಕಾಂತ್ ರವರೊಂದಿಗೆ ಇನ್ನೂ 3 ಜನರು ನಮ್ಮ ಮನೆಗೆ ಬಂದರು. ನನ್ನ ಗಂಡ ಅರ್ಜುನ್ ರವರು ಲೌಟೆ ಶವ ಸಂಸ್ಕಾರ ಮಾಡಿದ ಹೊಲದಲ್ಲಿ ಬಿದ್ದಿರುತ್ತಾನೆ ಎಂದು ಹೇಳಿರುತ್ತಾರೆ. ಇವ್ರು 1 ಗಂಟೆಗೆ ಅಂತ ಇವ್ರು ಹೇಳ್ತಾರೆ. 1 ಗಂಟೆಗೆ ಇವ್ರ ಮನೆಯಲ್ಲಿ ಇದ್ದಾನೆ ಐ ವಿಟ್ನೆಸ್. ಹೊಲದಲ್ಲಿ ಬಿದ್ದಿರ್ತಾನೆ ಅಂತ ಹೇಳಿರ್ತಾರೆ. ನಾನು ಸ್ಥಳಕ್ಕೆ ಹೋಗಿರುತ್ತೇನೆ. ನಂತರ ಚಾಸ 11 ನನ್ನ ಮಗಳು ಸ್ವರೂಪ, ಚಾಸ 12 ಮುಕ್ತಮ್ಮ, ಚಾಸ 10 ರಾಹುಲ್ ಲೌಟೆ ಅವರ ಹೊಲಕ್ಕೆ ಬಂದರು. ನನಗೆ ನನ್ನ ಮಗ ಆರೋಪಿ ನನ್ನ ಗಂಡನಿಗೆ ಕುತ್ತಿಗೆ ಹೊಡೆದು ಗಾಯಪಡಿಸಿ ಕೊಲೆ ಮಾಡಿ ಶವ ಹುಲ್ಲು ಹಾಕಿ ಸುಟ್ಟಿರುತ್ತಾನೆ ಎಂದು ಗೊತ್ತಾಗಿರುತ್ತದೆ. ಬೇರೆ ಜನರು ಸಹ ಬಂದು ನೋಡ್ತಿದ್ದರು. ನಂತರ ನಾನು ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಹೋಗಿ ದೂರು ನೀಡಿರುತ್ತೇನೆ. ಸದರಿ ದೂರು ನೋಡ್ತಿದ್ದರು. ಅದನ್ನು ನೀಪಿ 1 ಎಂದು, ಸಾಕ್ಷಿ ಸಹಿಯನ್ನು ನೀಪಿ 1A ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಪೊಲೀಸರು ಬಂದು ಸ್ಥಳಕ್ಕೆ ಬಂದು ನನ್ನ ಸಮಕ್ಷಮ ಪಂಚನಾಮ ಮಾಡಿರುತ್ತಾರೆ. ನಂತರ ನನ್ನ ಗಂಡ ಅರ್ಜುನ್ ತೀರಿಕೊಂಡ 3 ದಿನಗಳ ನಂತರ ಠಾಣೆಗೆ ಕರೆಸಿ ಒಂದು ಕಾಮಕತ್ತಿ ತೋರಿಸಿ ಆರೋಪಿಯಿಂದ ಸದರಿ ಕಾಮಕತ್ತಿ ವಶಪಡಿಸಿಕೊಂಡಿದ್ದು ಅದರಿಂದ ಹೊಡೆದಾಗಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಪಾಟಿ ಸವಾಲ್ ಇವರ ನನಗೆ ಓದಲು ಬರಲು ಬರುವುದಿಲ್ಲ. ನನ್ನ ಗಂಡ 20 ರಿಂದ 30 ವರ್ಷದಿಂದ ಹೆಣ ಸುಡುವ ಕೆಲಸ ಮಾಡುತ್ತಾನೆ. ಹೆಣ ಸುಡುವುದು ನಮ್ಮ ಕುಟುಂಬಕ್ಕೆ ಅನುವಂಶವಾಗಿ ಬಂದಿರುವುದಿಲ್ಲ. ರವಿಚಂದ್ರ ಲೌಟಿ ಅವರು 6/12/2015 ತೀರಿಕೊಂಡಿರುತ್ತಾರೆ. ಇವರು 6 ಅವ್ರು ಏನಪ್ಪ ಅಂದ್ರೆ ಎಂದು ತೀರ್ಕೊಂಡಿದ್ದಾರೆ, ಯಾವುದೇ 7ನೇ ತಾರೀಕು ತೀರ್ಕೊಂಡಿದ್ದಾರೆ, 6ನೇ ತಾರೀಕು ತೀರ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. ಇವರು CW ದಿಲೀಪ್ ಅಂಡ್ ದೀಪಕ್. ಇವ್ರು ಏನದ 6/12/2012 ತೀರಿಕೊಂಡಿರ್ತಾರೆ ಅಂತ ಇವ್ರು ಹೇಳ್ತಾರೆ. ಈ ಪಾಟಿ ಸವಾಲಿನಲ್ಲಿ CW1 says wife of the deceased. ಅವರ ಶವ ಸಂಸಾರ 6ನೇ ದಿವಸ ಆಗಿರುತ್ತದೆ. ಅವರ ಸತ್ತ ದಿವಸ ಜಾಗರಣೆಗೆ ನನ್ನ ಗಂಡ ಹೋಗಿರುವುದಿಲ್ಲ. ಸದರಿ ರವಿಚಂದ್ರ ಅವರವರು ತೀರಿಕೊಂಡ ಕಾರಣ ವಿಷಯ ತಿಳಿದುಕೊಂಡು ಅವರು ಬೇರೆ ಕಡೆಗೆ ಕೆಲಸಕ್ಕೆ ಹೋಗುವುದಿಲ್ಲ. ಹೆಣ ಬೆಂಕಿ ಇಟ್ಟ ಮೇಲೆ ಕೆಲವರು ಮಾತ್ರ ಅಲ್ಲಿ ಇರುತ್ತಾರೆ, ಉಳಿದವರು ಅಲ್ಲಿಂದ ಹೊರಟು ಹೋಗಿರುತ್ತಾರೆ. ನನ್ನ ಗಂಡ ಎಲ್ಲರೂ ಹೋದ ಮೇಲೆ ಅಲ್ಲಿ ಇದ್ದ ಆಯತಪ್ಪಿ ಬೆಂಕಿಯ ಮೇಲೆ ಬಿದ್ದ ಕಾರಣ ಮೈಗೆ ಹತ್ತಿಕೊಂಡಿರುತ್ತದೆ. ನನ್ನ ಗಂಡನಿಗೆ ಬೆಂಕಿ ಹತ್ತಿಕೊಂಡಿದ್ರಿಂದ ಆತ ಹಾಕಿಕೊಂಡು ಬಟ್ಟೆಗಳು ಸಹ ಸುಟ್ಟಿರುತ್ತವೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಚಾಸ 16 ಚಂದ್ರಕಾಂತ್ ಪೌದ್ರ ಅವರು ನಿನ್ನ ಗಂಡ ಅವಸರ ನಮ್ಮ ಮನೆಗೆ ಬಂದು ನಿನ್ನ ಗಂಡ ಲೌಟಿಯವರ ಹೊಲದಲ್ಲಿ ರಕ್ತ ಗಾಯವಾಗಿ ಬಿದ್ದಿರುತ್ತಾನೆ ಎಂದು ಯಾವ ಕಾರಣಕ್ಕೆ ತೀರಿಕೊಂಡಿರ್ತಾನೆ ಎಂದು ಗೊತ್ತಾಗಿಲ್ಲ ಎಂದು ಹೇಳಿ ನೀಪಿ 1 ಫಿರ್ಯಾದಿಯಲ್ಲಿ ಬರೆದಿರುತ್ತದೆ ಎಂದರೆ ಸರಿ. Chandrakant is a eyewitness, important eyewitness of this case, your lordship. He is not examined. ಇವನೇ ಇತರ ಜೊತೆ ನಾನು ಇನ್ನು 2-3 ಜನ ಇದ್ದೇವೆ ಅಂತ ಪ್ರೆಸೆಂಟ್ಸ್ ಇದ್ದೇವೆ ಅಂತ ಇನ್ನು ಇವನೇ ಹೇಳ್ತಾನೆ ಚಂದ್ರಕಾಂತ್ is not examined. And other witnesses of this case are related witnesses.
7 and 8 ಐವಿಟ್ನೆಸ್ ಇದ್ದಾರಲ್ವಾ, ಏನಕ್ಕೆ ಅವರನ್ನು ಡಿಸ್ಬಿಲೀವ್ ಮಾಡಬೇಕು? ಅವರ ಎವಿಡೆನ್ಸ್ ಅನ್ನು ಏನಕ್ಕೆ ಕನ್ಸಿಡರ್ ಮಾಡಬಾರ್ದು? 7 and 8 ಅವರ ಐವಿಟ್ನೆಸ್ ಅಲ್ವಾ ಇಬ್ರು ಕೂಡ.
PW7 ಹೇಳ್ತಿದ್ರು ಸರ್. PW7 ಮೃತ ಅರ್ಜುನ ಸರಾಯಿ ಕುಡಿಯುವ ಅಭ್ಯಾಸ ಇತ್ತು ಎಂದರೆ ಸರಿ.
ಸರಿ
ಅಂದ್ರೆ ಕುಡಿದವನು ಕೂಡ ಒಳಗ ಬಿದ್ದಿರ್ಬೋದು ಸರ್. ನಿಶೆ ಹಾಕಿ ಆಲ್ಕೋಹಾಲಿಕ್ ದಲ್ಲಿ ಕಂಡೀಷನ್ ಅವ್ನು ಸ್ಟೇಟ್ ಆಫ್ ಮೈಂಡ್ ಏನದ ಅವ್ನು ಸರಿ ಇರ್ಲಕ್ಕಿಲ್ಲ.
ಡಾಕ್ಟರ್ ಏನ್ ಹೇಳಿದ್ದಾರೆ? ಅವನಿಗೆ ಗಾಯ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. 3 injuries ಗಾಯ ಆಗಿದೆ ಅಂತ ಹೇಳಿದಾರಲ್ವಾ? ಗಾಯ ಹೆಂಗಾಯ್ತು? ಗಾಯ ಹೇಗಾಯ್ತು? ಬಿದ್ರೆ ಗಾಯ ಇಲ್ಲ ಆಗುತ್ತೆ ಅಂತದ್ದು. ಅವನಿಗೆ ಗಾಯ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಸತ್ತದ್ದು ಡ್ಯೂ ಟು ಮಲ್ಟಿಪಲ್ ಇಂಜುರೀಸ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದು ಯಾರು ಮಾಡಿದ್ದು? ಐ ವಿಟ್ನೆಸ್ ಇದ್ದಾರಲ್ವ 7 and 8. ಮತ್ತೆ ನೀವು ಹೋಗಿದ್ದೀರಿ ಅಂತ ನಿಮ್ಮ ತಾಯಿಯವರು ಹೇಳ್ತಾರಲ್ವಾ PW1 ನೀವು ಜೊತೆಗೆ ಹೋದದ್ದು ಹೌದಂತ. ಜೊತೆಗೆ ಹೋಗಿದ್ದೀರಿ, ಬರ್ತ ಅವನಿಗೆ ಹೊಡೆದಿದ್ದೀರಿ ಅಂತ 7 and 8 ಹೇಳ್ತಾರೆ.
ಈಗ ಆಲ್ಕೋಹಾಲಿಕ್ ಕಂಡೀಷನ್ ದಲ್ಲಿ ಅವ ಏನ್ ಮಾಡ್ತಾನ ಅಂತ ಗೊತ್ತಿರಲ್ಲ ಇವ್ರು.
ಯಾರು?
ಈಗ ಅವ ಹೀಸ್ ಕನ್ಸ್ಯೂಮಿಂಗ್ ದಿ ಡ್ರಿಂಕ್ಸ್. ಅವನೇ ಬಿದ್ದಾನೋ ಅಥವಾ ಐ ವಿಟ್ನೆಸ್ ಚಂದ್ರಕಾಂತ್ ಈಸ್ ನಾಟ್ ಎಕ್ಸಾಮ್, ಅವನೇ ನೋಡಿದ್ದಾನೆ ಅಂತ ಹೇಳ್ತಿದ್ದಾನೆ. ಚಂದ್ರಕಾಂತ್ ಇಸ್ ನಾಟ್ ಎಕ್ಸಾಮಿನ್. ಈ ಉಳಿದವ್ರು ಯಾರು? ಇವ್ರು ಐ ವಿಟ್ನೆಸ್ ಅಲ್ಲ, ಇವರು ದಿಲೀಪ್ ಇವ್ರು ಐ ವಿಟ್ನೆಸ್ ಅಲ್ಲ, ಇವರು.
ನೀವೇನ್ ಕ್ರಾಸ್ ಮಾಡಿದ್ದೀರಿ ಡಾಕ್ಟರ್ ಅಲ್ಲಿ? ಡಾಕ್ಟರ್ ಅನ್ನು PW14 ಎವಿಡೆನ್ಸ್ ಓದಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಕೇಳಿದ್ದೀರಿ ಹಂಗೇನಾದ್ರು? ಅವು ಬಿದ್ದು ಬಿಟ್ಟಿಂತ ಗಾಯಗಳಾಯ್ತಂತ?
PW14
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಅವ್ರದ್ದು
ಸುನಿಲ್, ಮೃತದೇಹದ ಮೇಲೆ 3 ಗಾಯಗಳು ಕಂಡು ಬಂದವು. ಒರಟಾದ ಆಯುಧಗಳಿಂದ ಹೊಡೆದಿದ್ದರಿಂದ ಯಾವುದೇ ಗಾಯಗಳು ಕಂಡು ಬಂದಿಲ್ಲ. ಆಯುಧದಿಂದ ಹೊಡೆದಿಲ್ಲ ಅಂತ ಇವರೇ ಹೇಳ್ತಾರೆ. ವೆಪನ್ ಇಸ್ ಅದೇ ಚೂಪಾದ ಸರ್, ಕಂಡು ಬಂದಿಲ್ಲ. ಸದರಿ ಮೂರು ಗಾಯಗಳು ತೀವ್ರ ಸ್ವರೂಪದ ಗಾಯಗಳಾಗಿದ್ದವು. ಸದರಿ ಗಾಯಗಳು ಭಾರವಾದ, ಹರಿತವಾದ, ಚೂಪವಾದ ಆಯುಧಗಳಿಂದ ಹೊಡೆದಾಗ ಗಾಯಗಳು ಕಂಡು ಬರುತ್ತವೆ. ನೀಪಿ 10ರಲ್ಲಿ ಯಾವ ಆಯುಧಗಳಿಂದ ಹೊಡೆದಾಗ ಗಾಯಗಳು ಆಗುತ್ತವೆ ಎಂಬ ಬಗ್ಗೆ ಆಯುಧಗಳಿಂದ ನಮೂದು ಮಾಡಿಲ್ಲ ಎಂದರೆ ಸರಿ.
ಒಪಿನಿಯನ್ ಕೊಟ್ಟಿಲ್ಲ. ನೆಕ್ಸ್ಟ್
ಚೂಪಾದ ವಸ್ತುಗಳ ಮೇಲೆ ಬಿದ್ದಾಗ, ಹಿಂಭಾಗಕ್ಕೆ ಬಿದ್ದಾಗ ಆಗುವ ಸಾಧ್ಯತೆ ಇರುತ್ತದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಯಾವ ಆಯುಧಗಳಿಂದ ಹೊಡೆದಾಗ ಆಗುತ್ತದೆ ಎಂದು ನಮೂದು ಮಾಡಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಅದರಿಂದ ಹೊಡೆದರೆ ಇವರಿಗೆ ಈ ರೀತಿ ಗಾಯಗಳಾಗ್ತವಂತ ಬರೆದಿಲ್ಲ ಅಂತ ಇವರು ನಮೂದು ಮಾಡಿ. ನಾಟ್ disclose the injuries. ಗಾಯಗಳು ಎಷ್ಟು ಗಂಟೆ ಪೂರ್ವದಲ್ಲಿ ಆಗಿರುತ್ತೆ ಅಂತ ನಮೂದು ಮಾಡಿದಿಲ್ಲ ಅಂದರೆ ಸರಿ. ಎಷ್ಟು ಗಂಟೆ ಪೂರ್ವದಲ್ಲಿ ಆಗಿದ್ದಾವ ಅಂದ್ರೆ ಅದನ್ನು ನಮೂದು ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಶವವನ್ನು ಮುಟ್ಟಿ ನೋಡಿ ತಂಪು ಇರುತ್ತದೆ ಎಂದು ಹೇಳಿರುತ್ತೇನೆ. ಗಾಯಗಳ ಅಳತೆಯನ್ನು ಟೇಪ್ ಮುಖಾಂತರ ಮಾಡಿರುತ್ತೇನೆ. ಶವವನ್ನು ಬಿಗಿತದಿಂದ ಕೂಡಿತ್ತು. ನಿಯಮ 11 ಶವ ಪರೀಕ್ಷೆ ಮಾಡುವ ಕಾಲದಲ್ಲಿ ಅಳವಡಿಸಿಕೊಂಡಿರುತ್ತೇನೆ. ಬಾಡಿ ಅದರ್ ಬಾಕ್ಸ್ ನಲ್ಲಿ ಯಾವುದು ಅವನಿಗೆ ಇದು ಆಗಿಲ್ಲ, ಇನ್ಜುರೀಸ್ ಆಗಿಲ್ಲ. ಕಿವಿ ಕೆಳಗಡೆ ಆಗಿದ್ದ ಅಂತ ಎಲ್ಲರೂ ಅದೇ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಕಿವಿ ಕೆಳಗಡೆ ಹೊಡೆದಿದ್ದಾನೆ, ಎಡಗಿವಿ ಕೆಳಗಡೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಆಲ್ ವಿಟ್ನೆಸಸ್
ಏನ್ ಹೇಳ್ತಾರೆ ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ ಅಲ್ಲಿ? ಎಲ್ಲಿ ಅಂತ ಹೇಳ್ತಾರೆ? ಎಲ್ಲಿ ಇಂಜುರಿ ಆಗಿದೆ ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ ಪ್ರಕಾರ? ಅಪ್ಪರ್ ಪಾರ್ಟ್ ಆಫ್ ನೆಕ್, ಪೇಜ್ 28ಕ್ಕೆ ಬನ್ನಿ, 28ಗೆ. ಸಿಕ್ತಾ PM?
ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ ರಿಪೋರ್ಟ್ ಇದೆ.
ಫಾಲೋವಿಂಗ್ ಇಂಜುರೀಸ್ ಆರ್ ಸೀನ್ ಅಂತ ಇದೆಯಾ, ಓದಿ.
Incised wound over occipital region, left side and upper part of neck. Oblique of size 16 centimeter into 2 centimeter.
ಅಲ್ಲೇ ಬರುತ್ತೆ, ಅವರು ಹೇಳಿದಲ್ಲೇ ಬರುತ್ತೆ.
Inside wound on left side of neck, upper part and mandibular region, horizontal of size 11 centimeter into 4 centimeter. X bone, 10 bone deep margins, clean cut and reddish on dissection, jugular vein.
ಸಿಕ್ಕಿಲ್ಲ ಅದು ಏನು ವೆಪನ್? What is the weapon?
That is Kamkati in the sense, my lords, it's a just like dagger, my lords.
ಕುಡಿಗಲ್ ಅಂತಾರಲ್ಲ ಸರ್, ಕುಡಿಗಲ್.
No, ಕುಡಿಗಲ್ ಅಲ್ಲ. ಕುಡಿಗಲ್ ಹೀಗಿರುತ್ತೆ.
ಕುಡುಗುಲಿ ಸಿಕ್ಕಲ್ಲ?
No, sickle is no.
ಕುಡುಗೋಲೆ ಅಂತ.
That is no. Just like dagger, it's.
ಇವ್ರು ಹೇಳ್ತಾರೆ ಸರ್ 4 ಇಂಚ್ ಇರುತ್ತೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಬೋತ್ ಎಡ್ಜ್ ಶಾರ್ಪ್ ಇತ್ತು ಅದಲ್ಲ.
ಹಾ ಅದೇ ಸ್ವಲ್ಪ ಇದು ಹಿಂಗ್ ಬಾಗಿದ್ದಿರುತ್ತೆ ಸರ್ ಸೇಮ್
ಅದೇ ಅದೇ
ಲಾಂಗ್ ಅಂತ ಅಂತಾರಲ್ಲ
ಕತ್ತಿ ಅಂತ ಹೇಳುದು.
ಲಾಂಗ್ ಹಾ ಸೇಮ್
ಕತ್ತಿ ಅದು ಬೇರೆ
in
ಇದು ಕುಡುಗಿಲ್ಲ
films
ಸರ್,
they keep
ಕುಡುಗೋಲು.
in shirt
ಸಿಕಲ್ ಅಂದ್ರೆ ಕುಡುಗಲ್ ಅಂತ ಅರ್ಥ.
ಕುಡುಗೋಲ್ ಅದೇ.
ಹಾ ರೀ, ಅದು ಹಿಂಗಿರ್ತದೆ ಸರ್.
ಹುಡುಗಲ್ ಕಂಪ್ಲೀಟ್ ಇದೆಯಾ
ಅದು ದೊಡ್ಡದಿರ್ತದೆ ರೀ. ಇವ್ರು 4 ಇಂಚ್ ಅದಾವ ಅಂತ ಹೇಳ್ತಾರೆ ಸರ್ ಎವಿಡೆನ್ಸ್. 4 ಇಂಚಿನಿಂದ 6 ಇಂಚ್.
ಕಾಮಕತ್ತಿ ಎಸ್
ಇಲ್ಲಿ PW 16 ಎವಿಡೆನ್ಸ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್. ಜೂನಿಯರ್ ಇಂಜಿನಿಯರ್ ಸ್ಕೆಚ್ ಮ್ಯಾಪ್ ಮಾಡಿದ್ದಾರೆ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್. ಅಂದ್ರೆ ಅಲ್ಲಿಂದ ಪ್ಲೇಸ್ ಇಂದ ಅಫೆನ್ಸ್ ಆಗಿದ್ದ ಪ್ಲೇಸಿಗೆ ಎಷ್ಟು ದೂರ ಅದ ಅಂತ ಹೇಳ್ತಾರೆ ಇವ್ರು. ಅಂದ್ರೆ ಪೊಲೀಸರ ಮನವಿ ಮೇರೆಗೆ ನಮ್ಮ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಜಿನಿಯರ್ ಆದೇಶದ ಮೇರೆಗೆ ನಾನು ಗುನ್ನೆ ಸ್ಥಳಕ್ಕೆ ಭೇಟಿ ನೀಡಿದ್ದೇನೆ. ಗುನ್ನೆ ಸ್ಥಳವು PC ನೀಲಕಂಠ ತೋರಿಸಿದ್ದಾರೆ. ಸ್ಥಳಕ್ಕೆ ಭೇಟಿ ಕೊಟ್ಟ ಜಮೀನು ಸರ್ವೆ ನಂಬರ್ ಹೇಳಲು ಬರುವುದಿಲ್ಲ. ಅದು ಯಾರ ಹೆಸರಿಗೆ ಇರುತ್ತದೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಘಟನಾ ಸ್ಥಳವು ಜನವಾಡದಿಂದ 2-3 ಕಿಲೋಮೀಟರ್ ದೂರದಲ್ಲಿ ಇರುತ್ತದೆ. 2-3 ಕಿಲೋಮೀಟರ್ ಅವ ಅಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕಾದ್ರೆ 1 ಅವರ್ ಟೈಮ್ ಬೇಕಲ್ಲಿ ಇವ್ರ. 11ವರೆಗೆ ಇಲ್ಲೇನಪ್ಪ ಅಂದ್ರೆ ಮನೆಯಾಗಿದ್ದ ಅಂತ ಅವ್ರ ತಾಯಿ ಹೇಳ್ತಾರೆ.
ತಾಯಿ ಹೇಳ್ತಾರೆ 2 ಗಂಟೆಯ ಸಮಯಕ್ಕೆ ಆಗಿದೆ ಅಂತ.
11:30 ಗಂಟೆಗೆ ಮನೆಗೆ ಆರೋಪಿತನು ಬಂದನು.
ಹೌದು, ಇನ್ಸಿಡೆಂಟ್ ಆದ್ದು 2 ಗಂಟೆಗೆ ಅವರ ಪ್ರಕಾರ. 2 ಗಂಟೆಗೆ ಬಂದು ನಮಗೆ ಹೇಳಿದ ಅಂತ ಚಂದ್ರಕಾಂತ. ಇವ 11ವರೆಗೆ ಹೋಗಿದ್ದಾನೆ ಅಲ್ಲಿಗೆ.
ಅದೇ 11:30 ಈಗ 2-3 ಕಿಲೋಮೀಟರ್ ಹೋಗ್ಬೇಕಲ್ಲ ಸರ್.
ಅದೇ 1.5 ಗಂಟೆ ನಂತರ ಆದದ್ದು ಅಂತ ಇನ್ಸಿಡೆಂಟ್. 2 o'clockಗೆ ಇನ್ಸಿಡೆಂಟ್ ಆದ 2 ಗಂಟೆಗೆ. 11ವರೆಗೆ ಇವ ಮನೆಯಿಂದ ಹೋಗಿದ್ದಾನೆ, ಹೊರಟಿದ್ದಾನೆ. ಸೊ 1.5 ಗಂಟೆಯಲ್ಲಿ ಅಲ್ಲಿ ತಲುಪಿದ್ದಾನೆ. ಅವ ಬರ್ತಾ ಇರುವ
12:30 ಗಂಟೆಗೆ ಈಗ ಇವ್ರದ್ದು ಶವ ಸಂಸ್ಕಾರ ಆಗಿದೆ ಅಂತ ಅಕ್ಕಿನ ಹೇಳ್ತಾಳ್ರಿ ಮದರ್. ಸುಟ್ಟ ಶವ ಸಂಸ್ಕಾರ ಮಧ್ಯಾಹ್ನ 12:30 ಗಂಟೆಗೆ ಆಗಿರುತ್ತದೆ. ಹೌದು, ಚಂದ್ರಕಾಂತ್ ಲವಟಿಯದು 12:30 ಶವ ಸಂಸ್ಕಾರ ಆಗಿದೆ ಅಂತ ಮದರ್ PW 1 ಹೇಳಿದ್ದಾರೆ. 11:30 ಗಂಟೆಗೆ ಇವ್ ಮನೆಯಲ್ಲಿ ಇದ್ದ ಅಂತ ಹೇಳ್ತಾನೆ. 11:30 ಗಂಟೆಯಿಂದ 3 ಕಿಲೋಮೀಟರ್ ಹೋಗ್ಬೇಕಾದ್ರೆ 1 ತಾಸು 2 ತಾಸು ಬೇಕು ಇವ್ರು ಹೊಲಕ್ಕೆ ಹೋಗ್ಬೇಕಾದ್ರೆ.
ಬೇಕು. 12.5 ಗಂಟೆ ಅಲ್ಲಿ ತಲುಪಿದ್ದು. ಶವ ಸಂಸ್ಕಾರ ಆದ್ದು 12ವರೆಗೆ. ಇವ 11ವರೆಗೆ ಮನೆಯಿಂದ ಬಿಟ್ಟಿದ್ದಾನಲ್ವಾ. ಸೊ 1 ಗಂಟೆ ಅಲ್ಲಿ ತಲುಪಿದ್ದಾನೆ. 2 ಗಂಟೆಗೆ ಈ ಘಟನೆ ನಡೆದಿದೆ.
2 ಗಂಟೆ ಹಿಂದಿಲ್ಲ ಸರ್ ಇವ್ರು ನೋಡ್ರಿ.
2 ಗಂಟೆಗೆ ನನಗೆ ಚಂದ್ರಕಾಂತ್ ಬಂದು
1 ಗಂಟೆಗೆ 1 ಗಂಟೆಗೆ ಹೇಳಿ.
ಚಂದ್ರಕಾಂತ್ ಬಂದು
1 ಗಂಟೆಗೆ
ಹೇಳ್ತಾನೆ 2 ಗಂಟೆಗೆ ನನಗೆ ತಿಳಿಸಿದ್ರು ಅಂತ. ಎಷ್ಟೊತ್ತಿಗೆ ಆಗಿದೆ ಅಂತ ಯಾರು ಹೇಳ್ತಾರೆ? ಕಂಪ್ಲೇಂಟ್ ಪ್ರಕಾರ ನನಗೆ 2 ಗಂಟೆಗೆ ಬಂದು ಹೇಳ್ತಾರೆ ಅಂತ.
ಅದೇ ಇದು ಅವ್ರು ಇದರಲ್ಲಿ ಹೇಳಿಲ್ಲ.
In the 7, 8 says, my lords, the incident is said to have occurred in between 1 to 1:30.
1 to 1:30.
And 7 says it is 3 to 4. That is there. But PW1, what he is submitting is, PW1 has stated in chief examination that 1 gantege ante. She being a illiterate woman, my lords.
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳಿದಾಳೆ.
That is to be taken into consideration.
ಇಲ್ಲ ಸಾಬ್ ಇವರು ಅದರ್ ವಿಟ್ನೆಸಸ್ ಸೇಸ್ 3ರಿಂದ 4 ಗಂಟೆವರೆಗೆ ಜಗಳ ಆಡ್ತಿದ್ದಾರ ಅಂತ ಅವ್ರು ಹೇಳಿದ್ದಾರೆ ಇವ್ರು.
That is PW.
ನಾನು ಅವಾಗ 4 ಗಂಟೆ ಮತ್ತೆ ಅವ್ರು ಸತ್ತ ಮೇಲೆ ಅವ್ರು ಜಗಳ ಆಡೋ ಎಲ್ಲಿ ಕ್ವಶನ್ ಬರಲ್ಲ.
ಏನಾಗುತ್ತೆ, ಟೈಮಿಂಗ್ಸ್ ಎಲ್ಲ ವ್ಯತ್ಯಾಸ ಆಗುತ್ತೆ. 2 ವರ್ಷದ ನಂತರ ಎವಿಡೆನ್ಸ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದ.
ಹೌದು.
2 ವರ್ಷದ ನಂತರ ಅಲ್ವಾ ಇದು? ನಿಮಗೆ ಲೀಗಲ್ ಏಡ್ ಇಂದ ಬಂದದ್ದ ಅಲ್ಲ ನಿಮ್ದ ಕೇಸ್?
ಇಲ್ಲ ಸರ್, ಲೀಗಲ್
ಏಡ್ ಇದ್ದದ.
Yes. In all the prosecution of examined PW 1 to PW 17.
Why you didn't examine Chandrakant?
All amongst four eyewitness, two have been examined.
Correct,
Yes,
complaint
exactly.
ಅಲ್ಲಿ mention ಮಾಡಿರೋದು ಅವಂದು.
Yes, exactly.
That was the best.
My submission would be, fair submission would be, my lord. In some extent, somebody turns hostile, my lord. Because of that, who come forward for reducing their evidence, whatever they have seen in. To that effect, these two PW 7 and 8 have been examined.
But their statements are recorded on the same day.
Same day, my lord, 7/12 itself, that is it. The same day itself, their statements have been.
ಆಯ್ತು, ಕೂತ್ಕೊಳ್ಳಿ. ಕೂತ್ಕೊಳ್ಳಿ.
Accused is a young age person having a mother and wife here also. And he is
Mother
a
herself
poor
has
person
supported the
and he
case
is
of
a
the
poor
prosecution.
person and ಅದಕ್ಕೆ ಅವ ಏನಪ್ಪ ಅಂದ್ರೆ ಲೀಗಲ್ ಏಡ್ಗೆ ಕೇಸ್ ಇದು ಮಾಡಂತೇಳಿ ಇದು ಮಾಡಿದ್ವಿ.
ಹೌದು, ಬಟ್ ನಿಮ್ಮ ತಾಯಿನೂ ನಿಮ್ಮ ಎಗೇನ್ಸ್ಟ್ ಸಾಕ್ಷಿ ಹೇಳಿದ್ದಾರೆ,
She
ನಿಮ್ಮ
said-
ಅಣ್ಣನೂ ನಿಮ್ಮ ಎಗೇನ್ಸ್ಟ್ ಹೇಳಿದ್ದಾರೆ, ನಿಮ್ಮ ತಮ್ಮನೂ ನಿಮ್ಮ ಎಗೇನ್ಸ್ಟ್ ಹೇಳಿದ್ದಾರೆ, ಎಲ್ಲ ನಿಮ್ಮ ಎಗೇನ್ಸ್ಟ್ ಸಾಕ್ಷಿ ಹೇಳಿದ್ದಾರೆ.
ಆಮೇಲೆ ಅಲ್ಲಿ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಅನ್ನಲ್ಲ ಅಂತ ಹೇಳಕ್ ಆಗಲ್ಲ. ಅವ್ರು ನಿಮ್ಗೂ ಇಂಟ್ರೆಸ್ಟೆಡ್, ಅವ್ರಿಗೂ ಇಂಟ್ರೆಸ್ಟ್. ಬೇರೆ ಅಂದ್ರೆ ಬೇರೆ
Prosecution has
ಅವ್ರು
failed
ನಿಮ್ಗೂ ಇವಾಗ
to
ನಿಮ್ಗೆ
beyond the reasonable grounds, your lordship.
all contradictions we can't.
The version of the prosecution witnesses are contradicts.
Minor contradiction.
Minor
Yes.
contradiction.
ಆಮೇಲೆ really if they wanted they could have protected you. ನಿಜವಾಗ್ಲು ಇಲ್ಲ ಇವನು ಇನ್ನಸೆಂಟ್ ಅಂದ್ರೆ ತಾಯಿನೂ ತಮ್ಮ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡ್ಬೋದು.
Already he is undergone imprisoned for 9 years.
ಆಯ್ತು, ಬರ್ತಾನೆ, ಇನ್ನೊಂದು 2 ವರ್ಷ ಅಷ್ಟೇ ಬಂದು ಬಿಡ್ತಾನೆ. ಬರ್ತಾನೆ, ಆಯ್ತು ಆಯ್ತು, ಕೂತ್ಕೊಳ್ಳಿ. ನೀವು ಚೆನ್ನಾಗಿ ಮಾಡಿದ್ದೀರಿ, ಕೂತ್ಕೊಳ್ಳಿ. ಆಯ್ತು. This appeal directed against the judgment of conviction, order of sentence dated 23/4/2018, passed in SC number 135 of 2016 by the special judge and additional district and session judge at Bidar, wherein the learned session judge convicted the accused of the offence punishable under section 302, 201 of IPC and sentenced him to undergo SI for life and to pay a fine of ₹10,000 in default, SI for 6 months for the offence punishable under section 302 of IPC. Further, the accused sentenced to undergo SI for 3 years and to pay a fine of ₹5,000 in default, SI for 2 months for the offence punishable under section 201 of IPC. It's directed that the substantive sentence shall run concurrently. Also, next, the abridged facts of prosecution case are that that on 7/12/2000, the accused appellant is the son of deceased, son of
Deceased
ಏನ್ ಹೆಸರು?
Arjun.
Deceased
Arjun.
Deceased Arjun, and on 7/12/2015 at about 1:30 PM, the deceased Arjun was working in the land of CW23.
Yeah.
And at that time, the accused went there and demanded money when he refused to give money, the accused had assaulted him with kammakatti, sickle, like a sickle, on his head and on left ear, and due to which the said Arjun had sustained grievous injuries and succumbed to the injuries on the spot. Further, the accused also in an attempt to disappear the evidence by setting ablaze the dead body, the corpus of the deceased. Full shot. The mother of the deceased, PW1
Godavari.
Godavari has mother of the accused.
Mother of the accused, the wife of the deceased.
That is the wife of deceased, had lodged the complaint before the respondent police on the same day, that is on
7/12.
That is on
7/12/2015.
So 2015, before the respondent police, as per exhibit P1, P1 against the accused, full stop. The same as registered in crime number 196 of 2015, dated 7/12/2015 by 2015 by PW 17 as per exhibit P. Exhibit FIR as per exhibit P.
Complaint is the exhibit P1. FIR is.
Exhibit
P9. P9.
As per exhibit P9, for the offence punishable under section 302, 201 of IPC. Full stop. Subsequently, the PW 17, conducted the investigation. PW 17 Allah.
PW 17 conducted.
PW 17, sorry.
Partly.
PW 17 conducted the investigation by drawing the spot mahazar, as per exhibit P2, so also drawing the inquest panchanama on the corpus of the deceased as per exhibit P5, full stop. So of those P5. Later on, when the accused arrested?
11/12.
On
11/12/2015.
11/12 later,
Yes.
on 11/12/2015, the PW 17 arrested the accused and based on his voluntary statement, the MO1 and the MO1, that is the weapon used for the commission of crime, and the clothes of the accused used at the time, worn at the time of commission of the crime, were seized under exhibit P4 Panchanama, full stop. Subsequently, after obtaining necessary documents from the concerned authority, and also recording the statement of the witnesses, PW 17 laid the charge sheet against the accused.
Further investigation has been handed over to exhibit PW 15.
PW 15 laid the charge sheet against the accused for the same, for the offense 302 and 201 of IPC, 201 of IPC before the committal court. Full stop. After committal of the case before the session court, the learned session judge has framed the charges against the accused for the aforementioned offences and read over the same to him. However, he claimed, he denied the charges and claimed to be tried. Full stop. In order to prove the charges leveled against the accused, before the trial court, the prosecution in total examined 17 witnesses, SPW 1 to 17, and got marked 16 got marked 16 documents as a exhibit P1 to P16. So also got identified 11 material objects, MO1 to 11, 1 to 11. Next, post assessment of the oral and documentary evidence placed before the session court, the learned session judge has convicted the accused for the charges leveled against him and sentenced him as stated sutra. Challenge, the said judgment is challenged under this appeal. Full stop. We have heard Shri Kumar for the appellant, so also Shri Dastagir Saab B. Nadaf, amicus curiae for the appellant. So also the Shri Patil for the Patil additional SPP for the respondent state. Full stop. The Shri Dastagir learned counsel submitted that the judgment under this appeal suffers from perversity and illegality, and the learned session judge, erred while learned session judge grossly erred while appreciating the evidence on record. Full stop. According to him, though the prosecution relied the evidence of eyewitnesses, the evidence of eyewitness PW 4 and
7.
PW
7 and 8.
PW 7 and PW 8, PW 7 and 8, there are serious infirmities in their evidence in respect of the timings of the alleged incident. Full stop. He by elaborating his contention, he submit that, submit that on perusal of exhibit P1, the complaint, it is stated that the deceased left the alleged incident caused at about 1:30 to 2 p.m.
Good.
However, in the PW 4 of 7 and 8 eyewitness were stated that the incident was caused at about 4 p.m.
PW 7 only said between 3 to 4 p.m.
Between 3 to PW 7 states that PW 7 and 8 and the better. PW 7
3 to 4.
Stated that the incident caused at about 3 to 4 p.m. 3 to 4 p.m. Full stop. 3 to 4 p.m. In such circumstance, there is a doubt occurs in respect of the version of the eyewitness to the incident. Further, according to him, the prosecution also failed to examine one Chandrakant, that is eyewitness of CW 16, who cited as a charge sheet witness number 16, who informed the incident to inform the alleged incident to PW1, and the said aspect was forthcoming. The said aspect is forthcoming in exhibit P1. Also, in spite of that, the prosecution failed to examine the said witness which totally fatal to the prosecution case. Full stop. He also contends that the evidence of PW1, PW4, PW1, PW4 are PW1, PW1, PW4 and PW1 and 4, alwa? PW1 and 4. The ಹಿಂಗಾಗಿ further submit that much evidentiary value cannot be attached to the evidence of PW1 and 4 for the reason that they are the partition witness to the incident. Full stop. According with these submission, he prays to allow the appeal by setting aside the impugned judgment. For contra, Shri Patil SPP, additional SPP would submit that the judgment under this appeal does not call for any interference for the reason that interference since the learned session judge, after meticulously examining the evidence on record, passed a well-reasoned judgment. Full stop. He would submit that the evidence submit that PW1, who is none other than the mother of accused and wife of deceased, lodged the complaint, exhibit P1 soon after the incident, full stop. Further, her evidence clearly corroborates to the contents of exhibit P1. Moreover, PW4, who is none other than the brother of the accused, also deposed that on the fateful day, the accused, the deceased and the accused went together to the one, ಅವರ ಹೆಸರೇನು ರವಿ ಪಾಂಟಾಲನ ಏನು
ಚಂದ್ರಕಾಂತ್ ಲವಟೆ ಸರ್.
ಚಂದ್ರಕಾಂತ್ ಲವಟೆ. One Chandrakant Lavate, and thereafter the
Ravichandra Lavate.
Chandrakant satisfied.
Ravichandra Lavate.
Chandrakant CW16.
Thereafter, the deceased did not return to the house. In such circumstance, their evidence has to be treated as in such circumstance, the prosecution has proved the last scene theory that the accused and deceased went together on the date of incident. Full stop. Further, the prosecution also examined PW 7 and 8.
Yes.
Eyewitness to the incident, both these witnesses have categorically stated that they stated that the accused assaulted the accused, quarreled with his father in the field and thereafter assaulted him with the MO1 on his
Right mandible
region
and occipital region of the head.
Occipital region. Full
Region
stop.
of the head and
Occipital region.
right
full stop.
mandibular.
Region. Full stop. As such, he succumbed on the spot. Full stop. Succumbed on full stop. The prosecution also proved the recovery of MO1 by the evidence of PW4. In such circumstance, there is no reason to interfere in the impugned judgment.
Yes.
Accordingly, he prays to dismiss the appeal. Full stop. Next, having heard the learned counsel for the appellants, who also the learned SPP, the point that would arise for our consideration, number one, whether the judgment illegal forward. Number two, same, justified in convicting the accused, full stop. In order to prove the full stop, before the though the prosecution in total examined 17 witnesses, 17 witnesses to prove the before the trial court to prove the guilt of the accused, comma, we are of the view that it is not required to examine all the required to not required to state the evidence of all the witnesses, and suffice to discuss the evidence of material witness to material witness before this court, full stop. This court, full stop. In order to prove the homicidal death of the deceased, comma, the prosecution the homicidal death of deceased, deceased Arjun, comma, the prosecution prosecution predominantly relied the evidence of PW14 doctor who conducted the autopsy on the corpus of the deceased and issued the post-mortem report as per Exhibit P10, full stop, on P10, and also the final opinion as per Exhibit P12, full stop. On careful perusal of Exhibit P10, comma, the doctor examined the following three injuries. Following three injuries in other more injuries, page 28, 3 injuries, full stop. Injury. Further opined that the cause of death is due to hemorrhage and shock due to multiple injuries. Full stop. The doctor, full stop. PW14 also gave his final opinion as to cause of death as death due to hemorrhage and shock due to multiple injuries. Full stop. Multiple injuries. Apart from that, he has stated that all the injuries sustained by the deceased are anti-mortem in nature. Full stop. Apart from the same, comma, the prosecution also relied Exhibit P5, the inquest Panchanama conducted on the corpus of the deceased by PW15 as per Exhibit P12. Full stop. P12. On perusal of Exhibit P5, comma, there are the PW15 and the punch witness PW6 noticed 3 injuries on the dead body, full stop. Dead body. Even otherwise, the defense has not seriously disputed the homicidal death of the deceased. In such circumstance, we are of the view that the prosecution has proved the homicidal death of the deceased beyond all reasonable doubt. Full stop. To connect the accused for the homicidal death of the deceased, the prosecution has relied the evidence of mother of the accused, who is mother of the accused, PW1, PW4, the brother of the accused, so also the evidence of PW7 and 8 were the eyewitness to the incident. On careful perusal of the evidence of PW1, who is none other than the wife of deceased and mother of accused, she has stated that the accused, the deceased and accused were engaged in the work of cremation of dead bodies in their village, and the accused used to quarrel with the deceased deceased by demanding money out of the said income, by demanding share of money out of the said income, full
For
stop.
its bad wishes.
For its bad vices, full stop. The bad vice. On that background, on the date of incident, on that background, on 7/12/2015, the accused and deceased went to perform the cremation of one late Ravichandra Lavate of their village, and at about 11 a.m. and thereafter, her husband, the deceased, did not return, and at about 2 p.m., one Chandrakanta CW16 informed her that her husband was lying, the dead body of her husband was lying near the in the field, full stop. Thereafter, they went to the field. Thereafter, they visited the said hospital, said place, and came to know that the accused who is the perpetrator of the crime, full stop. The said version of PW1 clearly corroborates to the contents of her complaint Exhibit P1, full stop. Moreover, the PW4, who is none other than the brother of PW4, also reiterated the contents, reiterated the evidence of PW1, yes, PW1, full stop. PW1. PW1. It is pertinent to mention at this juncture, the PW1 and PW4 being the mother and brother of accused respectively, had no such intention to from their evidence, no such intention could be gathered that they were nourishing any ill will against the deceased to falsely implicate him in the crime, in the incident, full stop, in the incident. That too, the deceased none other than the deceased being none other than the father of accused. Yes, accused, full stop. They further on perusal of the evidence of PW 7 and 8, who are the eyewitness to the incident, they both stated that on the date of incident, they also participated in the cremation of Ravichandra Lavate, and thereafter, while returning from the after cremation, while returning, they saw they witnessed the accused was quarreling with his father, and he assaulted him with MO1 as MO1 and caused his death, full stop. Caused his death. They caused his death, full stop. Though the defense has cross-examined these witnesses at length, nothing worthwhile has elicited to discard their testimony, full stop. This testimony. The learned counsel for the appellant contended that it is the vehement contention of the learned counsel for the appellant that there is a difference in the time, in the time of the incident, as stated by PW7. It is the settled position of law that the minor contradiction of the in the evidence of material witness does not go to the root of the prosecution case, full stop. The prosecution case, full stop. The Honorable Apex Court in the case of in the Mallikarjuna, in the case of Mallikarjuna the Nakoli, so and so, para, so and so, held as under Adana full stop. The full stop. It is further full stop. It is also the contention of the learned counsel that counsel for the appellant that the witness that the PW one and four being the relative of deceased. PW one and four are wife and son of deceased, their evidence cannot be considered since they comes under the category of partisan witness. However, the Honorable Apex Court in the case of Ravana Sahib versus Adanakoli, Rava Sahib versus so and so Nakoli, they held as under extract Malkoli and full show. On next, applying the guidelines of the Honorable Apex Court in the findings of the Honorable Apex Court, the above judgments, we are of the view that the minor contradictions in the evidence of the above material witness does not take away their testimony, and accordingly their evidence cannot be discarded for the said reason. Full show. The said reason. The further on perusal of the evidence of PW, perusal of the evidence of PW 5 alwa, PW 5, who is the witness for the Mahazar, witness for the recovery Mahazar, recovery Mahazar, that is the weapon which said to have used for the commission of the crime, the M1 under exhibit P4 recovery Mahazar, this witness also categorically stated that the accused who led the police and him to the place at a place called to the place where he hidden the
Bidar Fort.
Bidar Fort, near Bidar Fort.
Kila andre forts.
Neither Bidar Fort. Beer Fort where he hidden the MO1.
Under one big rock. Under big rock, it was kept. From there, it was recovered.
Rock, full shot. The rock. The said full shot. The exhibit P4 drawn by PW 15. PW 15.
Yes.
PW 15, the investigation officer. Further investigation officer. Further the MO1, so also the clothes worn by the accused at the time of commission of the crime and accused and the burnt clothes of the deceased are also sent for FSL examination, and the scientific officer has given the opinion.
Exhibit P12.
As per exhibit P12, which exhibit P12, which depicts that
Page number 31.
is in respect of toxic metal item
Yes.
not found on.
So what their contention is, he used to drink alcohol.
That is their contention.
For
FSL thing with full show. FSL and the thing with full show. They full show. In such circumstance, the prosecution also proved the recovery of MO1 at the instance of accused. Full show. The other contention, the full show. The another contention raised by the learned counsel for the appellate that the accused himself committed suicide. That is the reason.
By falling.
Why they were sent for FSL?
Because, my lord, their defense is the deceased was a drunkard. To that effect, on that day, he had alcohol heavily and he fell down from there.
So
What the
because of
report
that,
says,
all the, there is no, sir. Residues of volatile poisons, pesticides, drugs, alkaloids
Nowhere
and toxic
concerned,
metalloids
nowhere
were not
concerned.
detected.
nowhere
Nowhere
concerned.
concerned. But because of that cross-examination, these,
FSL procedural Allah koli, the prosecution has placed the FSL certificate. What is the page number 38 ಅಲ್ಲಿ ಇರುವುದು ಯಾವುದು?
page number 31 is a.
38 ಅಲ್ಲಿ. In respect of the
Yes,
weapon.
yes, blood stain ಇದೆ.
Exhibit ಎಷ್ಟು ಅದು?
Exhibit P11s.
As per exhibit P11 ಅಂತ. As per exhibit P11 and the same depicts that the blood stain was detached in item number 1. That is the item number 5. That is the weapon. That is the
Sorry, sir.
weapon.
Exhibit P16. 16. That 11 is
Exhibit P16.
16.
Item number 5, that is the MO1. MO1 and the same use of human blood of A group.
A
group.
A group.
Full stop. A group. In such circumstance, the prosecution approved the recovery ಅಂತ ಈಗ ಹಾಕುದು. ಬೇಡ another content. Recovery of the accused at the instance of the accused and also that the MO1 was
Stained.
used for the commission of the
Offense.
crime, was the commission of the offense, full stop. The commission of the offense. For the offense, hence, full stop. Minor contradiction ಅಂತ ಹೇಳಿದೆ ಅಲ್ವಾ? Full stop. Full stop. In hence, overall perusal of the entire evidence on record, comma, evidence on record, on appreciating the evidence of, on reappreciating the evidence of the material witness PW1, PW4, comma, PW7, 8, say 8, coupled with the evidence of PW15, the investigation officer, comma, we are of the considered
Even Dr. corroborates.
evidence of
PW14.
PW15, 15, comma, PW15, comma, we are of the view that the oral testimony of these material witnesses clearly corroborates to the medical evidence deposed by the doctor PW14. PW14. In such circumstance, there is no reason to, in such circumstance, the prosecution proved that the accused is the perpetrator of the crime, full stop. Accordingly, the learned session judge has rightly appreciated the evidence on record and passed the impugned judgment. The same does not call for any interference in that view of the matter, comma, we answer the point raised above in the negative. First one is perverse illegality, negative, justified, affirmative. Point number 1 in negative and point number 2 in affirmative, and proceed to pass the following order. The criminal appeal is dismissed being devoid of merits. The judgment of conviction and order of sentence imposed by the trial court is conformed, full stop. Next, the advocate Shri Shambhulinga,
Shambhulinga Salimat.
The Shri Learned Counsel Shri Shambhulinga Salimat, though the Learned Counsel Shambhulinga Salimat was appointed as a counsel to argue this case by the legal service authority, he expressed his inability to be present before this court today. As such, we appointed Shri Dastagir
Dastagir Saab.
Dastagir Saab as amicus curiae to assist in this case. Assist it as such, the KL, as such, the legal service legal service authority is directed to pay the remuneration of the Dastagir Saab of rupees 25,000. 20, sorry, rupees 25,000. Yes.
Achha.
Syed Maktan.
Fourth or next date adjournment, my lord, the 4th or February 10th.
Oh, that is too late. 10 ವರ್ಷ ಇದೆಯಲ್ಲ ಬೇಗ ಮಾಡಿ.
Before that, we have to complete 10,
Complete.
9 years ತನಕ ನಾವು ಮುಗಿಸ್ಬೇಕು.
Please, 3rd of February.
ಏನ್ ಡಿಫಿಕಲ್ಟಿ ಏನಿದೆ? ವಾಟ್ ಇಸ್ ಯರ್ ಡಿಫಿಕಲ್ಟಿ?
28.
ಒಂದ್ ದಿನದಲ್ಲಿ ಓದ್ಬೋದು. ವಾಟ್ ಇಸ್ ಯರ್ ಡಿಫಿಕಲ್ಟಿ ಬಿಫೋರ್ 4th? Why can't you have it tomorrow, day after tomorrow, Monday?
I have some trial, my lord, very extremely sorry to say that I have some murder trial before the sessions court, my lord. That's why I'm asking to adjournment.
ಹೌದು, ಮರ್ಡರ್ ಟ್ರಯಲ್ ನಿಮ್ಗೆ ಕನ್ವಿಕ್ಷನ್ ಅಪೀಲ್ಗಿಂತ ನೀವು ಇಲ್ಲಿ ಅಪೀಲ್ ಬಿಟ್ಟು ಅದನ್ನು ಮಾಡಿದ್ರೆ ಹೇಗೆ ಟ್ರಯಲ್?
This case also I have conducted. In this matter also I have conducted the trial before the sessions court, my lord.
Good,
Yes,
good.
my
So it's going to be easier for you. ಅಲ್ವಾ?
ಮಧ್ಯಾಹ್ನ ಹತ್ರ ಬನ್ನಿ, ಆಫ್ಟರ್ನೂನ್ ಬನ್ನಿ.
Please.
ಮಾರ್ನಿಂಗ್ ವಿಟ್ನೆಸ್ ಮಾರ್ನಿಂಗ್ ಇರುದಲ್ವಾ?
ಮಧ್ಯಾಹ್ನ.
ಯಾವ ಬರ್ತೀರಿ? 4th ತನಕ ಆಗಲ್ಲ, ಮಂಡೇ ಮ್ಯಾಕ್ಸಿಮಮ್ ಮಂಡೇ ತನಕ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿ ಅಷ್ಟೇ. ನೀವು ಮಂಡೇ ತನಕ ಕೊಡ್ತೀವಿ ಟೈಮ್.
They are Tuesdays because Monday 2 matters have been posted. One is Sanjay Patil's and second one is Lagle's.
ಸಂಜಯ್
Sunday.
ಪಾಟೀಲ್ ಅವರು.
That is also on bank declaration. Tuesday would be the best. It could be posted on Tuesday. On 28th.
ಅದು ನಾಳೆ ರೆಡಿ ಆಗ್ಬೇಕು. SPP.
Yes, minutes.
Will take up that to state appeals.
Yes.
64. 64 ಓದ್ಕೊಂಡು ಬನ್ನಿ, ನಾಳೆ ಮುಗಿಸ್ಬಿಡೋಣ.
64.
64.
60?
64. Serial number 64.
Yes. Yes.
64 and 64.1. ಎರಡನ್ನ ನಾಳೆ ಮುಗಿಸ್ಬಿಡೋಣ.
Yes. Yes.
ರೆಡಿ ಆಗಿ ಬನ್ನಿ.
Yes.
So we'll take up your matter on Monday ಆಗ್ಬೋದಾ? ಇದು Tuesday ಆಗ್ಬೋದಾ?
Maybe. Murder. 28.
That is Tuesday.
Tuesday, 28. 28 ನೀವು ಬರ್ಬೇಕು ಮಾತ್ರ. 30 ಇಲ್ಲಿ ಇರ್ಬೇಕು.
ಖಂಡಿತ.
We'll take up.
Please.
ರೆಡಿ ಮಾಡಿಸಿತ್ತು. ಡಿಸ್ಪೋಸ್ ಆದ್ಮೇಲೆ ಲಿಸ್ಟಿಗೆ ಸೇರಿಸ್ತಾ ಇದ್ವಿ.
63. ಇನ್ನೊಂದು ಹಾಕಿದ್ರೆ ನಡೆಯುತ್ತೆ ಸರ್.
ಯಾವುದು?
Monday. Because that is only on the point that my lords the bank declaration. That is the only point.
Patil,
Yes. 316 of 2000.
Motion. Thoughts have granted the interim relief. Pray for London.
ಫೋಟೋ ತಗೊಂಡ್ಬಿಟ್ಟು ಸಾಕು. ಫೋಟೋ ತಗೊಂಡ್ಬಿಡಿ ಅದು. ಆಯ್ತು ಕೊಡಿ ಕೊಡಿ.
Photo ತಗೊಳ್ಳಿ ಅಂತ.
Yes,
Serial number 43, my lord, is adjourned in the morning. May kindly be referred to mediation center.
40.
43, my lord. MVC case idari and the insurance company want to negotiate the amount. May kindly be referred to mediation center.
Better refer to mediation.
Please, man. 40.